Ladies and gentlemen, kindly rise as we shall sing the national anthem, the Negaraku, followed by the Sabah state anthem. Ladies and gentlemen, please be seated. To begin with our colloquium, we would like to call upon Mr. Wan Faiz bin Wan Jafar to recite a dua for our colloquium today.
Cubaan, 1, 2, 3. Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alamin. Wassalatu wassalam ala Sayyidina Muhammad wa ala alihi wa sahbihi ajma'in. Allahumma aftah alaina hikmataka wanshur alaina min khaza'ini rahmatika ya arhamar rahimin. Rabbi zidni ilman warzuqna fahma. Rabbi syrahli sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. Ya Allah ya Rahim, sesungguhnya Engkau Maha mengetahui bahawa kami di sini ingin menimba ilmu-Mu yang sangat luas bagi mengembangkan potensi kami sebagai hamba-Mu yang Engkau redai. Justru itu, cucurlah rahmat-Mu ke atas Kolloquium Timbantara Antarabangsa 2023, kedaulatan dan kekebalan negara dalam timbantara komersial yang diadakan pada hari ini. Berkatilah ia dari mula hingga akhirnya, dan semoga majlis ini berjalan dengan lancar serta memberi 1000 kebaikan dan manfaat kepada semua hadirin. Kurniakanlah kepada kami apa kiranya ilmu-Mu, sinarilah hati-hati kami dengan cahaya hidayah-Mu. Ya Aziz, Ya Jabbar, Ya Mutakabbir, kurniakanlah keamanan kepada dan keselamatan kepada negara kami, selamat daripada anasir luar yang khususnya kepada negeri Sabah dan Malaysia secara amnya. Allahumma Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzaban nar. Wassallallahu ala sayyidina Muhammad wa ala alihi wa sahbihi wa sallam walhamdulillahi rabbil alamin.
Thank you. Yang Amat Berhormat Datuk Seri Panglima Haji Hajiji bin Haji Nur, Chief Minister of Sabah. Yang Berhormat Datuk Seri Azlina binti Othman Syed, Minister in the Prime Minister's Department of Law and Institutional Reform, cum Chair of the Special Secretariat, who's attending virtually. Yang Berhormat Senator Tan Sri Datuk Seri Dr. Wan Junaidi Tuanku Jaafar, President of the Senate. Yang Berhormat Datuk Seri Panglima Haji Kadzim Muhammad Yahya, Speaker of the Sabah State Legislative Assembly. Yang Berhormat Datuk Seri Panglima SR Haji Safar bin Untung JP, Secretary of the Sabah State Government. Yang Berhormat Senator Tan Sri Datuk Seri Panglima Anifa bin Aman, Member of the Special Secretariat. Yang Berbahagia Datuk Seri Khairul Zaimi bin Daud, Director General of the Legal Affairs Division of the Prime Minister's Department. Yang Berhormat Deputy Speakers of the Sabah State Legislative Assembly and Assistance Minister. Yang Berhormat Members of Parliament and Yang Berhormat Members of Sabah State Legislative Assembly. Yang Berbahagia Tan Sri Datuk Seri Panglima.
Recording in progress.
Datuk, heads of government agencies, senior government officials, members of the media, ladies and gentlemen. A very good morning and a warm welcome to the Sabah International Convention Center, what is more commonly known as the SICC. Thank you to all who are present here, this fantastic state-of-the-art facility. To all those worldwide tuning in on the live feeds on both the Legal Affairs Division of the Prime Minister's Department, BHEUU, and the AIAC's Facebook pages. The International Arbitration Colloquium 2023, themed State Sovereignty and Immunity in Commercial Arbitration, once again draws upon the strong relationship between the Legal Affairs Division of the Prime Minister's Department, BHEUU and JPM, the Asian International Arbitration Center, the AIAC, and with this edition of the Sabah Colloquium, the Institute for Development Studies, Sabah, IDS, and the Sabah Law Society, SLS. Following the success of the colloquium held at the AIAC's very own Bangunan Sulaiman in Kuala Lumpur, earlier in the year, this edition of the colloquium stands as our ongoing commitment to unweave the multifaceted impacts of this highly controversial Sulu case on the global arbitration landscape. As many of you are aware, the government of Malaysia is presently engaging in an international legal battle against some self-proclaimed descendants of the defunct Sulu Sultanate. With our national security and sovereignty at stake, much global attention has been drawn to this ongoing international dispute, especially in light of the purported final award delivered by Dr. Gonzalo Stampa on the 28th of February 2022. On the 6th of June 2023, Malaysia successfully anchored a landmark victory via the Paris Court of Appeals ruling in the ongoing legal battle against the claimants. The partial award on jurisdiction rendered in Madrid on the 25th of May 2020, which was heavily relied upon by Dr. Stampa and the claimants, has now been decisively annulled both in Spain and in France. We are pleased that the Hague Court of Appeal has, on the 27th of June 2023, determinatively upheld Malaysia's challenge against the recognition and enforcement of the purported final award. These successive victories strengthen Malaysia's resolve in this legal pursuit. In light of the above, today's International Arbitration Colloquium, Sabah edition, promises a lineup of interesting academic discourses on different facets of the Malaysian Sulu legal duels. To begin this colloquium, we would like to invite Yang Berbahagia Datuk Seri Khairul Zaimi bin Daud, Director General of the Legal Affairs Division, the Prime Minister's Department, to deliver his welcoming remarks.
Thank you, MC. Yang Amat Berhormat Datuk Seri Panglima Haji Hajiji bin Nur, Ketua Menteri Sabah. Yang Berhormat Datuk Seri Azalina binti Osman Said, Menteri di Jabatan Perdana Menteri, Undang-Undang dan Reformasi Institusi. Yang Berhormat mengikuti program kita secara online daripada Tokyo, Jepun. Yang berbahagia Senator Tan Sri Datuk Seri Dr. Wan Junaidi Tuanku Jaafar, Yang di-Pertua Dewan Negara. Yang berbahagia Datuk Haji Kazim bin Yahya, Yang di-Pertua Dewan Negeri Sabah. Yang berhormat Timbalan-Timbalan Menteri Kerajaan Persekutuan. Yang berhormat Datuk Seri Panglima Haji Safar Untung, Setiausaha Kerajaan Negeri Sabah. Yang bahagia Senator Tan Sri Anifah Aman, Ahli Sekretariat. Yang berhormat Ahli-Ahli Parlimen dan Ahli-Ahli Dewan Undangan Negeri Sabah. Div kehormat Tan Sri, Datuk Sri, tuan-tuan dan puan-puan sekalian, Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera, salam Malaysia Madani, salam Sabah Maju Jaya. Mewakili pihak urustia, saya terlebih dahulu ingin mengucapkan jutaan terima kasih kepada Yang Amat Berhormat Datuk Seri Panglima Haji Hajiji bin Noor, Ketua Menteri Sabah, dan semua div kehormat, khususnya pemimpin-pemimpin Kerajaan Negeri Sabah yang sudi hadir dan memberikan sokongan ke atas penganjuran Kolloquium Timbang Tara Antarabangsa 2023 ini yang bertajuk Kedaulatan dan Kekebalan Negara dalam Timbang Tara Komersial. Kolloquium ini dianjurkan secara bersama oleh Bahagian Hal Ehwal Undang-Undang Jabatan Perdana Menteri, Institut Kajian Pembangunan Sabah IDS dan Pusat Timbang Tara Antarabangsa AIAC. Yang Amat Berhormat Datuk Seri dan semua div kehormat, objektif utama kolloquium ini adalah untuk membincangkan pelbagai isu berkaitan tuntutan pihak yang mendakwa mereka sebagai waris Kesultanan Sulu dari perspektif sejarah dan perundangan, khususnya isu-isu berkaitan Perjanjian 1878 antara Sultan Sulu dan North Borneo Company, atau lebih dikenali sebagai McCaskey Judgment 1939 and 1908, implikasi New York Convention 1958 dan kekebalan kedaulatan atau sovereignty immunity serta prosedur timbang tara berkenaan kes ini, termasuklah penyalahgunaan proses timbang tara yang sedia ada oleh pihak-pihak yang menuntut. Sesungguhnya kehadiran serta sokongan pemimpin-pemimpin kerajaan negeri sudah tentu akan meningkatkan moral dan semangat kami di Bahagian Hal Ehwal Undang-Undang Jabatan Perdana Menteri dan juga bagi pihak Jabatan Peguam Negara serta semua kementerian dan agensi yang bertindak selaku agensi peneraju utama di dalam menguruskan tuntutan pihak-pihak yang berdakwa sebagai waris Kesultanan Sultan Sulu ini. Alhamdulillah, sebagai makluman Yang Amat Berhormat Datuk Seri, jumlah peserta yang hadir pada hari ini adalah seramai 708 orang dan ia adalah sesuatu yang di luar jangkauan pihak kami urustia. Sebagai makluman semua hadirin dan div kehormat, kolloquium kita pada hari ini akan dibahagikan kepada 3 sesi utama. Yang pertama, The Sulu Case, Discovering the Missing Puzzle. Sesi ini akan membincangkan isu-isu sejarah termasuk Kesultanan Sulu, peranan North Borneo Company dan pembentukan Malaysia. Sesi yang kedua pula bertajuk The Sulu Case, Time to Preserve Sovereign Immunity. Perbincangan akan melihat dari aspek perundangan berkaitan kekebalan sebuah negara yang berdaulat seperti Malaysia, termasuk mengkaji konsep Akta Kekebalan Negara atau State Immunity Act yang sesuai untuk Malaysia. Manakala sesi yang terakhir, itu yang ketiga, akan melihat the effect on the New York Convention and the Global Arbitral System yang akan mengupas isu tuntutan pihak-pihak berkaitan dan prinsip-prinsip di bawah New York Convention 1958. Sementara barisan panel pula adalah terdiri daripada pakar-pakar perundangan, khususnya berkaitan perundangan antarabangsa dan arbitrasi. Yang Amat Berhormat Datuk Seri dan semua hadirin sekalian, Sesi kolokium ini dijangka akan berakhir pada pukul 5 petang dengan ucapan penutup oleh Yang Berbahagia Senator Tan Sri Anifah Aman, bekas Menteri Luar Negeri merangkap Ahli Sekretariat Khas Sulu. Datuk Seri, tuan-tuan dan puan-puan sekalian, sebelum mengundurkan diri sekali lagi bagi pihak urus setia, kami merakamkan setinggi-tinggi penghargaan dan terima kasih di atas kehadiran semua yang memberikan sokongan padu terhadap penganjuran kolokium ini. Sekian, wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. Terima kasih.
Thank you for your welcoming remarks, Yang Berbahagia Datuk Sri. Next, ladies and gentlemen, we are honored to have Yang Berhormat Datuk Sri Azalina Othman Said, Minister in the Prime Minister's Department of Law and Institutional Reform, who is now attending the ASEAN-Japan Special Meeting of Justice Ministers and ASEAN G7 Justice Ministers Interface in Japan, joining us virtually to deliver the opening remarks.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Mohon maaf Yang Amat Berhormat Ketua Menteri, sebab saya tidak ada di sana. Ohayo gozaimasu. Yang Berhormat Datuk Seri Panglima Haji Ji, Chief Minister of Sabah, Yang Berhormat Senator Tan Sri Datuk Sri Dr. Wan Junaidi, President of the House of Senate, the Upper House Malaysian Parliament, Yang Berhormat Datuk Armizan, Minister of the Prime Minister's Department, Sabah Sarawak Affairs and Special Duties, Yang Berhormat Datuk Seri Panglima Haji Kazim, Speaker of the State Legislative Assembly, Yang Berhormat Datuk Seri Panglima SR Haji Safar, Secretary of the State of Sabah, Yang Berhormat Tuan Khairul Firdaus, Deputy Minister of Tourism, Arts and Culture, Yang Berhormat Tuan Mustafa, Deputy Minister of Human Resource, Yang Berhormat Senator Tan Sri Datuk Sri Panglima Anifah Aman, Member of the Special Secretariat, Yang Berhormat Datuk Sri Khairul, Director General of the Legal Affairs, Yang Berhormat Deputy Speakers of Sabah State Legislative Assembly, Assistant Ministers of the Sabah State, my fellow colleagues and members of Parliament, members of the State Legislative Assembly of Sabah, all the invited guests, heads of government agencies, senior government servants, especially my esteemed colleagues from abroad, the speakers and moderators, and also within Malaysia, distinguished guests, members of the media, ladies and gentlemen. Thank you so much all to be attending this colloquium, and congratulations again to the State of Sabah and Bahagian Undang-Undang for having the attendance of 700 over, according to the Director General, although I'm told the hall is estimating 600. So congratulations to all those that is attending this fantastic and very important colloquium. As you all know, this is the second colloquium that we are doing under the Bahagian Undang-Undang and AIAC with the titling of the State Sovereignty and Immunity in Commercial Arbitration of Sabah. The MC has mentioned, and also the Director General, that I am in Tokyo attending the special meeting of Justice Ministers in ASEAN G7 interface in Japan. Unfortunately, because I am the co-chair, I'm unable to just fly to Sabah then to Tokyo, as the multilateral and bilateral meeting is starting today. Nevertheless, the third part of this colloquium, as all of you in attendance would be would be the last colloquium in London, in United Kingdom, and I hope in this colloquium the new Senator President, my abang Tan Sri Wan Junaidi, can assist Bahagian Undang-Undang with this colloquium in London and would give a speech on behalf of the Government of Malaysia. So that's all in preparation. So thank you so much to all of you for attending. But first of all, I would like to emphasize the biggest thank you and gratitude from Bahagian Undang-Undang to Yang Amat Berhormat, the Prime Minister of Malaysia, Datuk Sri Anwar Ibrahim, for his continued support, for his trust to the Secretariat in ensuring that Malaysia's interests, sovereignty are protected at all times. I also would like to take this opportunity to the Chief Minister of Sabah, Yang Amat Berhormat, Datuk Sri Panglima Haji Ji, for assisting us today to deliver the keynote address and officiating the colloquium on behalf of the Bahagian Undang-Undang, the Prime Minister's Department. But before I start with my speech, thank you again to all the members of the Secretariat, especially to the Bahagian Undang-Undang Legal Affairs Division, the Attorney General's Chambers. We have got the AIAC, the Asia International Arbitration Centre, and of course, the Institute of Development Studies Sabah and the Sabah Law Society for all the effort and commitment in making this colloquium another reality. As you know, Yang Mat Berhormat, Chief Minister, and also Yang Berhormat Tan Sri, Speaker of the Upper House, this colloquium that we are doing today is live on Facebook, and our speakers and also visitors from abroad are watching us. I think a lot of people are now quite interested with this second phase of this continuous legal standpoint between Malaysia and the so-called claimant. As you know, continuously I have been calling them the Sulu fraud, not the Sulu award, because I don't believe that the award is justified even from day one. Anyway, let's go to the legal part, as I'm invited to give the opening remark to start off the colloquium. One of the things that we have to bear in mind is that this whole arbitration process since day one is technically null and void. Given the absence of any intention between the contracting parties to arbitrate dispute 1878, it is very evident, as you know, the 1878 agreement denotes a dispute resolution provision, signaling that the parties mutual consent to appoint an independent third party to resolve any dispute and differences, which means to say there must be consent by all parties. As we all know, arbitration, akin to other alternate dispute resolution mechanism, requires unequivocal, express and mutual consent of both contracting parties to adopt the same. Having said that, nowhere in the 1878 agreement states that the parties' intention to select arbitration as a preferred dispute resolution mechanism. On that basis, in the absence of the prerequisite arbitration agreement, the commencement of the purported arbitration proceeding by the claimants is manifestly without basis. Distinguished guests, ladies and gentlemen, I must emphasize that the government of Malaysia has never in any circumstances renounced its sovereign immunity in these purported arbitration proceedings. No state should be subject to the jurisdiction of any court of any other state. This is the principle recognized under the customary international law. The government of Malaysia has been consistently raising timely objections against the claimants' blatant attempt in forum shopping, the jurisdiction of the arbitrator, the continuation of the arbitral proceedings, despite the Spanish court orders and the unprecedented shift in the seat of arbitration, as well as the delivery of the purported final award. This particular frivolous case, financed by an international litigation funder called Terium, has raised several alarming concerns, especially in respect to the necessity to uphold ethical conduct, integrity, professionalism, and good practices by international arbitrators all around the world, which is the cornerstone of any legitimate commercial arbitration. This is fundamental to preserve the confidence of any parties who choose arbitration as a platform to settle their dispute, failing which could cause the whole arbitration system to be undermined. Therefore, ladies and gentlemen, distinguished guests, and also international speakers and local speakers, on June 6, 2023, the government of Malaysia achieved a landmark victory in the ongoing legal battle against the claimant, wherein the Paris Court of Appeal found that the arbitrator wrongly upheld his jurisdiction. This decision has added tremendous value and confidence to Malaysia's defense in this matter. Most importantly, the recent landmark decision by the Hague Court of Appeal rendered on the 27th of June 2023 is the first decision that rejects the claimant's attempt to recognize and enforce the purported final award. This particular decision, ladies and gentlemen, was unequivocally made based on three following grounds. The first one, no final award could have been lawfully rendered due to the annulment of Dr. Stampa's appointment as arbitrator by the Spanish court that appointed him. 2, no valid arbitration agreement exists. 3, the exceptional stay of enforcement of the purported final award in Paris renders the sham award incapable of recognition and enforcement in the Netherlands. The Hague Court of Appeal decision is indeed consistent with the discussion and findings of the expert that were conveyed during the first series of this similar colloquium held in Kuala Lumpur on 9 May 2023. It is hoped that the success obtained through the Hague Court of Appeal decision will contribute to subsequent success in ongoing proceedings commenced by the government in challenging the recognition and enforcement of the purported final award in other jurisdictions, including one in Luxembourg somewhere in September. Distinguished guests, ladies and gentlemen, international speakers, national speakers, Dr. Stampa is currently indeed indicted in Spain on the charges of contempt of court and unqualified professional practice following his blatant disregard of the Madrid court order, which annulled his appointment as the arbitrator of these proceedings. The Criminal Investigation Court has decided to proceed with the trial stage of this rogue arbitrator, Dr. Stampa, which will be held in the Madrid Criminal Court somewhere in 2024. Keeping that in mind, the successful victories achieved by Malaysia, the government remains devoted to our legal pursuit in ensuring that the purported final award by claimants or representative of claimants. We have to bear in mind the other challenge that we are facing is this so-called third-party funder, litigation funder Sculptorium, that is known to assist the claimant in commencing this sham arbitration and ultimately the enforcement of illegal award. Of course, the government is ready. The government is ready to fight anyone, anywhere. But at the same time, we have also to bear in mind that the government, in its process of investigating this particular claim, we are also in the process of probing the possibility of any Malaysians providing aid to the claimant to strategize their claims against Malaysia. In this regard, I would like to remind everyone again and again, has also been reminded by Yang Amat Berhormat, the Prime Minister, during the ministerial statement in Parliament, which he has also mentioned, that any person found to have been in close affiliation and contact with the so-called S, based on clear evidence, will be considered to have committed an offence under our penal law, including the act of treason against Malaysia. In the near future, the Madani government will also legislate a State Immunity Act, which will, with the purpose of codifying the principle of state immunity as part of Malaysian law to reflect Malaysia's effort to ensure the sovereignty of states are protected in the event similar frivolous claim is brought against those states before the courts of Malaysia. This law will reflect the general principles of international law on sovereign immunity, including effective service on foreign states, to uphold the rights and interests of parties concerned, safeguard the sovereignty of states, and to preserve and promote friendly relations with other states. With this, it is hoped that the reciprocal treatment will be accorded to Malaysia in the event Malaysia is brought to courts of a foreign state in the near future. The Madani government commits table this particular state immunity bill during the September or the October sitting in Parliament session this year. The law itself would present the work as of now. Particular Sulu fraud is compounded with multiple legal and unethical issues for abusing the established arbitration process, which jointly have adversely affected our sovereign as well as global arbitration community. Must not be done in a very unprofessional and unethical approach. Unethical arbitrators with irresponsible third parties must not be allowed to manipulate and abuse such arbitral process. With that, ladies and gentlemen, I am confident today's colloquium will be a success.
Thank you, Yang Berhormat Datuk Seri, for your words. We apologize for the technical difficulties. Ladies and gentlemen, we are pleased to invite Yang Amat Berhormat Datuk Seri Panglima Haji Hajiji bin Haji Noor, the Honourable Chief Minister of Sabah, to deliver the keynote address for this colloquium.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Salam Malaysia Madani dan salam Sabah Maju Jaya. Yang berhormat Datuk Seri Azalina binti Osman Said, Minister in the Prime Minister's Department, CAM, Chair of the Special Secretariat, whom is attending virtually. Yang berhormat Senator Tan Sri Datuk Sri Dr. Wan Junaidi Tuanku Jaafar, President of the Senate. Yang berhormat Datuk Sri Panglima Haji Kazim M. Yahya, Speaker of Sabah State Legislative Assembly. Yang berbahagia Datuk Sri Khairul Zaimi bin Daud, Director General of Legal Affairs Division, Prime Minister's Department. Yang berhormat Datuk Sri Panglima Haji Safar bin Untung, Secretary of Sabah State Government. Yang berhormat Senator Tan Sri Datuk Sri Panglima Nifa bin Aman, Member of the Special Secretariat, former Foreign Minister, distinguished guests, panelists, and learned friends from the local, national, and international legal fraternity, ladies and gentlemen. It is my pleasure to join all of you here today to address a very pertinent and important issue that concerns the sovereignty of our country. Your theme, state sovereignty and immunity in commercial arbitration, is most fitting as we deliberate and explore the principles of sovereignty and immunity within the context of international arbitration on the Sulu claims against Sabah. Ladies and gentlemen, as we know it, on the 28th February 2022, a so-called final award was issued by Dr. Gonzalo Stampa, bringing the ongoing international legal battle between the government of Malaysia and the self-proclaimed descendants of the Sulu Sultanate to the forefront. This so-called award has sparked widespread discussion and debate, requiring our attention and response. Let me very clear again that the state government of Sabah firmly rejects this award and does not recognize the legitimacy. We consider it to be baseless, lacking any legal or historical foundation. We see it as an attempt to undermine the sovereignty and territorial integrity of Malaysia, particularly with regards to the state of Sabah. The recent decision at the Paris Court of Appeal in France and at the Hague Court of Appeal, Netherlands, are a testament to our unwavering commitment to protecting the right, integrity, and sovereignty of Sabah. It affirms that the claim made by the self-proclaimed descendant of the Sulu Sultanate is without legal foundation. We have always maintained that Sabah is an integral part of Malaysia, and these court rulings further solidifies our position. Ladies and gentlemen, I have full confidence in the leadership of our Prime Minister, Datuk Sri Anwar Ibrahim, and Law Minister, Datuk Sri Azalina Osman, in taking the lead for Malaysia, as well as in our legal team, led by Federal Attorney General, who have been working tirelessly with our Sabah State Attorney General to counter the false narrative spread by those supporting the Sulu claims. I assure you of our commitment to work closely with the federal government to deal with this case. In addition to our legal authorities, we are leveraging the expertise and support of esteemed organizations such as the Legal Affairs Division of the Prime Minister Department, the ASEAN International Arbitration Center, AIAC, the Institute for Development Studies, Sabah, IDS, and the Sabah Law Society, SLS. I want to highlight the collective efforts by these various institutions, organizations, and together with independent history experts in assisting the state government in navigating this complex legal landscape. Their involvement demonstrates the collective determination to address this issue comprehensively and with utmost professionalism. Through these channels, we are pooling our resources, knowledge, and legal acumen to mount a robust defense against the baseless claims. We are engaging in thorough historical records, international treaties, extensive research, analysis, and strategic planning to strengthen our position and present a compelling case that upholds the sovereignty and immunity of Sabah. Ladies and gentlemen, the international community has been pivotal in supporting Malaysia's position on this matter. We are grateful for the solidarity expressed by our friends and allies who understand the importance of upholding the principle of sovereignty and territorial integrity. We call upon the global community to stand with us in rejecting this unfounded claim, which threaten not only Malaysia, but also the principles that underpin international order. I thank the research and legal teams that have tirelessly fought to safeguard our interests and debunk these baseless claims. Their expertise and dedication have been instrumental in securing this victory for Sabah. I appreciate the unfailing support from the people of Sabah and their conviction that Sabah is and will always be an integral part of Malaysia. Ladies and gentlemen, in conclusion, I welcome the significant victories at the courts of appeal in France and the Netherlands, which reinforce Sabah's position in the Federation of Malaysia. We shall continue our legal battle with determination and resolve. Let us rally together as Malaysians in Sabah and across the nation to reaffirm our commitment to peace and unity. By standing united, we can ensure that our future generations will inherit a nation that values its diversity, respects its history, and upholds the principles of peace and stability. Together, we will prevail so that we may continue to build a brighter future for Sabah and our people. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Young Ahmad Berhormat, for your words. We request Young Ahmad Berhormat to remain on stage for the officiation. Ladies and gentlemen, joining him on stage, we would like to invite Young Berhormat Senator Tan Sri Datuk Sri Dr. Wan Junaidi Tuanku Jaafar, President of the Senate, and Young Berbahagia Datuk Sri Khairul Zaimi bin Dawud, Director General of the Legal Affairs Division, the Prime Minister's Department, on stage to officiate the colloquium and to place the puzzle pieces on the panel on my countdown. Are we ready? 3, 2, 1, go. Distinguished guests, ladies and gentlemen, we are proud to announce that the Sabah edition of the International Arbitration Colloquium 2023 is now officially launched. Thank you. May we please request both Yang Amat Berhormat and Yang Berbahagia to remain on stage for the presentation of a small token. Thank you. You may now follow the ushers back to your seat. Ladies and gentlemen, if we could direct your attention to the screen, there shall be a short video presentation on the Sabah issue. Thank you. Ladies and gentlemen, we shall now have a short photo opportunity for the members of the media. May I ask all attendees to remain seated, and can the members of the media kindly follow the directions of the floor managers who will assist in guiding you to the stage. Ladies and gentlemen, we announce the departure of the Yang Amat Berhormat Datuk Sri Panglima Haji Hajiji bin Haji Noor, the Honourable Chief Minister of Sabah. Thank you very much for your attendance. Distinguished guests, ladies and gentlemen, welcome back. We would like to invite our guest of honour, Yang Berhormat Senator Tan Sri Datuk Sri Dr. Wan Junaidi Tuanku Jaafar, President of the Senate, on stage to deliver a special remark for this colloquium. Ladies and gentlemen, a round of applause as we welcome Yang Berhormat.
Thank you. Perhaps I didn't have to repeat the salutation for the morning anymore. Now our guest of honor is no longer here. So, Tan Sri, Datuk-Datuk, Tuan-Tuan, Puan-Puan yang saya hormati sekalian. Assalamualaikum warahmatullahi wabarakatuh. Good morning to all of you. First, allow me to thank the organizers for the event, for inviting me as a great honor. At the same time, to participate and to share a few words with all of you today. My views and opinion regarding the Sulu matter. As all of you are aware, this is really unprecedented case in history of our country. And of course, a big wake-up call for us all in Borneo regions. It deals with not only the sovereignty of our nation, but with the national security, public interest, and stability that form our foundations of a strong nation. I wish to take this opportunity to thank the Minister of Prime Minister's Department, Law and Institutional Reform, YB Datuk Sri Azalina Osman Said, for her prompt and apt decision thus far in articulating and leading a team forward. My appreciation also goes to the Attorney General, Yang Bahagian Tan Sri Idrus Harun, for his leadership in guiding this legal team. I must also give credence to Special Secretariat led by the Minister, for advising the government from time to time on pertinent issues that required in-depth analysis of legal matters. With that, I would like also to take this opportunity to congratulate the BHEUU for having a new Ketua Pengarah. I hope that you are not stepping out from immigration just to avoid Tiong, Datuk Sri Tiong. The success in France on the 6th June 2023, where the executive order was announced by the Paris Court of Appeal, and the success of 27 June 2023 in The Hague, where the Court of Appeal had refused to recognize the final award, are not only victory for the nation, but victory for all of you who have worked so hard in providing support to our international counsel in Spain, France, Luxembourg, and also in Netherlands. In 2022, when we formed the task force, which is now known as the Special Secretariat, there were so many unanswered questions in our mind, and we were not sure on the seriousness of this claim case by those who claim to be the heir of Sultan of Sulu. However, slowly the mystery unravels, and the claimant spread the wing to countries like Luxembourg and Netherlands, affecting assets belonging to our GLCs. Only then we realized the possibility of the claimant going farther than we expected. I'm indeed glad that the current government had decided to opt for the offensive, as that has brought the claimant to a standstill, at least for now. I'm also glad that we have appointed international PR, public relations agency, who have been assisting the government in putting our voice and stand forward in international fora. This was, of course, being discussed at length by the task force in the 2022. This, I must say, is a very important in gaining the confidence and buy-in from the international legal community. At this juncture, I wish to speak as a previous law minister who was instrumental in constitutional amendment pertaining to Malaysia Agreement 1963. We have heard from the Right Honourable Chief Minister this morning about the formation of Malaysia, and that we have to defend the right of the Borneo region, particularly the state of Sabah. The people of Sabah cannot and must not be held at ransom by the agreement signed in 1878, which does not even have an arbitration clause in it. Our nation cannot be treated the way we have been by a rogue arbitrator who moved the seat of arbitration from one jurisdiction to the other on his whim and fancies. We as citizens cannot allow third-party funder to take advantage, to manipulate a group of Filipino citizens for their own gain and benefit, while doing this affecting the sovereignty of our nation. I must reiterate here that there is no arbitration clause under Agreement 1878. Malaysia was not obligated to have a claim by the Sulu as arbitrated in the absence of any arbitration agreement between the government and the purported claimants, or heirs of the Sultan of Sulu. Since there was no agreement, there is no agreement on the seat of arbitration. The arbitrator appointed a claimant, proceeded initially to hear arbitration in Spain, and later moved the arbitration to France after intervention by the Spanish court. We have heard from the minister earlier on how we have succeeded in Spanish court as well as in France. The government of Malaysia never agreed that any arbitration could be conducted in France or in Spain, and yet it was being held there. It seemed the transfer arbitration process and the enforcement of arbitrators' awards could easily be moved from one place to the other. These are the risks that Malaysia is currently exposed to in regard to the award made. This third-party funded arbitration would have been held by the French Netherlands court to be invalid and cannot be enforced by the so-called the Sulu heirs. I would like to take this time to share my views on MA 63 and the links with the claim. In 1963, the Malaysia Agreement was signed between the United Kingdom, Great Britain, Northern Ireland, the Federated Malay state, North Borneo, Sarawak, and Singapore. This agreement was a foundation for the formation of Malaysia. This agreement, we must remember, was registered in the United Nations in 1970, and recognition was sought by Malaysia, and the federal constitution was amended accordingly. A precursor of this agreement was the Ehwal Commission that was formed to hear the views and recommendations of the people of North Borneo and Sarawak. Prior to deciding if the two territories wished to be joined and be part of federated Malaysia state to form Malaysia. Rigorous initiative, yet thorough engagement were conducted amongst the community leaders of both North Borneo and Sarawak. The total of 4,000 people representing 690 communities from both North Borneo and Sarawak were engaged. The Commission also received 2,200 memorandum from people of North Borneo and Sarawak. The final decision made by the Ehwal State Commission said that more than 2/3 of the people have agreed to join the federated Malay state to form Malaysia. And this time, the act of self-determination by the people choosing the nation they wish to belong to. These actions are clearly, to me, that no agreement signed way back in 1878, all the parties referred to so-called agreement have all long gone. If you read the agreement in 1978, referral to the High Commission of Britain in Brunei is no longer there. Oberbach is no longer around, and neither is the Sultanate of Sulu. All the parties referred to in the so-called agreement had all gone. Now, how could it supersede the right of self-determination by the people of Sabah? With this, I must say that there was never a valid agreement, and the so-called agreement was nullified when the people opted through self-determination to form a single nation, Malaysia, in 1963. I must also reiterate that this is not only in my view, a strong proponent of MA 63, but the views of many scholars and legal experts. Despite the ruling by the court in Paris and The Hague, the lead counsel of the claimant, Paul Coyne, was quoted by the Straits Times of Singapore in saying, "The fight is far from over." Those shows how third-party funded arbitration can drag on as a claimant do not have to bear the cost, and those who funded the enforcement proceeding are determined to continue with the expensive legal process in the hope that the government would come to a compromise over a huge arbitral award. And for us, for me, this we cannot allow to happen at all. In my understanding, this case of claim has no merit and should easily be dismissed by any court of law. Unfortunately for us, this case was tried before the court civil law jurisdiction and not the common law. And this, of course, made it difficult due to procedural complexities in the court. Nevertheless, we have been successful in 3 jurisdictions, thanks to the competent and the legal expert team from Malaysia and those representing in that respective jurisdiction. And I hope this victory, the entire matter will be put to an end soon. I would again like to reiterate my strong support for the Minister and the Prime Minister's Department, Law and Institutional Reform, for her strong will in spearheading the Sulu case team from both Attorney General Chambers, and the Legal Affairs Division. And I also would like to congratulate organizers for the well-coordinated colloquium. And we hope the target to inform the public, to create a better perception of what's going on, will be successful after this colloquium ends. I hope this colloquium serves its purpose of creating awareness, answering questions, doubt, and curiosity of many on the Sulu matters. I also hope all of you will continue to support and assist the government in providing a correct and accurate information on the grassroots community members so that this information on this matter can be alleviated. In short, as Malaysians, we all must stand together, not only for Sabah, but also for Malaysia's sovereignty. Like I said to the press early on, not an inch of this country ought to be touched by the people like the claimant from Sulu. Not a piece of property belonging to this country ought to be touched illegally by people like those claimants from Sulu, whether or not they are funded by the well-financed body like Tyrium internationally. With that, ladies and gentlemen, thank you.
Thank you, Young Berhormat, for your words. Ladies and gentlemen, we shall now move into the first session of the colloquium entitled The Sulu Case, Discovering the Missing Puzzle Pieces. Moderating the panel for the first session, please welcome Mr. Philip Gollingai, News Editor at the Star Media Group. Joining him on stage are our esteemed panelists. Yang Berhormat Tan Sri Datuk Sri Panglima Pandikar Amin bin Haji Mulia, President of the United Sabah National Organization and Special Envoy to Brunei Darussalam, Indonesia, Malaysia, Philippines, East Asian Growth Area, Sabah. Yang Berhormat Datuk Sri Panglima Yong Tek Lee, former Chief Minister of Sabah. Yang Berbahagia Datuk Professor Dr. Danny Wong Tze Ken, Dean, Faculty of Arts and Social Sciences at the University of Malaya. And Mr. Avtar Singh, Private Historical Researcher and Author. Ladies and gentlemen, please give our panelists a round of applause. Thank you.
Hello. Good morning, everybody. Tan Sri, Datuk, ladies and gentlemen. Welcome to the session 1, which is the Sulu case, Discovering the Missing Puzzle Pieces. Earlier, we saw the Chief Minister put up the pieces, but I think our panelists today will explain how the pieces go together. Okay, it will be an awesome and insightful 60 minutes. We have 4 distinguished panelists. They are Tan Sri Datuk Pandikar Amin, Datuk Yong Tek Lee, Datuk Professor Danny Wong, and Avtar Singh. I'll introduce them briefly before they make their presentation. Our first speaker is Tan Sri Pandikar Amin Mulia. He provided a modest resume to the organizer. He put in as president of USNO and then special envoy of BIM Niaga and BIM Niaga for Sabah. As a journalist since 1994, I've covered him, and then he wears many hats. He was like assemblyman for Usukan and Tempasuk. He was also the Dewan Rakyat speaker. And Tan Sri Pandikar, through WhatsApp, he has promised to give a fiery start to this session. The floor is yours, Tan Sri. Yeah, sana.
Terima kasih, Saudara Moderator. Assalamualaikum dan selamat pagi. Sahabat karib saya yang berhormat Tan Sri Dr. Wan Junaidi yang sekarang ini menyandang jawatan Speaker Dewan Negara, Speaker Dewan Undangan Negeri, Saudara Tan Sri Datuk Sri Hanifah Aman, Tahniah, karena sekarang ini Labuan you punya. Attorney General ataupun Peguam Besar Negeri Sabah, Datuk Aisyah, pegawai daripada menteri di jabatan menteri yang juga bertanggung jawab sebagai Menteri Undang-Undang kita dan Reformasi Parlimen, dan seterusnya kepada semua yang hadir pada pagi ini. Saya dipahamkan bahwa setiap panelis diberi masa 15 menit untuk berujar kepada satu subjek matter yang amat kompleks dan mustahak. Jadi kalau boleh saya mohon izin daripada moderator, as first speaker allow me a latitude of space so that the mood, I can create the mood. That one I can promise you. Tuan Moderator, saya mengucapkan ribuan terima kasih kepada penganjur kolokium ini yang sudi untuk menjemput saya bersama dan berkongsi pengalaman. Apabila saya dipanggil oleh pegawai daripada jabatan yang berkenaan, saya berpikir apa benda kolokium ini. Jadi saya tengok dictionary, rupanya kolokium ini adalah conference of academician atau conference of academic, bermakna orang-orang yang mahir dengan subjek matter. Jadi yang saya disuruh bercakap ini tidak tahu menau dia punya kepala ekor ataupun pokok pangkal untuk bercerita dengan satu perkara yang begitu mustahak. Tetapi saya diberitahu bahwa dalam sisi ini diberi tajuk sebagai The Sulu Case, Discovering the Missing Puzzle Pieces. Bermakna kes tuntutan Sultan Sulu, dan kami diminta untuk mengatur susun gambar kes Sultan Sulu, the puzzle. Jadi tujuan penganjur untuk mengadakan ini dalam sisi ini dengan tajuk ini ialah pertama, merongkai dokumentasi sejarah 300 tahun yang mengisah kewujudan kedaulatan wilayah Borneo Utara. Kedua, motif mereka untuk mengenal pasti percanggahan naratif, mengikut sejarah sehingga tercetus pertikaian antara negara Malaysia dengan pewaris Sultan Sulu. Ketiga, untuk memahami hak kepentingan diri ataupun right of determination yang dilaksanakan oleh penduduk negeri Sabah dan Suruhanjaya Kobold pada tahun 1962. Dan keempat, ini motif mereka membincang hubungan di antara penubuhan persekutuan Malaysia dan isu kedaulatan Borneo Utara. Jadi kalau setiap panelis diberi 15 menit dengan subjek matter yang begitu kompleks dan wide adalah tidak amat adil sekali. So allow me latitude please. Tuan Moderator, baru-baru ini rakyat negeri Sabah telah dikejutkan oleh sebuah berita bahwa harta Petronas berjumlah berbilion ringgit di beberapa negara di Eropah akan disita oleh pewaris Sultan Sulu sebagai pampasan atau keengganan Malaysia membayar kepada pewaris Sultan Sulu karena melanggar tarma yang terkandung di dalam dokumen pemberian pajakan pada tahun 1878. Tuan Moderator, selaku pembicara pertama, wajar saya tekankan untuk pengetahuan yang hadir, saya bukan pakar sejarah yang tersohor berkaitan dengan isu yang dibincang, ataupun sebagai seorang pakar dalam bidang perundangan antara bangsa berkaitan dengan isu pertikaian wilayah di antara pihak-pihak yang berkepentingan dalam isu yang berbangkit, yaitu di antara pewaris Keturunan Sulu dan Kerajaan Persekutuan Malaysia. Adapun inverted comma, kepakaran saya dalam isu yang berbangkit ini ialah saya anak merdeka negeri Sabah yang secara kebetulan berpendidikan undang-undang dan pengamal politik lebih kurang 40 tahun dan amat prihatin terhadap isu yang amat serius ini. Atas keprihatinan itulah, maka saya membaca risalah-risalah, artikel-artikel, dokumen-dokumen lama yang ada kaitan dengan kemerdekaan negeri Sabah, dan juga mendapat tahu tentang isu yang berbangkit ini daripada informasi-informasi melalui simbang-simbang dengan individu-individu yang kononnya ada kaitan dengan pewaris keturunan Sultan Sulu, ataupun mereka itu adalah pewaris juga kepada Kesultanan Sulu. Tuan Moderator, pada saya isu tuntutan pewaris Sultan Sulu ini tidak seharusnya tumbuh subur seperti sekarang ini. Sekiranya pihak berwajib di Malaysia sejak Malaysia merdeka, clip it from the bud, atau dalam bahasa Melayunya, sejak awal lagi memutung tunas sebelum tumbuh. Tuan Moderator, tuntutan pewaris Sultan Sulu terhadap negeri Sabah bukannya perkara baru. Perkara ini adalah hal lama, bermula berpuluh tahun sebelum Sabah merdeka pada September 1963 melalui pengujudan negara Malaysia. Sebagai contoh, pada 28 hari bulan April 1950, secara rasmi tuntutan Filipina terhadap Sabah dimulakan melalui resolusi Makapagal. Pada tahun 1951, Kongres Filipina meluluskan satu akta yang memperuntukkan bahwa perluasan konsulat Filipina di Singapura tidak dianggap sebagai pengetepian tuntutan Filipina terhadap Sabah. Pada 25 hari bulan November 1957, waris Sultan Sulu membuat pengisytiharan rasmi dan awam menyangkal perintah penyerahan dalam Majlis Masyuarat di Perundangan Britain pada tahun 46 dan membatalkan pajakan 1878 mulai 28 hari bulan Januari 1958. Pada 24 hari bulan April 1962, resolusi Ramos memberi kuasa kepada Presiden Republik Filipina mengambil segala langkah untuk memperoleh kembali Bumi Utara. Pada April 1962, waris Sultan Sulu Jamalul Kiram membuat pengisytiharan pengiktirafan Presiden Filipina terhadap pihak berkuasa yang menyokong Republik Filipina supaya memulakan, membawa dan meneruskan tuntutan terhadap Sabah. Pada 22 hari bulan Jun 1962, Republik Filipina mengemukakan secara resmi surat tuntutan kepada Kerajaan United Kingdom kedaulatan bidang kuasa hak milik ke atas Bumi Utara sebagai pengganti yang berkepentingan Kesultanan Sulu. Pada 12 September 1962, sebelum kita merdeka 1 tahun, Sultan Sulu Sultan Muhammad Ismail Kiram menyerahkan atau memindah milik kedaulatan atas wilayah Borneo Utara kepada Republik Filipina. Dan pada 25 Januari hingga 1 hari bulan Februari 1963, ingat kita merdeka pada bulan 9, ini bulan Februari 1963, wakil kerajaan Republik Filipina dan kerajaan United Kingdom mengadakan perbincangan resmi di London tentang pertikaian wilayah Borneo Utara. Tuntutan ini pada pandangan kerajaan United Kingdom pada ketika itu, kena dia yang menjajah Sabah, tidak berasas. Pada mereka tidak berasas. Sekiranya berasas, sudah tentu kerajaan United Kingdom tidak akan melibatkan diri di dalam gagasan untuk menubuhkan sebuah kerajaan baru yang terdiri dari wilayah-wilayah jajahan dan naungannya, yaitu seperti apa yang dibayangkan oleh Perdana Menteri Tanah Melayu pada ketika itu, Tunku Abdul Rahman. Semua kita tahu apabila kita baca risalah mengenai dengan kemerdekaan. Dia berucap dalam satu majelis di Singapura pada 27 hari bulan 5 yang dia membayangkan bahwa dia kata, there will be a time, now is come, that kita terpaksa satukan wilayah-wilayah ini. I got the quotation, but if I read it, you feel bored. Begitulah antara lain. Jadi Tuan Moderator, dalam isu tuntutan ini, Kerajaan United Kingdom tahu bahawa banyak bukti-bukti yang terkandung di dalam pelbagai bentuk treaty yang melibatkan United Kingdom dan negara-negara lain yang boleh digunakan sebagai asas atau alasan bahawa United Kingdom berhak terhadap Bumi Utara. Antara lain ialah Pertama, treaty yang dibuat antara Sultan Brunei dengan Syarikat Hindia Timur pada tahun 1847 ialah untuk menubuhkan lingkungan kepentingan British di Brunei. Orang British ini penjajah ini brilian. Dia orang buat langkah, dia orang cover, dia orang punya diri. Dua, treaty yang dibuat antara Sir James Brooke dengan Sultan Sulu pada tahun 1849. Tujuan ialah untuk mewujudkan lingkungan kepentingan British di wilayah Sulu. Ketiga, Treaty 1865 yang dibuat antara Sultan Omar Ali dengan Syarikat Perdagangan Amerika Borneo Utara terbukti merupakan perintis jalan bagi pemberian 1878 Sultan Sulu, yaitu Jamalul Al-Alam Borneo Utara kepada Overbeck dan Dent. Dan pemberian ini atau pajakan ini telah menjadi asas untuk mereka bertapak di Borneo Utara. Keberadaan ataupun kehadiran Overbeck dan Dent di Borneo Utara yang kemudiannya mencetuskan kewujudan hak milik United Kingdom terhadap Borneo Utara. Tuan Moderator, bermula daripada tahun 1877 hingga tahun 1946 terdapat berbagai-bagai dokumen yang boleh digunakan oleh United Kingdom bagi membuktikan puncak hak miliknya terhadap Borneo Utara. Tindakan yang memutamatkan hak United Kingdom terhadap Borneo Utara dari sudut perundangan antarabangsa ialah perjanjian memindah milik hak kedaulatan Borneo Utara dari tangan Syarikat Borneo Utara British ke tangan kerajaan British pada 26 bulan Jun 1946, yaitu sewaktu Borneo Utara dijadikan sebagai Crown Colony. Tuan Moderator, bersandar kepada treaty-treaty, perjanjian, pemberian, penyerahan dan sebagainya, itulah yang telah membolehkan United Kingdom untuk berunding dengan kerajaan Malaya untuk mengejutkan sebuah negara baru di mana Borneo Utara dan Sarawak dimasukkan sebagai negeri-negeri di dalam negara baru itu. Tuan Moderator, walaupun wajar juga disedari bahawa tuntutan pewaris Kesultanan Sulu ini telah pun wujud sejak tahun 1957, bukannya bermula sejak tertubuhnya negara Malaysia pada tahun 1963. Makna kata, tuntutan ini diwarisi oleh negara Malaysia daripada kerajaan United Kingdom. Tuan Moderator, dan perlu juga diketahui bahawa pada masa proses perundingan untuk menubuhkan kerajaan persekutuan Malaysia di antara kerajaan Malaya, United Kingdom, Borneo Utara, Sarawak, Brunei dan Singapura dari tahun 1961 sehingga tahun 1963, isu tuntutan perwaris keturunan Sulu dan Republik Filipina terhadap Borneo Utara tidak pun dibincangkan di dalam masyarakat SICC ataupun Malaysian Solidarity Consultative Council ataupun jawatan kuasa perundingan Perbadanan Malaysia. Suruhanjaya Kobol yang dilantik pada 16 hari bulan Januari 1962 dan tidak juga dibincang di situ. Dan dalam IGC ataupun Intergovernment Committee jawatan kuasa antara kerajaan tidak juga disebut di situ mengenai dengan tuntutan Sulu ini yang dibahas cuma kepentingan Sabah dan Sarawak saja, macam mana diberi jaminan oleh orang-orang daripada Malaya. Itu yang dibincang. Tidak ada isu mengenai dengan Kesultanan Sulu ini, because that is a done deal. Kerana itu adalah di antara United Kingdom dan Sultan Sulu. Tuan Moderator, walau bagaimanapun perlu juga disadari bahawa walaupun tuntutan pewaris Kesultanan Sulu terhadap Borneo Utara tidak menjadi salah satu agenda perbincangan di masyarakat jawatan kuasa yang membincang pengujudan Malaysia. Namun apabila Republik Filipina dan Indonesia menyedari bahawa gagasan mewujudkan negara baru Malaysia akan menjadi kenyataan atau tercapai, maka kedua-dua buah negara Republik itu membuat bantahan dengan sekeras-kerasnya, sehingga bantahan tersebut telah mencetuskan konfrontasi di antara Republik Indonesia dan ketegangan hubungan diplomatik di antara Kerajaan Malaya dan Republik Filipina. Pada saya, Tuan Moderator, bantahan Republik Filipina dan Indonesia adalah bantahan yang berbaur regional politik serantau untuk kepentingan negara mereka, bukan bersandarkan di atas perundangan antara bangsa. Tuan Moderator, Bapak Kemerdekaan Persekutuan Malaya, Tuanku Abdul Rahman menyadari permainan regional politik ini. Atas sebab itu, apabila Vice President Republik Filipina Emmanuel Pilais mencadangkan untuk diadakan summit di Manila yang akan dihadiri oleh ketua kepala 3 negara yang bertikai untuk mencari penyelesaian, maka Tuanku Abdul Rahman bersetuju kepada cadangan tersebut. Maka selari dengan cadangan tersebut pada 7 hari bulan sehingga 11 hari bulan Jun 1963. Diadakan di Manila persidangan 3 pihak menteri luar negara. Persidangan menteri-menteri luar tersebut telah membuat SOR yang dikenali sebagai Persetujuan Manila ataupun Manila Accord. Dan antara lain kandungan Manila Accord, saya baca, kedua-duanya, referring to Indonesia dan Filipina, mengalu-alukan penubuhan Malaysia dengan syarat sokongan rakyat wilayah Bumi Utara ditentukan oleh suatu pihak berkuasa yang bebas dan adil oleh Setiausaha Agung Bangsa-Bangsa Bersatu atau wakilnya. Menurut peringkat 10 dan 11 Persetujuan Manila itu, Setiausaha Agung Bangsa-Bangsa Bersatu atau wakilnya hendaklah menentukan sebelum Malaysia ditubuhkan kehendak rakyat Bumi Utara dan Sarawak dalam konteks resolusi Perhimpunan Agung bilangan 1541/15 prinsip 9, yaitu memastikan pematuhan penuh ke atas prinsip penentuan sendiri, yaitu self-determination. Tuan Moderator, yang paling menarik di dalam persetujuan atau Manila Accord itu ialah pernyataan di peringkat 12 yang menyentuh tentang pendirian Filipina terhadap kemasukan Bumi Utara dalam Persekutuan Malaysia. Bahwa kemasukan Bumi Utara ke dalam Persekutuan Malaysia tertakluk kepada keputusan muktamar tuntutan Filipina terhadap Bumi Utara. Dia gantung. Kenapa pada ketika itu perundingan antara pemimpin? Okay, I agree that you enter, but subject to our rights. What rights they are talking about? Bahwa Filipina akan terus berusaha mencapai tuntutannya mengikut undang-undang antara bangsa dan prinsip penyelesaian pertikaian secara damai. Lagi, what are you talking about? Prinsip apa antara bangsa yang sedangkan WIBUR ditentukan kita punya self-determination melalui Kabul Commission. Ketiga, kemasukan Bumi Utara dalam Persekutuan Malaysia tidak akan menjejak sama ada tuntutan itu atau sebarang hak di bawahnya. Anda dua di lock, orang punya interest sebelum pun kita merdeka. Karena itu adalah kepentingan mereka, yaitu politik serantau. Nothing to do with legal. Apa yang sekarang kita buat ini, kita belanja beratus juta for nothing, which we can stop long time ago. Bersetuju akan berusaha dengan sedaya upaya untuk menyelesaikan tuntutan dengan adil dan cekap, seperti dengan cara rundingan, perdamaian, timbangan atau penyelesaian mahkamah dan cara aman yang lain yang dipilih oleh pihak itu sendiri mengikut piagam bangsa-bangsa bersatu. Tuan Moderator, untuk mengelak dari sebarang kemungkinan, saya repeat, untuk mengelak dari sebarang kemungkinan yang boleh menggagalkan penubuhan Malaysia, maka Bapak Kemerdekaan Malaysia, Tuanku Abdul Rahman telah bersetuju untuk menangguhkan Hari Kemerdekaan Malaysia yang telah pun ditetapkan pada 31 bulan Ogos 63 ke suatu hari yang akan ditentukan kelak, yaitu setelah pihak Pertubuhan Bangsa-Bangsa Bersatu selesai membuat siasatan sama ada rakyat negeri Sabah telah benar-benar bersetuju tanpa paksaan untuk Bumi Utara merdeka melalui Persekutuan Malaysia. Ini adalah selari dengan pernyataan di peringkat 10 dan 11 Manila Accord. Karena apabila Filipina dan Indonesia, diorang pikir, diorang anggap, diorang sudah agak bahwa kita akan merdeka, maka itulah diorang bawa ke conference. Tuan Moderator, selari dengan perkara-perkara yang telah dipersetujui dalam Manila Accord, seperti yang dinyatakan di peringkat 12. Maka pada 17 hari bulan Jun sehingga 16 Julai tahun 68, kita merdeka 63. baru ada conference pada 68 di antara Filipina dan Malaysia dibuat di Bangkok. Wakil kerajaan Malaysia dan Filipina telah mengadakan perbincangan di Bangkok. Kena isa follow up to the agreement di Manila Accord. Malangnya perbincangan tersebut telah tidak membuahkan hasil atas sebab suatu pertikaian teknikal. Apa itu pertikaian teknikal? Pertikaian ialah kegagalan pihak wakil Filipina membekalkan kepada Malaysia 2 buah dokumen penting berkaitan dengan tuntutan ke atas Bumi Utara, yaitu bertarik pada 11 hari bulan dan 12 hari bulan September 1962. Jadi ada 2 dokumen yang Malaysia minta tapi Filipina tidak provide. Kena dokumen tersebut telah mereka bawa juga waktu berunding di London. 2 dokumen jurabangnya. Dokumen pertama ini adalah surat yang ditandatangani oleh Presiden Makapagal yes, pada 11 September memberi kuasa kepada Vice Presidennya Emmanuel Pilais untuk menerima bagi pihak Filipina satu lagi konon surat daripada Sultan Ismail yang mengatakan bahwa kedaulatan Sultan Brunei dikasih sama Filipina. Ini yang 2 dokumen yang disebut itu. Tetapi Filipina tidak kasih sama Malaysia karena mereka takut. Karena sangkaan kita ialah dokumen itu adalah dipalsukan. Ditisuno tariah dokumen. Sampai sekarang dia orang tidak provide. Apa yang terjadi Tuan Moderator ialah pihak-pihak yang berwajib di negara kita, termasuk Perdana Menteri, lalai dalam menjalankan tugas mereka. Pada saya, Tuan Moderator, setelah meneliti dan menghayati dokumen-dokumen yang berkaitan dengan kes tuntutan pewaris Sulu, bolehlah disimpulkan dengan tuntas bahwa kerajaan British adalah pemilik dan berhak kepada kedaulatan Bumi Utara, bahwa kerajaan British sah menyerahkan hak miliknya dan kedaulatan Bumi Utara sebagai salah satu negeri dalam Malaysia, bahwa proses kemerdekaan Bumi Utara menerusi penubuhan Malaysia adalah teratur mengikut kehendak-kehendak rakyat Bumi Utara dalam konteks resolusi Perhimpunan Agung bilangan 1541/15 prinsip 9, yaitu memastikan pematuhan penuh ke atas prinsip penentuan sendiri ataupun self determination. Tuan Moderator, pada saya itulah gambaran, susun suai gambar ataupun jigsaw puzzle Kes Sultan Sulu. Tidak ada satu pun kepingan yang tercicir. Apa yang terjadi Tuan Moderator ialah pihak-pihak yang berwajib di negara kita, termasuk Perdana Menteri, telah lalai untuk menanggalkan duri dalam badan Malaysia, yaitu tuntutan. Sejak merdeka tidak ada usaha-usaha agresif dari Malaysia untuk membuat tekanan kepada kerajaan Filipina atau pewaris Kesultanan Sulu untuk mereka menggugurkan tuntutan seperti mana yang telah digariskan caranya di bawah peringgan 12 Manila Accord. Tetapi di sebaliknya, Tuan Moderator, kerajaan Filipina dan pewaris Sulu tidak berhenti untuk memberikan tekanan kepada Malaysia. Sebagai contoh, pada negara Filipina, pendirian mereka yang dinyatakan di dalam peringgan 12 Manila Accord adalah belum memadahi dan belum cukup kesan kehebatannya di minda rakyatnya, termasuk pemimpin-pemimpin elit, untuk memberi impak yang lebih hebat dan mendalam di hati, lubuk hati setiap rakyat Filipina. Maka Akta Republik Filipina 5446 yang berkuat kuasa pada 16 September 1968 menganggap Sabah sebagai wilayah yang dimilikinya, dan pada 16 Julai 2011 Supreme Court Filipina telah mengesahkan bahwa tuntutan terhadap Sabah boleh diteruskan. Tuan Moderator, pada setiap pilihan raya untuk memilih senator atau kongresmen, calon-calon yang mengambil bahagian dalam majlis perbahasan calon-calon pastinya akan ditanya oleh moderator majlis perbahasan pandangan atau pendapat masing-masing terhadap isu tuntutan Republik Filipina. Tuan Moderator, tindakan tersebut adalah merupakan strategi Republik Filipina untuk memberikan kepada rakyat, memberitahu kepada rakyat Filipina secara siaran langsung bahwa Sabah itu adalah kepunyaan negara Filipina. Pencetus strategi ini menyadari bahwa berjuta-juta rakyat Filipina yang menonton program perbahasan calon. Tuan Moderator, sehubungan dengan kelalaian pihak yang berwajib di dalam negara ini, saya pembicara pertama dalam sisi pertama kolokium anjuran kerajaan ini dengan izin mencadangkan supaya kerajaan Malaysia bertindak dengan lebih agresif untuk mendepani isu tuntutan ini. Dia kasih saya 1 menit, saya akan kasih habis. Kita harus mendesak Republik Filipina dan pewaris Kesultanan Sulu untuk menggugurkan tuntutan mereka ke atas sebuah negeri yang merdeka dan berdaulat sejak berpuluh tahun yang lalu. Malaysia tidak wajar untuk diikat oleh Republik Filipina kepada terma-terma yang terkandung di dalam peringkat 12 Manila Accord, di mana di dalam perjanjian tersebut negara Filipina juga telah melanggar terma-terma perjanjian. Tuan Moderator, sepatutnya setelah tertunai syarat yang dikenakan kepada negara persekutuan Malaya untuk membenarkan wakil-wakil PBB untuk mengesahkan sama ada rakyat Sabah dan Sarawak benar-benar menyokong untuk Sabah dimerdekakan selari dengan kehendak resolusi 1514 kurungan 15 prinsip 9 yaitu self-determination, maka negara Filipina seharusnya juga menggugurkan tuntutannya ke atas Sabah. Tuan Moderator, melalui kolokium ini, saya Pandikar Amin Mulia sebagai pembicara pertama dalam sisi pertama yang membincangkan isu tuntutan terhadap negeri Sabah, mencadangkan tindakan seperti berikut. Pertama, mengadakan suatu referendum pungutan suara di Sabah untuk rakyat negeri ini membuat pendirian bahwa, baru kamu bertepuk, karena itu yang kamu paham. Kalau saya tidak berucap begitu, tidak ada yang paham, karena ini adalah soal teknikal. Mengadakan suatu referendum di Sabah untuk rakyat negeri ini, membuat pendirian bahwa anak-anak negeri merdeka Sabah tidak membenarkan siapa saja untuk menuntut negeri kami. Kedua, mengajak kerajaan Filipina untuk mengadakan summit di mana 3 negara yang terlibat di dalam penggubalan Manila Accord berbincang kembali untuk mengkaji terma-terma yang terkandung di dalam Manila Accord tersebut. Tuan Moderator, cadangan ini didorong oleh perasaan sedih dan membara-bara karena rakyat negeri ini tidak lagi sanggup untuk menghadapi kejutan-kejutan dari masa ke semasa disebabkan oleh isu tuntutan ini. Tuan Moderator, beberapa tahun yang lalu kami dikejutkan oleh kes berdarah di Tanduau. Beberapa bulan yang lalu kami sekali lagi dikejutkan oleh kes yang menjadi puncak kolokium diadakan pada hari ini. Tuan Moderator, sebelum kami dikejutkan selanjutnya oleh isu tuntutan ini, kami pohon untuk kerajaan Madani untuk bertindak dengan berani. Tuan Moderator, dengan hujah yang membosankan para hadirin itu, I raise my case.
Thank you, Tan Sri Pandikar. What he said is we need to nip it in the bud. And to summarize what he said, Sabah belongs to us. It's a done deal, and we have history to back us. And then the next speaker is Datuk Professor Danny Wong, who will talk about history. He's the Dean of the Faculty of Arts and Social Science in University Malaya. He's also a Professor of History at the Department of History in University Malaya. I know Professor Wong since our LaSalle day in 1980s. And I don't remember him showing interest in history because I think he was in science stream and I was in art stream. So I was a bit surprised one day when I saw in the newspaper that he's been quoted about history. Okay, I've asked Datuk Wong to cut short a bit because we are running out of a bit of time. So, yeah.
Can I have the slide? Yeah, thank you. A very good morning to everyone. Thank you, Philip, for the introduction. Yang Berhormat Senator Tan Sri Wan Junaidi, our Speaker of the Senate, Dato Sri Khairu, the Director General, our Chief Secretary to the State Government, ladies and gentlemen, I would not address everyone here, but it is very nice to be here. I wanted to thank the organizer for having me today. And if I may just, this is because we are given 15 minutes, so this is really to concise 300 years into 15 minutes is a challenge. Therefore, I would like to just pick up some historical antecedents for us to discuss. So, as a historian, I thought the best way to contribute to today's discussion is through historical sources. And I would like to pick up one or two of them, which I consider to be related and also in many ways resemble to the case that is ongoing or shaping up today. And secondly, to see how earlier governments, especially the British North Borneo government, actually reacted to some of these questions about cession money and also perhaps the question of sovereignty. So I would like to draw your attention to two cases. One that took place in 1939 that was alluded to by the International Arbiter. And also the second one, in 1946, there was another case that I think somehow the arbiter chose not to mention. So this is what I'm going to do. And if I may just move out a bit from this. My slides are a bit wordy, so I hope you can actually bear with me. So if you look into today's case that we are at hand is actually something that has been built on for many, many years. So Malaysia that we see today is not a country that was shaped overnight by one treaty. In the case of Sabah and also our relations with Malaysia, it's actually much longer, 300 years, and I would like to group them into 6 groups of treaties and agreements and arrangements and accord and so on. So first one, pre-19th century, Sulu and the islands of Balambangan, case of Spanish and the Brooks and so on. Up to the second one, up to 1865, this was when the Spanish talked to the Sulu, the British talked to the Sulu, and then we took, or rather the British took Labuan in 1846. And then thirdly, you can see the most important one for us for today's case would be the 1865 to 1878. This was when the Brunei government actually gave out Kimanis area a concession given to the American company in 1865, and that's the original agreement that was inherited by Overbeck and also Dant eventually in 1877, because he decided that we want to renew this concession, and then the territory was ceded by the Brunei government. And in 1878, January, they went to Sulu and signed this agreement that formed the basis of our discussion today, and the very basis of the agreement that formed the state of North Borneo. Between 1878 to 1909, then you see the consolidation of these treaties, of these territories. So when you have North Borneo Company consolidated with all the rivers on the west coast, for instance, the islands on the west coast that were actually signed agreements. There were agreements signed by the government then with all the chieftains on the West Coast, especially after the Mat Saleh incidents or Mat Saleh affairs. From 1909 to 1941, you have a clearer demarcation of boundaries, and therefore you have the Dutch boundaries at the south with the Dutch Borneo, and also with some of the islands like Turtle Islands with the United States in 1930s. And then after that, 1961, when Malaysia was mooted, then right up to 1966, the confrontation, and of course the Manila Accord. So there were a lot of issues, a lot of treaties that actually helped to shape what we are today. But the treaty that we want to focus on, of course, is the 1878 treaty and also the 1903 that actually formed the basis of our discussion today. So the initial stage was to actually get a concession from the Brunei, and then later there was the original concession given to the American Trading Company, and then later on the treaty was renewed, and then the territory was transferred to Overbeck and also Alfred Dan. And that was in 1877. January 1878, Overbeck and Dan went to Sulu and obtained the remainder of the territory thought to be under the Sulu Sultanate since 1702. This was at the suggestion of this first governor or governor designated at that point of time, William Treasure. So the treaty, if I may remind you, so you can see that there is a treaty, that's a copy of the treaty in Javi, and the term would be a payment of 5,000 and added on another 300 in 1903 when the territories were spelled out carefully. So that was a confirmation of the territories, the islands and so on. Overbeck was appointed Maharaja Sabah and Raja Sanakan, etc. And this treaty was stipulated very clearly that it's transferred in perpetuity forever. And there's no room for redress. There was no clause for arbitration or termination and so on. So this was alluded to by our speaker today, Speaker of the House, and also by the Chief Minister, His Honorable Chief Minister. There was no room, there was no clause for redress, for arbitration. So anything you want to talk about this, you have to actually refer to the British Consul General in Brunei, of course, which is no longer in existence. So we are talking about the representation of Britain. So altogether, the Treaty of 1877 and the subsequent treaties that with Sulu, this formed the basis of our territory of Sabah. And the payment was continued, and over the years you can see that is reflected in the Treasury reports. So these are the terms. So it was forever $5,000, and then you cannot transfer no transfer to any other nations without the consent of the Britannic Majesty's government. And then, of course, the Overbeck and Dan promised to help the Sultan of Sulu in face of Spain, later in face of America. Now, in 1936, the Sultan of Sulu, the last Sultan of Sulu, Sultan Jamalu Kiram II, passed away. He died in June 1936, before the session money was paid for that year. And so the heirs of Sultan Sulu, he left behind no sons. And therefore, there was a bit of disputes among the family members as to who should be the heirs to collect the money, 5,300. So they brought a case to the court in British North Borneo at that time, in Sanakan. The idea was that the government had not been paying since the death of Sultan, because the government C could not identify who are the heirs to this agreement to the Sultan. And therefore, this was led by Dayang Piandao Kiram and 8 others. So they solved a judgment, and the High Court judge at that point of time, CFC McCaskey, decided that the Dayang and the 8 claimants would be the right person to be paid. They are the heirs at that point of time. And therefore, the government was obliged to pay. But the government have been very clear in that aspect. Right from the beginning, they wanted to pay. But it's just that at that point of time, no heirs were identified. And therefore, it was necessary to actually have the High Court to determine who are the heirs to the Sultan. So the McCaskey decided that the Dayang and the 8 others would be the rightful heirs, and therefore payment was continued. There was no issue about sovereignty here, because by 1936, upon the death of Sultan Jamalur Kiram, there was no more Sultanate of Sulu. The Sultanate of Sulu was no longer recognized by the Filipino government. So that is something that we got to bear in mind. Right from beginning, there was no more Sultanate of Sulu. So there was no legal basis in terms of sovereignty, but only in terms of heirs as in personal property. So they were heirs to the money, but not to the sovereignty. So this is a point that was not highlighted or missed by quite a few others. So later, there was this idea that the payment was continued, but we were not sure whether 1940, 41 were paid. But war broke out in December 1941, and of course, North Borneo, Sabah, as well as much of Southeast Asia, including the Philippines, were occupied by the Japanese right up to August 1945. So upon return of peace, between then and the return of peace, no payment was made. So, therefore, in 1939, at that point of time, Dayang, Piandao Kiram, and 8 others were recognized by the court in Sanakan as the rightful heirs. I'd like to bring you forward to 1946, the second case. In June 1946, the Sulu claimants engaged a law firm in Chicago to make representation to the British North Borneo Company and presented a letter of termination to the British North Borneo Company. So you can see a resemblance of a pattern of engaging someone from outside. So in this case, from the United States. And the law firm was Adams, Moses, and Kluwer of Chicago. The letter of termination actually stated that the grants of 1878 was by the issuance of the letter of termination is hereby terminated. So they said that this grant is no longer valid by 1946. And in view of the impending transferring of North Borneo, British North Borneo, from the company to the British Crown, it was deemed time to negotiate for a new grants. They wanted a new grants to be negotiated with new terms. They were not happy with the existing terms because $5,300 in 1878 was a hell lot of money, but by 1946 it wasn't. It was just 5,300. So therefore they wanted a new term to be negotiated, and also indicated that there were other parties who were interested with the territories. If you don't want to negotiate, leave it. We are going to another party. That was how the letter of termination was presented. So they accused the British North Borneo Company for failing to pay since during the war. I mean, nobody can pay you any money during the war when you're occupied. Life was at stake. But then this was used against the British North Borneo Company. And they also emphasized that the transfer of the territory to the British Crown was not right. And in fact, they accused the British government of seizing the territory. So this is not right, according to them. And that the present term unfair and not reasonable, especially on the amount of the cession money, which is too small. And they also demanded that not only cession money, but also areas of income from economic gains during the years from 1939 to 1946. And also, if you read the letter of the termination from the day the treaty started in 1878. So I will not read through all this. These are the 8 items laid out in the letter of termination. And so they said that, you should, it's already, this is not valid anymore. For them, there are terms, you better, one of the points that they mentioned was that the said grant in perpetuity is contrary to law. So the international arbiter actually also said that. So this is the same point of law. The consideration provided in the said grant is wholly inadequate, inequitable, and insufficient to support a good consideration for said grant. For 5,300, not enough. Therefore, we need to negotiate. So the point here is that a lot of things were actually focusing on the amount of money. And if you look into the last term, the demand is hereby made for an accounting of all ways committed inconsistent with terms of the grant from January 22nd, 1878 to January 21, 1936. That's the year when the Sultan passed away. They say, look, you need to do the accounting since 1878 because a lot of money were involved. So the primary goal of the heirs was essentially money. So the gains, financial gains. Let me just move on to the reply from the British North Borneo Company, which they sent to the Foreign Office for vetting before they apply. The law firm that represented the North Borneo Company was Stevenson, Harvard, and Tatum of London. The letter, I quote here, "We are instructed by our client," we here means the lawyers, "to repudiate expressly each and every of the grounds of the termination referred to in the said notice, and to inform you that your client had no right whatever on those or any other grounds to terminate the grant in question. Accordingly, the notice of termination enclosed in your letter under reply is returned herewith. We are further instructed to advise you for the information of your client that the government of North Borneo has been authorized to make payment at Sanakan of all outstanding cession monies on proof of title." So on the first part, the government of North Borneo says, no, you have no ground because there's no clause saying that otherwise you can actually renegotiate and so on. 1878 says that it's forever, and that's the term, 5,000. Added on another 300 in 1903. That's it. There is no non-negotiable. So the government of the day was very clear that this was not negotiable. So therefore, whatever terms that they put up to terminate this grant or this agreement would deem to be void, null and void. And But the government did mention that, look, as far as the session money, we will pay. Sometimes the government cannot pay because of certain circumstances when the heirs could not agree as to who are the heirs. And that has been a recurring problem to Sabah, to Malaysian government. Again and again, over the years, we have seen different claimants coming, challenging each other and presenting themselves to the state government, to the Malaysian government, and therefore it was difficult for the government to decide. From time to time, there were times when it was suspended, then it was repaid, continued to pay once an heirs has been decided. So since then, since 1946, mind you, in the judgment, final judgment, this 1946 case was not mentioned by the arbiter, by the international arbiter. So this is something that I think they conveniently ignore because it is not to their benefit. So they just brush it aside and so on. But then these are in the documents, in the historical documents that we can actually find. And there are a lot of conversation, a lot of discussion within the government, with the Foreign Office, and with the legal firm as well, talking about where we stand over this issue. So we can see that from 1950, after 1946, you can see occasional claims made by the families. And in 1962, President Macapagal actually dragged the Sulu claim to become part of Philippine claims. And therefore, we had the issue in 1963 over a Malaysian agreement, so the Manila Accord. And since then, even with the Manila Accord, we have seen how continuous attempts made by different Filipino presidents going back against their words to claim or not to claim and so on. We have seen that being played out in the past 40, 50 years. And continuous efforts by different parties within the Sulu families to claim, presented themselves as heirs to claim the session money. So again, the bottom line would be the session money. But of course, we all remember the 2013 military incursion by certain Sulu families or claimants or heirs and so on. So we stopped paying, suspended payment at that point of time. And then, of course, they presented the case for arbitration. Now, what can we glean from this presentation? I hope, give me 2 minutes. One, there are definitely lots more antecedents in the past, in the present case. So historical precedents, historical antecedents are definitely there. And I think we need to do more of this sort of research so that we can get a bigger picture, a clearer picture as to where we stand. Secondly, is that I'm not sure if they are coming back again after this. It seems that it is a habitual behavior. They keep on coming back. And there are definitely third-party funders and so on. So I hope we can actually put a stop to this bad habit of theirs. And thirdly, the authority in this case, I think we learned from the British North Borneo Company, and they are very clear. Also, the colonial government subsequently very clear and firm on the stand that the 1878 agreement is not negotiable. It's not something that you can just simply terminate. It's not something that you can change. And I think these are something that we can certainly note and learn. Well, in 1936 and 1946, it was clear that in both judgments, we are obliged to pay. But we are not obliged to pay because of anything else apart from paying to the heirs of the Sulu Sultanate. That's it. No sovereignty involved. So with that, thank you very much.
Thank you, Professor Danny Wong. Just to summarize, what he said is before the Stampa arbitration, there was arbitration 1.0 in 1946, and it looks like we won that one. Okay, the next speaker is my Facebook friend, Avtar Singh Sadhu, and he's a private historical researcher and author. He has published 5 historical books since 2017. Sir?
Thanks. A very good morning, very good day, everybody. Tan Sris, honorable senators, Datoks, Datins, ladies and gentlemen, I'd like to take this opportunity to thank Institute Development Sabah for the opportunity to present my findings today on 300 years of misleading historical narratives by the Sulu over Sabah. My research began in 2018 with my research partner, Shari Jeffrey, and our primary research began from a very different angle. Shari had managed to acquire all the essential documents, all the treaties and agreements, and we were able to decipher the agreements, go through them, and better understand what were the terms and conditions of these agreements. And there are many agreements. It's not just 1877 and 1878. It's significantly more. My role in the research was to look at things from a very different angle. Why would two sultans agree to sell? It actually essentially is a sale and purchase agreement if you want to look at it in layman's terms. Why would they both agree to give up all claims of ownership over Sabah at the same period of time? It's only a month apart. And so we started digging and going in and trying to understand the historical narrative of that period of time. What was going on in the world around us in Sabah, Brunei, and Sulu? And when we discovered what we did, it gave us a better understanding of whether it was secession, or lease. Brunei ruled Sabah. That is a fact. It's a fact that tends to get ignored in most historical narratives around the world, except in Borneo. It's 500 years that Brunei ruled over Borneo and Sabah. The Sulu are a relatively new sultanate. They're not the only sultanate in the Sulu Sea. They are one of many sultanates that existed in the southern Philippines. So there's this narrative, this false narrative that exists that only one sultanate existed and they were the most powerful sultanate in southern Philippines. Going back to the 1500s, this is false. There were many sultanates in the Sulu archipelago. Some of them didn't call themselves sultans, they called themselves Raja. And so we believe historically the Sulu Sultanate was originally a Raja that became a Sultanate due to intermarriage with the Sultanate of Brunei towards the end of the 1500s, early 1600s. Now, the once mighty Brunei Sultanate had faced many challenges since the arrival of the Spanish in the 1500s. And so this map doesn't get seen very often. It basically tells us the Brunei sphere of influence over the region. Once the Majapahit Empire collapses, Brunei then replaces Majapahit and they rule over all of Borneo and the Philippines. They in fact establish Manila. We believe that historically the Sulu Sultanate at that period of time, it may have been a Raja, And all the different kingdoms that existed in the southern Philippines were vassals to Brunei, and they paid tribute to Brunei. For the Sulu Sultanate, their circumstances are a little bit different as far as what transpires in the mid-1500s. Once the Spanish arrive, everything changes in the mid-1500s. Once the Spanish arrive, a number of things happen. Number one, cause and effect. What happens when you have a European power arrive in your backyard? The Europeans go through a period of extreme barbarism and forced conversions of many of the people of the southern Philippines who are Muslim. It's a period of forced conversions and attacks on many of the kingdoms and villages in that southern part of the Philippines. This causes a period of instability that lasts for 300 years until the Sulu are finally defeated in 1878. So when we did the research, what we found was that after centuries of raiding, kidnapping, and slavery of Sabah natives on the coast, the end was essentially, it was the end of the Sulu Sultanate basically. By July 1878, they were forced to sign a surrender to the Spanish. And so that pretty much puts an end to whatever great sphere of influence the Sulu had at that period of time. Where do the Sulu get their support to argue their case over Sabah? It comes from getting assistance from historical documents and books by established authors. One of them is Najib Celebi. Those of you who have been reading on Philippine history or Sulu history will be very familiar with Celebi. Now, Celebi is oftentimes referred to as an important historical source when scholars and the media need references to discuss topics relating to the Sulu claim over Sabah. However, one could argue that Celebi may have indirectly written inaccurate stories passed down from generation to generation. And he may have innocently, without realizing, have written half-truths and fictitious historical narratives based on what he was told by people that he interviewed to write his book. Whilst I do not suggest Celebi is deliberately or intentionally, did not intentionally or deliberately wrote these fictitious and misleading historical narratives, we must question his sources of information. And if he did indeed take into account the Brunei version of history, which is missing from his book. The other narrative that's important to take note of is Celebi's interpretation of the Sulu influence on the east coast of Sabah, which is really where it all begins. The claim over Sabah. It really has to do with the influence of the Sulu on the east coast of Sabah up to January 1878. James Warren in 1981 debunks this question of did the Sulu Sultanate have a system of administration and tax collection on the east coast of Sabah. In his mind, it is the powerful datos that are in the royal court in the Sulu Sultanate that actually are and have influence on the east coast. Now, having people travel to the east coast of Sabah to demand tribute versus setting up an administration center on the east coast of Sabah, they're two different things. If you are going to the east coast and threatening the natives of that particular east coast of Sabah with the threat of a knife that we will either raid and destroy your villages unless you pay us, or If they disagree to pay you, then you go ahead and destroy those villages. So you then obviously act, you are kidnapping the natives and you are selling them into slavery, and this is what basically transpired. Now, Warren is basically telling us it's the Datos that actually have influence on the East Coast. They are not necessarily based on the East Coast. It's the pirate bases that they set up on the East Coast that actually is what most people have confused, this narrative of administrative center versus setting up a pirate base on the East Coast. These pirates that set up these bases on the East Coast, they're small little villages, at times go to war. They're not there without anybody trying to stop them. At times, they are fighting with the natives on the East Coast, including the very little known Tidongs, who also are on the East Coast of Sabah. We tend to forget about the Tidongs. But there's simply no evidence to suggest that an actual administrative center existed on the East Coast. And so we ask this question, where does this claim come from that they once ruled over North Borneo? And they had a sultan of North Borneo as well. William Pryor shared very important insights into the population on the east coast of Sabah in the late 1800s. So there's this narrative that the Sulu have always been on the east coast of Sabah, and that is simply not true historically. We know this because we actually have the population census of the population in Sabah along the coastline in the late 1800s, and we can definitely see the pattern of different ethnic groups and the numbers. Now, William Pryor confirms what we know, in that the population on the east coast of Sabah by the late 1800s was decimated by a century or more of raiding, kidnapping of natives to be sold into slavery. And there's a population imbalance as well at this point in time. The population tends to be a little bit bigger, far more bigger on the west coast of Sabah, unlike on the east coast of Sabah where the population is sparse. Sparse means tidak begitu banyak orang, seperti di sebelah pantai barat Sabah. When we look at historical books in the Philippines and also the Sulu heirs, when they talk about their claim over Sabah, the one topic they refuse to touch on and will not talk about is 300 years of piracy, raiding of native villages on the coastlines of Sabah, kidnapping of natives of Sabah along the coastlines and also along rivers, and then the enslavement, the selling of natives into slavery. On many of the pirate islands in the Sulu archipelago, they would have slave markets to sell natives as slaves. They don't talk about this. You will find it missing from their historical narratives. We believe the average number of natives of Sabah who were kidnapped from the coastal and river villages over a period of 200 to 300 years to be not very far off from the average number of men, women, and children from the northern Philippines who were kidnapped twice a year. They would raid twice a year these villages in the north, an average number of 4,000 men, women, and children. So we believe that number is not so far off for Sabah as well. William Pryor also discusses a pirate raid that occurs on the east coast of Sabah, where an incident in 1879, 60 Bajaus were either killed or kidnapped to be sold as slaves. This is after the agreement, the grant of 1877 and 1878 is signed. So piracy is still ongoing even after the grants are signed. Pryor, interestingly, also says that some of these Sulu pirates have stopped acts of piracy and they've actually retired on the east coast of Sabah, meaning that they have set up homes, possibly married as well, and are no longer doing piracy. They have now begun a life of agriculture instead. Precedents of honoring treaties and agreements. The Sulu Sultanate have a horrible record of honoring agreements. It goes back centuries. So what they would do is they would go to war with the Spanish, they would lose battles, and what they would do is basically say, okay, we give up, we surrender, let's sign a peace agreement or a treaty. So they sign a peace treaties 1640, 1725, 1742, 1744, 1758, there's more. And in every instance after they sign these agreements, the Spanish have left, they tear up the agreements and they go back to doing what they were doing previously, which was attacking settlements in the north, conducting raids on the villages, kidnapping, slavery. It just repeats itself over and over again. What does this precedent tell us? They don't honor agreements. For them, the contents of an agreement mean nothing to them. It merely buys them time to rebuild, to rebuild their manpower, rebuild their ships, re-establish themselves, and then to go back and do what they were doing previously. That's all it is. It's just to buy time. This is very rare. We've actually got a quote from the Sultan of Brunei. So, this false historical narrative that the Bruneians gave away North Borneo during the Brunei Civil War, and part of a promise that Sultan Muhyiddin may or may not have made to his cousin in Sulu, has been rebutted by the Bruneians since the 28th of September 1764. So what's going on is this. So there's a brother who is put in jail in Manila. He's a Sultan Al-Muhyiddin. His brother then takes over his role as Sultan without the permission of his brother. His brother, who's in jail, then converts into Christianity. So younger brother then tells the British when the British arrive to negotiate an agreement for Pulau Belambangan that I'm the Sultan. So he signs an agreement with Dramfil. Dramfil records in his diaries and journals that, I've met the Sultan of Sulu and he claims that all of North Borneo is mine. The Bruneians hear about this later and they basically inform the East India Company that, hang on a minute, this is not true. We never gave Sabah. This is ours. You should be discussing with us. So the Bruneians set precedents in denying that they ever gave away North Borneo or Sabah to the Sulu. They never stayed silent. They always challenged the Sulu in this. The other thing that's interesting is the Sultan of Brunei receives a letter in 1965 from the claimants to the Sulu Sultanate. And they are basically asking him to help them with the claim over Sabah. And the Sultan of Brunei merely writes back very simply, no, I'm not going to help you. You should learn to honor agreements and treaties. As far as we are concerned in Brunei, we are honoring all our agreements and treaties and we're not going to challenge anything to do with this anymore. It's done deal. This is probably the most important part of our research in understanding, was it a sale and purchase agreement? In layman's terms, was it a sale of the territory or was it a lease? So we try to look at what's going on in Sulu in 1876 and into 1877. This is also missing from the Sulu history. They don't want to talk about this part especially because it tells us everything we need to know, that it was never a lease. The Sulu Sultanate, in September 1877, the Sultan writes to Labuan, to his old friend Don Quatron, who is the first Catholic priest of North Borneo. So Don Quatron was formerly a pirate. He finds his way in life, becomes a priest. He's living in Labuan, and he has a relationship with the Sultan of Sulu. Sultan of Sulu writes to him and says, please help me to negotiate a truce. Speak to Governor Treacher, speak to the Germans, ask them to help. The Germans are present in the area, they're doing business. Please speak to them to negotiate a truce with the Spanish because I don't want to do it. I don't want to lose face. So So please help to negotiate a truce. Quatron doesn't want to get involved in this. He reports this to Governor Treacher. Nobody gets involved. But what happens is interesting. Treacher somehow reaches out to Alfred Dent and his brother and Baron von Overbeck, who is in Hong Kong, that there may be a business opportunity here. At that period of time, the Dutch had taken pretty much what was available in the region as far as territories are concerned. So if you look at what's going on around Southeast Asia, the only territory that's left unclaimed by the Europeans is North Borneo. That's still available. Nobody's got that. So when Overbeck goes to Brunei, he signs an agreement with the Sultan of Brunei. Now, the Sultan of Brunei really has no choice at that period of time. The natives on the west coast of Sabah are no longer cooperating with Brunei. And so the easy solution for him is to give up his claims and to just accept the payments on a yearly basis. The Sulu, on the other hand, when Overbeck arrives in Holo Island, he brings with him guns, ammunition, weapons, and a new weapon called the Gatling gun. It's a multiple machine gun that fires 1,000 rounds a minute. This is not mentioned. So when they bring these toys to him and all these weapons and ammunition, it basically motivates him to agree to the terms that are given to him, which is sell us the territory. We'll give you 5,000 Mexican pesos a year. And if you need to escape to Sabah, you come over. Overbeck will be in charge of Sabah. You have a safe haven to come to, and you have 5,000 Mexican pesos to retire with for your family to enjoy for the rest of their lives. If you look at the terms of the 1878 agreement, it doesn't favor the person who claims that it was a lease. It favors the buyer. Okay. And so to conclude, what is obvious to us when we look at historical documents and evidence is there's a precedence for the claimants. It's always a case of pay us, or how much will you pay us to stop disturbing you. It's basically that, in layman's terms. The narratives have not changed. It's continued since 1939 and so forth. In a particular newspaper clipping in the Malay Tribune in 1946, the claimants have now apparently inserted a new clause in this 1878 agreement. We can give you 1 year's notice and then we can take back the territory. So you go back and look at the agreement, the grant of 1878, there's no such clause. But they're making things up as they go by giving 1 year's notice. The last point I would like to make is for your consideration. Which sultan in history who claimed to own a territory would then go and conduct raids on the same villages of the people he claims to rule over, destroy the villages, kidnap the natives of the villages to sell them as slaves? Does that make logical sense to you that this person would rule over this territory in any shape, way, or form? Of course not. That doesn't make sense. Thank you very much.
Thank you, Aftar. Just to summarize what he told us about half-truth history and missing narrative. The final speaker is Datuk Seri Yong Tek Lee. He was a Sabah Chief Minister, and I got to see Datuk Yong in action in Holo and Zamboanga City when I was a journalist in the year 2000, as he was part of a Malaysian team to facilitate the safe release of Malaysian hostages kidnapped in Sipadan and held in Holo. What I'm trying to tell you all is Datuk Yong knows the Sulu terrain very well. Okay, Datuk Yong will wrap up our session. As we are pressed for time, Datuk Yong has kindly agreed to speak for 6 minutes and counting. Over to you, Datuk.
Thank you, Philip. Tan Sri, Dip Kohamat. I'll limit myself to 5, maybe 6 minutes, straight to the point. The subject being the missing pieces. something I have brought about at various forums, including in the media, but somehow it has not been taken up. But I'm very happy that the historians today have highlighted a lot of the historical facts that were not, until now, presented as a Malaysian government narrative. Because we have always used 1963 formation of Malaysia, we have always used the Brunei, the Overback Sulu Treaty of January 1878. I have 3 points today. Number one, we have to revisit the 1939 Makassti judgment. Number two, we have to boost ISCOM, because ISCOM, Eastern Command of Sabah, is the best thing to happen to Sabah security ever since the formation of Malaysia. But ISCOM needs all the support and all the assets and all the facilities that the government can afford to ISCOM. It has done a very good job. It can do an even better job, but it will need all the resources that the government can give. Number three, across the border, we have to engage more actively and more intimately with Bangsa Moro Autonomous Region of Muslim Mindanao. Now, Bangsa Moro Autonomous Region of Muslim Mindanao is created partly, mainly actually, with the support of the Malaysian government, leading to the comprehensive agreement on Bangsa Moro. Why I say this? We need the Bangsa Moro government to be successful, to bring stability to the southern Philippines. At the same time, Bangsa Moro is the modern state government, modern government of state that can do away with the defunct Sulu Sultanate. We can move away from this talk of the Sulu Sultanate to the Bangsa Moro government. Now, where do I come from? I come from Lahadatu, ground zero of Tando. My first encounter, my first activity encountering the Philippine claim to Sabah was when I was a student. We were made to march 1.5 miles from my school, St. Dominic School, to downtown sports club, where we watched the burning of the effigy of President Makabaka of the Philippines. That was 1965. I was in primary 1. Fast forward, in London School of Economics, we knew all about the early writings of Professor Michael Leifer. Now look him up. Bahagian, Ehwal, Undang-Undang, so look him up. He's passed away, look up his writing. Professor Michael Leifer, one of the early academics in London, studying the Philippine claim to Sabah. Now, what are the missing pieces? Number one, I thank the historians for bringing this up, is the treaty between Brunei and Overback of 29 December 1871. That is the treaty we should look at in order to nullify the Treaty of January 1878. We keep talking about 1878 when in fact there is an 1877 treaty. Why? Brunei had already ceded North Borneo to Overback, Alfred Den, and so on. Therefore, Sulu had no right and no locus standi. Lawyers, we call this what, Roger? The name of that rule. What is not yours, you cannot give away. It is not for the Sulu to give away because it was never, North Borneo was never part of Sulu or the Philippines. If we use the Treaty of 1878, we are admitting that somehow the Sulu, today's Philippines, has something to do with Sabah. In historical fact, there is none. The second missing part is the Paris Treaty between United States and Spain after the American-Spain War of 1898. That boundary, national boundary between Spain and America of 1898 shows that North Borneo is outside the Philippine claim to Sabah. Number three, Datuk Cairo, ladies and gentlemen, Wisma Putra, please. A lot of the evidence in support of Sabah and Malaysia It's not in Spain, it's not in London, it's in Brunei. Tan Sri Wajiradi, it's in Brunei. I have seen myself, the museum and some of the archive. Yet, we are not using those documents in Brunei that go beyond, before 1878. That again talk about how Brunei have repeatedly rejected the efforts of the Sulu to claim Sabah by Brunei, even before Malaysia. A lot of the evidence in our favor is in Brunei. The next one is, of course, the McCaskey judgment. After Judge McCaskey passed away, the book written by him was published by his descendant. And that book talked about his judgment, how the British Colonial Office had been unhappy about his judgment and how he explained that. That can be used in our favor. The other one that Dr. Danny Wong has spoken about is actually the $5,003 payment by the North Borneo Company to Sulu was stopped by the Japanese. There was a break. There was a break. I think we can use that to our advantage. I fully support the Malaysian government in 2013 stopping the payment. It doesn't matter if later on another Attorney General make a mistake. At the time of stopping the payment, it's completely in order. The other one, Tan Sri talked about the Manila Accord. Prior to the Manila Accord, before the Philippines government took up the claim to Sabah, prior to the Manila Accord, was the Sulu descendants giving a power of attorney from Sulu to the Republic of Philippines to handle their claim on behalf of Sulu. In other words, the Sulu have already surrendered their rights, whatever that they have, to their government of Republic, to the Philippine government in Manila. Last but not least is the Philippine Constitution of 1987. You remember, in 1986 there was a people power revolution. A very popular government came to power and they amended the Philippine Constitution, particularly the article on definition of Philippine territory. Prior to 1987, definition of Philippine territory is including historical right and legal title. When the Philippine government in 1987, after the People Power Revolution, took away that clause, they have removed whatever legal basis they use. Historical title would refer to the Sulu-Overbeck Treaty, Sulu-Overbeck Grant. Therefore, in 1987, the Philippine government have removed their own legal basis to claim any territory, including Sabah and North Borneo, by virtue of historical right or legal title. Now, this to me, Dr. Cairo, ladies and gentlemen, are some of the missing pieces that are available to the government, that I have spoken personally many times, but not taken up, that I don't understand. Allow me to conclude, ladies and gentlemen. If you visit our museum, members of the media alerted me, we only talk about British era and Malaysian era in our museum. We don't talk about the Brunei era and before the Brunei era. I hope the government will pay some attention to this, put more of our history going before British, before Malaysia. Going back to the Brunei era, nowhere in our historical timeline shows that Sabah was ever under the Sulu. Thank you for allowing me to say a few words. Thank you.
Thank you very much, Datuk, for your brief talk. Just to summarize, what he said was the Sulu Sultanate can't take what it doesn't have. Okay, I'm allowed to ask 2 or 3 questions. Anybody from the floor? Okay, I give chance to somebody I see back there. Encik Neil Daud, a lawyer. Munira, lepas ni lah. Okay, I promise Munira second.
Right. Good afternoon. Just a very short question. Tan Sri Datuk Panglima Pandikar mentioned nip it in the bud the Sabah claim. So can I ask the panelists how to do so, when to do so? Is it possible? I didn't ask why. Okay, and the second part of it, would you agree this so-called Sabah claim is perhaps a prelude to an act of war again? Thank you.
Okay, thanks. Maybe Datuk Yong, because you only had 6 minutes or 9 minutes. Yeah, maybe you can answer the question. Can repeat the question? Is an act of war? Can repeat the question? The last question.
Yeah, last question is the so-called Sabah claim is perhaps a prelude to an act of war again?
I don't think it will lead to an act of war. You talk about a war between two countries. I don't think it will lead to an act of war. ASEAN is still a very strong organization. Yeah.
Yeah.
Tan Sri Anifa will say better on this.
Yeah, but how about Lahadatu 2.0? Not a country attack, but from a group?
Deterrent. Having a strong ISCOM will be a strong deterrence against any violent incursion from any neighboring countries. So I repeat what I said just now. To avoid war, the best defense is to prepare for war. That's the old axiom. We have to strengthen our own security, especially through ESCOM.
Okay, thanks Datuk Yong. YB Munira from MP of Kota Bulut.
Good afternoon. First and foremost, I would like to thank Yang Berhormat Datuk Sri Azalina Osman for taking this case and succeeding. Nombor dua, saya percaya kalau yang berbahagia Tan Sri Speaker masih Dewan Rakyat, masih Speaker Dewan Rakyat waktu itu, saya tidak akan dihalau keluar, for standing my patriotism, defending Sabah. You would definitely allow this agenda to be debated in Parliament, sebab apa yang kebanyakan Tan Sri Speaker sudah cakap juga saya pernah cakap dalam Parlimen. Yang ketiga, I do understand the ASEAN protocol's consensus, but by them, the senatorial candidates, debating about Sulu claim, claims over Sabah is already against keharmonian pada saya amongst the ASEAN countries. So in every Philippines general election since the Republic Act, tadi Tan Sri ada sebut tentang Republic Act ng Filipinas 5446, juga saya pernah sebut dalam Parlimen, was amended to include Sabah as their territory. This claim over Sabah has been the main topic. Ya, setiap kali presidential election, diorang akan sebut perkara ini to gain undi, to gain votes lah. So knowing their persistence, we should have the boldness. Kita juga perlu ada rasa berani untuk bagi tahu diorang, if you are persistent, kita lagi persistent daripada diorang. Dan pada saya hari ini saya bercakap bukan saja kepada panelis, saya juga mau bercakap benda ini kepada kementerian. BHEUU ada di sini, bahagian hal ehwal undang-undang, supaya kita kasih, ini kata-kata saya dalam Parlimen hari itu, kita hadapi dan muktamadkan. So saya juga ingin balik reiterate apa yang Tan Sri Speaker cadangkan tadi, and I think this is very important. Why don't we initiate government to government asking Bongbong Marcos to drop and cancel what his father signed in 1968, Republic Act ng Filipinas 5446. Jadi I think it is very important for us today sebab we see this coming. So jadikanlah Sulu case ini sebagai satu case, precedent case dalam mana-mana saja teritori nanti besok diklaim. Macam contoh Ambalat, we see this coming. So jadikanlah benda ini, we should never underestimate the claimants, be it Sulu kah, apalagi kalau our neighboring country. Terima kasih.
Okay, I think it was not a question, kan? So we go
Yeah,
for,
I mean, yeah.
Yeah. Okay, maybe third question, third and final, kah? Third and final, ada? Okay, I see Dr. Richard Barrow. Kau got another one? Oh, cukup sudah.
Thank you very much, speakers, and thank you for your talks. Especially, the question had in my mind, why in all this time are the 4 agreements with Brunei completely ignored, and they were made 3 weeks before the agreement with Sulu? I mean, why has it been ignored all this time? That's my question.
Okay. Okay, you want? Okay, Datuk Yong will answer.
I already mentioned that the Brunei overback grant shows that possession, control of over North Borneo had already passed from Brunei to overback and thereby the British. So there was never a Sulu law. So this is my point just now, that our authorities should take up that 29 December 1877 list. This is one of the important missing pieces. I'm using your heading, buddy, why I'm here, talking about missing pieces. But before I conclude, actually, my view is that once and for all, get the Philippines government to set up a consulate here in Sabah. That will once and for all, under international law, under Philippine law, means that Philippines or any part of the Philippines have no more claim whatsoever over Sabah, Malaysia. This will be my final message. It was the last message that the Malaysian government must work very hard, put it number 1 in the agenda. Every time there is a meeting between Malaysia and the Philippines, we want a consulate. Put it top of the agenda. Yang lain-lain AOB. Ini dulu. Nancy Hanifah, maybe you can give some advice to the new ministers. Thank you.
Okay. Okay, cukup sudah kan soalan? Okay. I hope we have helped the audience to discover some of the missing puzzle pieces. And can we give a round of applause to the panelists for their awesome and what? Yeah. Okay. Sekian, terima kasih. All the best. Oh yeah. Should I announce lunch? Most important part of the session.
Thank you. Ladies and gentlemen, another round of applause for our great panelists and moderator. We request the members of the panel to remain on stage, please. And I'd like to invite Yang Berbahagia Datuk Sri Khairul Zaimi bin Daud to present a token of appreciation to the panelists and moderator on behalf of the organizers. With that, we would like to invite our panelists on stage for the second session. Our moderator, Mr. Roger Chin Ken Fong, President of the Sabah Law Society and partner in Messrs. Chin Lau, Wong and Fu. Joining him on stage, our esteemed panel. Yang Berbahagia Datuk Firoz Hussein bin Ahmad Jamaluddin, partner at Messrs. Firoz Julian. Joining us virtually, Professor Robert Volterra, partner at Volterra Theatre and the visiting professor of international law at the University College of London and the University of London. Mr. Alvaro Lopez de Argamedo, partner at Uria Menendez. Mr. Chan Leng Sun, SC, senior counsel and chartered arbitrator out of Duxton Hill Chambers. Ladies and gentlemen, please give our panel a round of applause. Thank you.
Test.
Good afternoon, everyone. Thank you for still being here in the afternoon. It's never easy. I hope you were fed very well. And we are moving on to a very important topic, which is very little understood, which is time to preserve sovereign immunity. A lot of you would have asked about how is it possible for Malaysia in this Sulu award case to be attacked, challenged, when Malaysia is a country, a sovereign country. This is a very not that easy to understand topic, but we are very fortunate because we have 4 very, very esteemed speakers. What you see here is just the 2 of us. The other 2 are online. Thank you very much for joining us, Alvaro, Leng Sun, and Robert. Yes, Robert. Our distinguished speakers are basically people who have been involved in the case at various stages of the time. In fact, Alvaro has been involved with the case right at the start. He is Malaysia's lawyer in the Spanish arbitration where it all started. So any of you who have burning questions that you would like to ask about what happened in Spain, why are we here, you can please do feel free to ask them. So without further ado, let me proceed to introduce you our first speaker, which is Mr. Alvaro. Mr. Alvaro has been a partner of Uria Menendez since 2003. He focuses his practice on international arbitration and domestic and international civil litigation. He is an arbitrator at the Madrid Arbitration Court, the Madrid Bar Association Arbitration Court, the Spanish Court of Arbitration, the Civil and Commercial Arbitration Court, and the Center of Arbitration of the Lima Chamber of Commerce. He is currently court member of the London Court of International Arbitration and president of the steering committee of the UIA, Union Internationale des Avocats Arbitration Commission. He is also vice president of the Spanish and Iberico-American Arbitration Club, president of its Dispute Boards Commission, and sits on its mediation committee. Alvaro is a CEDR accredited mediator, member of the Registry on Mediators, and Mediation Institute of the Ministry of Justice and academic coordinator of the FIDE Mediation Club. Alvaro was an officer of the IBA Arbitration Committee from 2017 to 2019 and acted as chair of the Arbitration Guidelines and Rules Subcommittee and co-chair of the IBA Task Force for the revision of the IBA rules on the taking of evidence in international arbitration. And as mentioned previously, Alvaro was right with us at ground zero when all of this happened in Spain. So without wasting any more time, Over to you, Alvaro.
Yes, I don't know if you hear me, Roger.
Perfectly. Welcome. Welcome to Sabah.
Okay, thank you very much, Roger. Thank you for your very kind presentation. Well, many thanks to the government of Malaysia, represented by the Honorable Minister of Law and Institutional Reform, to the Chief Minister of Sabah, to the ASEAN International Arbitration Center, to all the organizers, and to all the attendants for giving me this opportunity to share with you my views on this unprecedented Sulu case. I will share with you the screen, so I can start presenting this. I think I can take the control of the screen if possible, Roger. Let me see. Okay, I hope you all are able to see the screen. No? So the purpose of this presentation is to explain how Malaysia's sovereignty has been impacted by the Sulu case. And I will do it going through these three different concepts: procedural safeguards for jurisdictional immunity, the Sulu dispute and Malaysia's sovereignty, and immunity from execution. And so I will explain how from the beginning of the case to the present situation, Malaysia's sovereignty has been breached. And in order to do that, I would like to first explain the main, this timeline of the case, which is essential to understand what happened. The case, as you probably know, started on February 1st, 2018, when the Zuluers requested the appointment of an arbitrator to the Madrid High Court. The reason why they went to the Madrid High Court is because they said that the north of Borneo belonged to the Spanish Empire. This is simply not true. The north of Borneo was never part of Spain. But the High Court of Madrid admitted the claim to proceed, and Malaysia, and this is a key aspect of the case, was not properly served. So Malaysia did not have the opportunity to appear in the proceedings, and therefore they continued in default. And on March the 29th, 2019, the High Court of Madrid appointed Mr. Sampa as sole arbitrator. Following that, Mr. Sampa started the arbitration proceedings and rendered a partial award on jurisdiction on May the 25th, 2020, basically upholding its jurisdiction. On March the 9th, 2021, Malaysia filed a motion for nullification of the appointment and of all the subsequent decisions after the appointment of Mr. Sampa, precisely on the basis that it had been improperly served. And this motion for annulment was upheld by the High Court of Madrid on June the 29th, 2021. The key point with this decision is that all the actions and decisions taken by the so-called arbitrator were null and void because he was not an arbitrator as a consequence of the annulment of his appointment. So following with this timeline, proceedings for the appointment of the arbitrator restarted from scratch as a consequence of the annulment motion. And this is another key point of the case. In September 2021, the Zuluers filed with the court the summons with this corresponding translation so Malaysia could be properly served. This is key because it implies that the Zuluers accepted the nullification of the appointment and accepted that all the decisions of the arbitrator from the nullification were null and void because he was not an arbitrator. So in November 2021, Malaysia was properly served, and on January the 7th, 2022, Malaysia filed an international motion challenging the jurisdiction of Spanish courts, precisely on the basis that they had no connection whatsoever with the case, and also Malaysia invoked its sovereign immunity, which had not been respected up to this time. And 4 days later, when the Sulu heirs had the opportunity to review Malaysians' motion, decided to withdraw the appointment proceedings. This is another key aspect of the case. And they decided to withdraw the appointment proceedings because they had already obtained the recognition of the partial award in France. And on the basis of that recognition, they requested the arbitrator to change the seat from Madrid to Paris. And the so-called arbitrator decided to change the seat. Here you have the annulment order of June the 29th, in which you can read that all the subsequent procedural decisions of the case were null and void, and consequently all the decisions taken by the arbitrator. But the Sulu heirs, in spite of having withdrawn their petition for appointment, went to the Spanish Constitutional Court. They filed an extraordinary appeal against the annulment decision, which was rejected by the Spanish Constitutional Court. And it was rejected because the Constitutional Court said that they had no legitimate interest, as there was nothing to protect or to appeal, because they had decided to withdraw from the appointment proceedings. So, as I already said, all the decisions taken by the arbitrator as a consequence of the annulment of his appointment are null and void, including the partial award and, of course, the final award. And this has been very recently recognized by the Court of Appeal of The Hague in the judgment of June the 27th, in which you can read the final arbitral award he rendered is not an arbitral award eligible for recognition and enforcement in the Netherlands, simply because it's an award rendered by a non-arbitrator, and therefore it cannot be classified as an award. So what really happened? What happened is that the method of service used by the Sulu heirs was that the summons was sent to the Spanish Ministry of Foreign Affairs, which in turn delivered them at the Malaysian embassy in Spain. But this way of service is totally incorrect under Section 27 of the Spanish International Judicial Cooperation in Civil Matters, and also under Section 54 of the Spanish Jurisdictional Immunity Act, because the process is that the summons should be sent to the Spanish Ministry of Foreign Affairs, which in turn should send it to the Spanish Embassy in Malaysia, which should deliver the summons to the Malaysian Ministry of Foreign Affairs. This is the right process, and this was incorrectly made by the Sulu heirs, and this is the reason for the nullification of the appointment proceedings, and particularly of the appointment decision. And the rationale under this process is Article 22 of the Vienna Convention of 1961, which says, you have the article there, the premises of the mission shall be inviolable. Therefore, service cannot be carried out at the embassy or even at the door of the embassy. And this has been consistently recognized by the Madrid High Court and also by other courts around the world. Here you have two decisions of the Madrid High Court. One refers to the Republic of Equatorial Guinea, in which the summons was nullified precisely because they were delivered at the embassy. And a more recent case in which our firm participated, defending the Arab Republic of Egypt, in which a similar situation happened. The summons was recognition and enforcement proceedings of an award and the summons were delivered at the embassy, and as a consequence, the High Court of Madrid decided to nullify the whole proceedings since the improper service of the summons. But it is not only that the High Court of Madrid has already consistently established this doctrine, but here you have also two decisions, one from the House of Lords of the United Kingdom, in which service was considered illegal, in this case regarding the Republic of Iraq, because it was made at the embassy, and also the US Supreme Court found that a foreign state should not be served at its embassy, and therefore nullified also the service. So, as you can see from the beginning, from scratch, there was a breach of the jurisdictional immunity of Malaysia, and as a consequence, judgment appointing Mr. Sabah could have been never rendered in accordance with Section 55 of the Spanish Jurisdictional Immunity Act, that says that the Spanish courts shall not render default judgments against a foreign state unless the following conditions have been met: service requirements have been complied with, which is, as you can understand, not the case at all. Now, I would like to explain that Malaysia, as soon as it was able to appear in the proceedings, once service was properly made, was able to invoke its sovereign immunity in that motion for lack of jurisdiction of the Spanish courts that I mentioned. And there you have what we argue. There is no exception that would permit the returning of Malaysian jurisdictional immunity before the Spanish courts. So, as you can see, during the first phase of the proceedings, right at the start, the sovereignty of Malaysia was breached, and fortunately this was corrected by the nullification of the appointment decision. I would like now to move to the next step, and how Malaysia's sovereignty has been also breached, in this case, during some arbitration proceedings. And for that purpose, I think it is important to make a very brief reference to the 1878 agreement. Here you have a photograph of the agreement. Probably you haven't seen it before. And as you know, this was an agreement executed between the then Sultan of Sulu and messengers von Overbeck and Dent. In the position of Overbeck and Dent, then they were substituted by first the North Borneo Company, then by the United Kingdom in 1946, and finally, upon its independence, by Malaysia. And it's important to note that by virtue of this agreement, the Sultan ceded in perpetuity certain lands in the north of Borneo, and also the Sultan gave Mr. Overbeck full sovereign powers, like power of life and death over the inhabitants, power to make laws and to count money, to raise and maintain soldiers, and to impose taxes. So clearly sovereign powers. And in exchange for this, the Sultan received 5,000 ringgits per annum, and then it was updated through a confirmatory deed in 1903 to 5,300. So the point is, and this is a key point, or was a key discussion in the arbitration, is in which I must say Malaysia never participated, because it never recognized that this arbitration could proceed. Well, the point is that the discussion is if the 1878 treaty was a lease agreement, as the claimants sustain, or if it was, as Malaysia always have considered, a cession of lands and sovereign powers. And I think we all can understand that it's not possible to admit that we have a lease agreement when the lease agreement involves the cession of sovereign power. Simply, this is totally inconsistent. However, the arbitrator, in some award decided that it was a lease agreement, that it has to be terminated, and that as a consequence, the natural consequence of the termination of the lease agreement is restitution of the lands which were the object of the agreement. However, he said that as restitution was not possible, because obviously Malaysia was exercising its sovereignty over those territories, restitution should be made in kind. And in kind means that an amount equivalent to the value of the natural resources over those territories should be paid by Malaysia to the claimants. And this amount is the 1492 billion. This, again, is a breach of Malaysia's sovereignty, because sovereignty or the income of the natural resources is part of the sovereignty of the state, or the value of these natural resources. And this was recognized by the decision of the Court of Appeal of France, in which it ordered the stay of the enforcement of the final arbitral award. I must say that this decision is unprecedented. There are very, very few cases in which the courts of France have ordered the state of enforcement of an award. And here you can see in the decision how the French court says that natural resources are an attribute of the sovereignty of the state. And in the next paragraph, that as the restitution in kind is calculated on the basis of the resources over which Malaysia exercises its sovereignty, this is again a breach on Malaysia of Malaysian sovereignty. So this is the second breach of Malaysian sovereignty. And I would like now to briefly refer to the third one, immunity from execution. What happened, well, first of all, I would like to just to briefly mention that, as you know, those assets which are used by the state to exercise acts of jure imperii are protected by immunity from execution. They cannot be attached to the payment of amounts owed by the state. This is recognized by the UN Convention on Jurisdictional Immunities of the States, which, although not enforced, it's a clear orientation usually followed by courts and states. And in this convention, the following assets are protected by immunity from execution: property used for diplomatic and consular purposes, military property, central bank accounts, property forming part of the cultural heritage of the state, and also scientific, cultural, and historical objects used in exhibitions. And specifically with respect to diplomatic premises, they enjoy the so-called inviolability of diplomatic premises in accordance with Article 22 of the Vienna Convention. Well, in this case, Malaysia's sovereignty was also breached, and in particular the immunity from execution, because on October 31st, 2022, the Sulu heirs, in order to obtain payment of the cost of the partial award granted by the so-called arbitrator or by the purported arbitrator, register a statutory mortgage on 3 real estate properties, which are premises of the Malaysian embassy in Paris and premises used for residences of the embassy staff. Malaysia has challenged this statutory mortgage, and on the basis precisely of diplomatic immunity and immunity from execution. And the good news is that this statutory mortgage is going to be lifted immediately as a consequence of the 6th of June decision, by virtue of which the Court of Appeal of Paris decided to revoke the recognition of the partial award, and in which it established that there is not a valid arbitration clause in the 1878 agreement. So, as you can see, Malaysian sovereignty has been breached and seriously impacted in these three stages of the proceedings. And to conclude, I would like to mention that we expect that all these breaches of Malaysian sovereignty will be completely restored by 2024 after the European courts have upheld all Malaysians' petitions. We expect that this will happen during the rest of 2023 and 2024, and we are absolutely confident that Malaysia will prevail in the end, basically because Malaysia is right. So thank you very much, and I hope this was understandable. Thank you.
Thank you very much, Alvaro, and thank you for the excellent job you're doing for Malaysia. And please do keep it up. And we expect nothing less than a complete, total, utter win. So thank you. Closer to home, we have Dato' Firoz. We were just saying that it's a very cozy affair here, just the two of us. The rest of us being online. But thank you. One day, all of you should be in beautiful Sabah. And of course, you're all very welcome. Dato' Firoz is currently a senior partner at Firoz Julian. He has been actively in practice for over 28 years and has appeared before various courts and arbitral tribunals, including the International Court of Justice and the Federal Court on behalf of clients, specializing in corporate and commercial litigation, construction and public law. He has advised on major corporate and commercial cases across Malaysia, represented both foreign and local clients for individuals and corporations in a variety of litigation and disputes. Dato' Firoz was called to the English bar in 1991. In 1995, he returned to Malaysia and joined Screen & Company. He was then a partner at Puttacheri, Firoz and Mai for 11 years, specializing in commercial litigation and counsel for several major litigation cases. He then joined Hafarism, One and Aisha Mubarak for 6 years, focusing on counsel work in company, commercial, construction, and political litigation. He joined Zaid Ibrahim & Co. in 2016 to head the litigation department. Together with his partners and team, Dato' Firoz formed Firoz Julian in 2022. Over to you, my dear friend.
Thank you. Thank you very much, Roger. Assalamu alaikum and good afternoon. Dato', tuan-tuan dan puan-puan yang dihormati sekalian, ladies and gentlemen. Thank you very much for attending this talk this afternoon. It is my pleasure to address a very, very specialized and specific topic this afternoon, and I hope it's not too boring, but it concerns a very interesting issue, and that is the relationship between the Sulu arbitral proceedings and the role of customary international law. Now, I think Alvaro was very kind in going through the whole history of the dispute and essentially what happened. So I will probably skip my part of it, but if you look at the slide on the left, that is an old map of what was at one time claimed to be the Sulu Sultanate. And carrying on, we have now the infamous 1878 agreement, which, unlike some, I say is not binding on us, and there has to be a proper historical assessment, including the agreements with Brunei, which were before the 1878 agreement, but that is for another day. The other important issue that emerged was that there was an incursion which occurred in 2013, a very, very deadly incursion. And as a result of that, these payments which Alvaro mentioned, which were, in my view, on an ex gratia basis, were halted. And that ultimately resulted in the arbitration that we have, where we have an arbitration that was heard by a single arbitrator in Spain, Dr. Stampa, who acted in rather extraordinary ways in that he transferred the seat of arbitration from Madrid to Paris, and finally gave an unprecedented award of 14.9 billion against Malaysia. Now, I will come back to the more specific topic, and that is the issue of sovereign immunity. What is sovereign immunity? Sovereign immunity is an ancient doctrine. It comes from almost Roman times. It originates from a principle which is called par in parem, non habet imperium, which when translated means that equals have no sovereignty over each other. Taken very simply, that is the basis on which states and international law function, that all countries are equal. Therefore, one should not be able to subject states in the courts, the domestic courts, or even arbitral tribunals of another country, unless there are specific exceptions to the generally accepted rule of sovereign immunity. So there was that idea of the equality of states is reflected in the UN Charter. If we look at Article 2 of Article 2 of the UN Charter, which provides the organization and its members, in pursuit of the purposes stated in Article 1, shall act in accordance with the following principles. Paragraph 1, the organization is based on the principle of the sovereign equality of all members. Now, why do I draw your attention to this? Is because the International Court of Justice has considered this issue. The International Court of Justice is a court formed under the auspices of the United Nations. And in 2012, there was a case involving Germany and Italy. And as I've reproduced the excerpt from the case, where it stated, the court considers that the rule of state immunity occupies an important place in international law and international relations. It derives from the principle of sovereign equality of states, which, as Article 2, Paragraph 1 of the Charter of the United Nations makes clear, is one of the fundamental principles of the international legal order. So let's focus on this fact. One of the fundamental principles of the international legal order is sovereign immunity. Now, how was Malaysia's sovereign immunity infringed? Basically, if one looks at it in depth, the issue of sovereign immunity has now, over the course of time, been defined as a matter of international law. So, if we look at the decision of the International Court of Justice in the case of Germany versus Italy, the part which I reproduced, which at paragraph 53, if I may just read. However, the court is not called upon to decide whether these acts were illegal, a point which is not contested. The question for the court is whether or not, in proceedings regarding claims for compensation arising out of those acts, the Italian courts were obliged to accord Germany immunity. In that context, the court notes that there is a considerable measure of agreement between the parties regarding the applicable law. In particular, both parties agree that immunity is governed by international law and is not a matter of comity. So I think we have to draw what is happening in the Sulu dispute on a more global level. What is being sought, the enforcement that is being sought in France, Netherlands, and Luxembourg, is also an issue of international law. It's not purely a question which is limited to arbitration. Because what is happening in the courts is that an arbitration award rendered by a commercial arbitrator is being enforced by the national courts of a country. Therefore, the question arises, can they do this? Can they do this when the subject matter of what they seek enforcement of is covered by sovereign immunity? Because it is generally accepted under international law that states have sovereign immunity in respect of sovereign functions, as opposed to pure commercial transactions. This was laid down in the different court decisions. For example, there was a case of the House of Lords in the United Kingdom called Trentex against the government of Nigeria, where the issue here was the House of Lords held that sovereign immunity did not apply in a pure commercial transaction. But the award that we have here, given by Dr. Stampa, relates to the sovereignty of Sabah. This is not a commercial lease agreement. This is about the totality of the natural resources of Sabah. The award for 49.9 billion is not just a figure which is contained in the agreement or that can be worked out from the agreement. It represents what the arbitrator considered as being the wealth, the sovereign wealth of Sabah. Therefore, to make such a claim and to enforce such a claim, in my view, was an infringement of sovereign immunity. As time has gone on, there have been different kinds of sovereign immunity evolving. First of all, we have to look at the distinction between the exercise of adjudicatory jurisdiction, that is the decision to adjudicate a dispute. And the second part is the exercise of enforcement jurisdiction. Now, these are two technical points, but what we have in relation to the enforcement award is the enforcement of, is the exercise of enforcement measures, the second type of infringement of sovereign immunity. Certain countries currently have absolute sovereign immunity. For example, China. You cannot sue another foreign state in China. They adopt the absolute sovereign immunity approach. Other countries like Malaysia, the United Kingdom, Singapore, for example, the Commonwealth countries, adopt what they call restrictive sovereign immunity, where in that system you can sue, but it has to be a purely commercial transaction. The courts, and particularly the International Court of Justice, has sought to define the distinction between commercial and also sovereign acts. And I think I will just refer you very, very quickly because this is very technical. And this is from the judgment of Germany against Italy, where they recognize the distinction between what they term as an act jure gestionis, that's where a state embarks on a commercial transaction, and an act which is jure imperii, where a state performs sovereign functions. And they spelt out the distinction in the following terms. At paragraph 59, The parties also differ as to the scope and extent of the rule of state immunity. In that context, the court notes that many states, including both Germany and Italy, now distinguish between acta iure gestionis, in respect of which they have limited the immunity which they claim for themselves and which they accord to others, and acta iure imperii. At paragraph 60, the court considers that the terms iure imperii and iure gestionis do not imply that the acts in question are lawful, but refer to whether the acts in question fall to be assessed by reference to the law governing the exercise of sovereign power, or the law concerning non-sovereign activities of a state, especially private and commercial activities. Now, in relation to the ownership of Sabah, it is my view that it cannot be said to be a private and commercial activity. The ownership of Sabah by its people and as being part of Malaysia, and the exercise of the right to self-determination is effectively the exercise of sovereign power. Therefore, such an act cannot be the subject of a commercial private arbitration. That was a fundamental wrong which was committed by the arbitrator. He should have identified the subject as being a subject that was non-arbitrable because of the very sovereign nature of what was being sought after. And that argument has been now taken by Malaysia. It can be found in the latest judgment given by the Dutch courts, the courts in The Hague in the Netherlands, the Court of Appeal in the Netherlands. I've reproduced it up there. I'll just read it to you. The final arbitral award leads to the determination of legal consequences that are not at the discretion of the parties. Article 5, paragraph 2, sub A of the New York Convention. The nature of the agreement makes it clear that the dispute, contrary to what the arbitrator assumed, does indeed concern sovereignty issues. The final arbitration award establishes that not Malaysia, but the Philippine citizens are entitled to the proceeds of the natural resources of the Malaysian territory, and thus violates Malaysian sovereignty. This determination cannot be made in an arbitration because it must have erga omnes effect. So this is a very, very important part of the Dutch judgment, that this subject matter is an infringement of the sovereignty of Malaysia. So within this, I think one can also see that the paragraph which was cited of the New York Convention, which we put up here, and that is Article 5, creates a mechanism at the enforcement stage to prevent the enforcement and recognition and enforcement of awards that infringe sovereignty, because they are considered as being the subject matter of the difference is not capable of settlement by arbitration under the law of that country, or B, the recognition or enforcement of the award would be contrary to the public policy of that country. So this emphasizes and stresses the point that even the New York Convention itself has a built-in mechanism to exclude enforcement of awards which are not arbitrable. So coming back, and in summary to what I would like to say is that all nation states have an obligation. They have an obligation not to enforce an award in their domestic courts which infringe Malaysia's sovereignty. Because if they do so, then it would be a breach of public international law, and it would entitle Malaysia to take the appropriate remedies it can at either the International Court of Justice or any other international legal forum. Thank you very much. If there are any questions, I'd be happy to addressing. Thank you.
Thank you so much, Dr. Firoz, for making something so difficult simple enough for everyone to understand. And that is an amazing feat in itself. The next speaker we have is Robert Volterra. Robert is a very prominent lawyer in the world, and he has been involved in some of Malaysia's cases in the past, and he has represented and does represent Malaysia in cases. Robert Volterra is partner at Volterra Fietta, visiting professor of law at University College London, visiting senior lecturer at King's College London, Canadian barrister and English solicitor advocate. Professor Volterra advises and represents governments, international organizations, and private clients on the full spectrum of public international law and international dispute resolution issues. He acts as counsel and advocate in international disputes around the world, including cases before the International Court of Justice, the Permanent Court of Arbitration Tribunals, investor state arbitration tribunals, and commercial arbitrations. Professor Volterra's cases, both as counsel and arbitrator, are amongst the most widely known international disputes. They are taught in classrooms around the world and relied upon as precedents by other lawyers, courts, and tribunals. Professor Volterra is acknowledged for having exposed the forged documents submitted by Qatar to the International Court of Justice in the case of Qatar versus Bahrain case. He has been instrumental in exposing the fraudulent activities of parties in the international litigation proceedings, including in a number of cases before the International Court of Justice, Permanent Court of Arbitration Proceedings, ICSID arbitrations, domestic courts in various jurisdictions, and other international fora. The global legal directives have ranked Professor Volterra and his practice consistently in the top tier since they began ranking practices more than 25 years ago. In their 2022 editions, Chambers and Partners stated, Robert Volterra is probably the best public international lawyer on the planet. And Legal 500 stated, Robert Volterra is the best public international lawyer around. And with that, Robert, I hope you are also the best speaker today. Over to you, Robert.
Well, thank you so much, Roger, for your kind welcome. On that last point, I have no doubt that I will be the least interesting and exciting speaker today. I have been absolutely fascinated and enthralled by my friend Alvaro and my friend Dr. Firoz's presentations today, fantastic, and I have no doubt that my friend Leng Sung's presentation will be equally fantastic. Roger, I'm terribly sorry that I am not in Sabah today. When you and I met last in Kuala Lumpur, when I was there on work, you invited me, including for this conference, and I would have very much liked to have been there in person. I have been to Kota Kinabalu a number of times. I've climbed Mount Kinabalu, and Sabah is one of the most wonderful places in the world. It's absolutely magical, and I really do wish I could be there today. Unfortunately, I'm speaking from London. But thank you very much for your warm introduction, and also my thanks to the Asian International Arbitration Center and the Sabah Law Society and all the other organizers of this very important conference. I will start sharing my screen now, and I have a PowerPoint presentation that will guide me as I speak along today, and I will build on the presentations already made by Alvaro and Dr. Firoz. So, if I am able to do so, is someone able to confirm that my screen is sharing properly?
Yes, it's being shared.
Wonderful. Well, there we are. I have been asked to discuss 2 points today. One, the arbitrability of territorial sovereignty disputes vis-a-vis the so-called Sulu arbitration case. And secondly, the benefits flowing from the codification of domestic sovereign immunity legislation. So the first topic will build on what the previous speakers have said and look at territorial sovereignty as a matter of public international law and how it relates to the Sulu arbitration case. And the second topic, entirely different, we'll look at questions of having national legislation dealing with sovereign immunity as opposed to just having customary law or court-made law. So I will turn to the first topic now. Very simply, the concepts of title to territory in public international law revolve around three concepts. The first is territory itself, the second is sovereignty, and the third is jurisdiction. Territory is, of course, easy to understand. It's the part of the surface of the world. Sovereignty is, if you want, the soul of a state. Only states are actors in international law. There's some international organizations that also have capacity to act in international law, but only states have sovereignty. That is the essence under public international law of entities that are actors as opposed to being acted upon. Human beings, animals, companies are acted upon under public international law, just like, say, animals in domestic law, but only states are sovereign and only states are actors in international law, not individual human beings or companies or anything like that. And so only states can exercise jurisdiction under international law, which means only states can act formally and have rights and obligations under international law. And these three concepts are tied together in a triumvirate, if you will, because in order to have a state, in order to be a state under international law, an entity has to have control over territory, but it has to have control over territory as a sovereign entity. There you get the sovereign aspect. So it's different from an individual owning territory in a personal capacity, which may or may not be allowed under domestic law. Under international law, the only entities that can essentially own and control territory, if you will, are states. So in order to have a state and therefore sovereignty under international law, an entity has to have control over territory. And only if a state has control over territory can it exercise jurisdiction. That means pass laws, control people's life or death, control the natural resources of the territory in question. So the three concepts of territory, sovereignty, and jurisdiction are inexorably intertwined, and you cannot take one of these elements out of the equation and still have a state. And if you don't have a state under international law, you don't have an entity that can control territory. So there is a fundamental difference in international law between a state that controls territory and, for example, individual human beings that may own territory but under domestic legal systems. And that has nothing to do with international law and who owns territory under international law. Now, the reason this is important is that public international law, which has been referred to today by the two previous speakers, and I know will be referred to by the last speaker, international law is the law that governs relationships between countries, between states. You can think of the international community as being one of 193 states, plus some international organizations. It's a small community. Public international law regulates the rights and obligations of this small community, essentially of states. It does not regulate relationships between human beings as individuals or between companies or trust territories or universities. And so the international legal order is state-centric. it revolves around states. Public international law is about the law that regulates the community of nations. And that is very important because, as I mentioned in the first part of the presentation, states are entities that exercise jurisdiction in a sovereign capacity over territory. So territory is the basis, the foundation of the existence of statehood, and it is essential to the allocation of rights and obligations in the international legal order. So you can imagine that control over territory at the state-to-state level is a focus of public international law, and it's something that's of great interest to the community of nations. And so the allocation of title to territory and the determination of what has control and jurisdiction over what territory is a question of balance, stability, and order for the international system and the community of nations. Now, a lot of the work my law firm and I do revolves around territorial disputes, questions of boundaries, and so on. And I had the honor and pleasure to work for Malaysia and represent it in a number of boundary negotiations and international law cases and so on. And the disputes are always at a state-to-state level. They have to be, because only states under public international law can control territory. Only states can do the sorts of things that were described in the 1878 agreement that were allocated by the then Sultan of Sulu to the individuals who were the counterparties in the 1878 agreement. So this is part of the aspects of the state-centric character of public international law. Only states can have title to territory, and importantly, as a result of that, only states can control the resources in them. And this is very important and ties into the questions addressed by Datuk Firoz in his presentation about control over resources. Because one of the things that the courts in France and the Netherlands pointed out that were flawed in the so-called arbitration award of Mr. Stampa are that the arbitration award purports to deal with restitution, remuneration, and compensation for control over resources being taken from the heirs of the Sultan of Sulu, supposedly. But as those courts pointed out, this is not possible to adjudicate and arbitrate. This question cannot be one that is properly put to a commercial arbitration tribunal by a group of individuals, because only states can have title to territory and only states can control the resources in them. So the fundamental flaw in intellectual terms of the so-called Sulu Arbitration Award is that it inappropriately mixed concepts of public international law with commercial arbitration, and it is an intellectual fraud as well as a legal one. Territorial sovereignty disputes are necessarily state-to-state disputes. Individuals like you and I cannot make sovereign-type claims either to the territory itself or to the natural resources contained in those territories. Now, the peaceful resolution of disputes related to title to territory are always state-to-state, because only states can claim territory under public international law, and only states can claim to control and have benefit of the resources in territory under public international law. And thus, any territorial dispute can only be resolved between the relevant state parties. As has been mentioned earlier, there's no obligation to litigate or arbitrate in public international law on a state without that state's consent. That comes from issues of immunity and the independence and equality of states that the previous speakers have mentioned. Domestic commercial law, domestic commercial arbitration law, such as the one in Spain or the one in France, is incapable of regulating public international law sovereignty disputes, such as those over territory or their resources. So in conclusion, on this first point, the so-called Sulu arbitration violates public international law, and it is a legal impossibility because the arbitrator mixed a commercial claim with a public international law outcome by giving so-called compensation for the value of a control over natural resources in a territory that can only fall to a state. It's not possible for public international law concepts over sovereignty of a territory to be addressed legally between a state and non-state actors. Individuals, groups of individuals cannot be sovereign over territory and have control over natural resources. So the appertaining rights to territorial sovereignty are only capably being disputed between states. And the Philippine nationals and Dr. Stampa tried unilaterally to convert something that started off as a commercial arbitration into a public international law arbitration. And that is a violation of the principles of public international law, and it violated the different domestic legal orders as have been described by the previous speakers, and I believe the final speaker will also address. This leads me to speak to the second point of my presentation, which is the benefits flowing from the codification of domestic sovereign immunity legislation. What this means is, should a country pass a law that sets out clearly what its courts will recognize as being legitimate sovereign immunity claims by a state and claims by states to sovereign immunity that are not covered by that country's courts. And you had a wonderful disquisition by Dr. Firoz setting out what is sovereign immunity. So I will not spend very much time at all on the point. He covered it wonderfully. As he said, it's a foundational rule of international law, and it's based on the principle of sovereign equality. And in terms of legislation dealing with sovereign immunity, of course, this relates to essentially when a state is being sued in front of a foreign court. So, for example, when my country, Canada, is sued in Italian courts by Italian persons, for example. Canada, my country, would claim immunity from being sued in the courts. And the question for the Italian courts as a preliminary matter is, in the particular case, does Canada enjoy immunity for itself and its property from the jurisdiction of the Italian courts? And so this is an important principle because no country is above any other country, and so no country's courts can necessarily, as a starting principle, adjudicate on sovereign aspects of another state. So Dr. Firoz, of course, was much more eloquent than me and expanded on this point. I will just now look at the historical evolution of immunity. The international community before the Second World War almost universally recognized what's called absolute immunity. And as Dr. Firoz had pointed out, there's some countries still today that follow the principle of absolute immunity. But after the Second World War, states became increasingly involved in commercial activities, international trade, and so on, and began acting in ways that were understood to be not entirely sovereign. They weren't pure sovereign activities like taxation and enforcing criminal law and that sort of thing. They were more commercial, entering into contracts, buying and selling goods. In 1952, the acting U.S. Attorney General at the time, Mr. Tate, received a letter from the United States State Department, their equivalent of the foreign ministry of different countries, setting out the understanding of the United States that the world had developed and that countries were becoming increasingly engaged in commercial activities of a non-sovereign nature, and therefore that there should be a recognition in terms of sovereign immunity in domestic courts that states sometimes act as a sovereign and sometimes act as an ordinary person engaged in commercial activities. And states began picking up this principle that had been enunciated by the United States, and now the overwhelming majority of the countries of the world have accepted for their own courts a concept of restricted sovereign immunity, i.e. not all states get to claim sovereign immunity all the time for all their actions. And Dr. Firoz explained the difference between sovereign activity and commercial activity as being an example of that. This has been reflected in a number of international treaties that deal with sovereign, diplomatic, and consular immunities. I set out a few of them here in this slide. And many states have passed laws setting out the scope precisely of what is restricted before their domestic courts in terms of foreign states claiming sovereign immunity. And you can see there's a number of countries. I've just given 4 examples here, and some of the legislation is quite recent. Japan's Act on the Civil Jurisdiction of Japan over foreign states, their equivalent of the State Immunity Act in the United Kingdom, is only a few years old. So the question arises, what is the position in Malaysia? Well, Malaysia does not have a Foreign Sovereign Immunity Act. It does not have legislation that clearly sets out and delineates what acts of a foreign state are sovereign and therefore cannot be subject to, for example, lawsuits in Malaysian courts. And on the other hand, what acts are not sovereign, perhaps commercial, and could be the subject of litigation before Malaysian courts. There are many benefits that come from codifying domestic sovereign immunity law into legislation. There are many benefits from this. One is that a state can control and clarify very clearly the sovereign immunities that other states enjoy within its own domestic courts. That does a favor to the foreign states because it reassures them where they have immunity and clarifies where they don't. This is a question of comity as well as law. Also, a state can limit any restrictions to sovereign immunity by way of government and governmental regulation and not just leave it to the judiciary, which is perhaps less clearly regulated by the needs of society and the democratic governance processes of a country like Malaysia. And finally, another benefit flowing from the codification of sovereign immunity in domestic legislation is that a state can encourage other states to comply with their legal obligations to treat it properly in terms of giving it sovereign immunity before their courts. And there are a number of countries in which concepts of sovereign immunity have been eroded and states are being sued in those foreign courts more and more in violation of public international law principles. And this is a concern, this phenomenon is a concern to many countries around the world. And the country in which I live in the United Kingdom, I live in London, and the United Kingdom in the last 5 years, the courts have veered far away from following the public international law accepted rules of sovereign immunity, and the British courts have, particularly the English courts, have allowed lawsuits against foreign states in situations that the United Kingdom itself would not like to be sued and has resisted being sued in other countries. And so having a mutuality or a reciprocal aspect to a domestic sovereign immunity law can ensure that a state is treated fairly overseas. So this brings me to the end of my presentation, and I thank you all for your time and attention.
Thank you so much, Robert. This is, you're getting a masterclass from a professor from university. So hopefully everyone enjoyed that talk, and I certainly did. Learned a lot from that. Leng Soon, thank you so much for waiting right to the end. Certainly not least, Leng Soon is a senior counsel of the Supreme Court of Singapore and a chartered arbitrator practicing with Duxton Hill Chambers. He is qualified in Malaysia, Singapore and England, having obtained his LLB from University of Malaya and his LLM from University of Cambridge. Leng Soon is a member of the Singapore International Arbitration Centre Court of Arbitration and the ICC Commission on Arbitration and ADR. He is formerly the Global Head of Arbitration of Baker McKenzie and President of the Singapore Institute of Arbitrators. He is the Deputy Chairman of the SGX Appeals Board. He has acted as counsel or arbitrator in arbitration seated in Asia, Europe, and USA. Leng Soon had also served as a legal officer of the United Nations Compensation Commission in Geneva. Leng Soon is the author of the book, Singapore Law on Arbitral Awards, and co-editor of Conflicts of Laws in Arbitration. He is recognized among the top lawyers worldwide by legal directories. Leng Soon, thank you very much.
Thank you very much, Roger. Para hadirin yang dihormati, selamat petang. And like Robert and Alvaro, I'm sorry that I cannot be in Sabah. I actually did climb Mount Kinabalu twice. The first was as a fresh graduate in the East and West Malaysia Bar Games. That time, somehow it was easier than when I climbed it again 2 decades later when I was older. It became much harder. But I couldn't make it to Sabah today, but I'm glad to join you online. Now, you have already heard from the experts what sovereign immunity is, and they've given a very good exposition that I do not need to add to. So I will not speak about sovereign immunity as such, and perhaps I should go into other related problems with the Sulu arbitration. And this topic would be one that goes to the process that have been undertaken. In particular, some people will refer to it as abuse of process. But abuse of process is a doctrine that has been developed in court, where the court has an inherent jurisdiction to prevent the abuse of its process from being used for ulterior purpose or in an improper manner. Court litigators are familiar with the doctrine. But does it apply in arbitration? Now, abuse of process is itself technically not a ground for setting aside an award under the anti-trial model law or for refusing enforcement under the New York Convention. However, there are certain wrongs comparable to abuse of process that could fall within the stipulated grounds for setting aside or refusing enforcement of an award, such as acting outside the scope of the arbitration agreement, if there was one in the first place, acting contrary to agreed procedures or breaches of natural justice. I do not have the inside knowledge that Alvaro and the legal teams for Malaysia have. At the Kuala Lumpur Colloquium in May 2023, I made some observations as a third-party outsider on what appears to be some egregious flaws in the Sulu arbitration and the final award. Perhaps I can run this through again for the colloquium in Sabah, because since then, as we know, there have been a couple of very positive decisions from the Paris Court of Appeal and the Hague Court of Appeal, and you can make some comparison with the findings they made with some of those observations that I had made in May 2023. So first of all, I said that in the first place, there was no arbitration agreement. There was a reference in case of dispute by the Sulu predecessors to the Consul General of Brunei as the office then existed. But is that an arbitration agreement? In my view, it's not. Secondly, Dr. Stamper was not the agreed neutral adjudicator or arbitrator. He is neither the UK Consul General for Borneo nor any successor to the office. Thirdly, Dr. Stamper's appointment was by the Madrid High Court. Well, in the first place, it's questionable whether there's a basis for Spain to appoint an arbitrator. The 1878 deed does not provide for Spain to appoint an arbitrator. Neither is Spain the state of arbitration, whether expressly or impliedly. And thanks to the good work of Alvaro and his colleagues in Spain, Dr. Stamper's appointment has been revoked by the Madrid High Court. This is a key development and cannot overestimate how important this development is, because it forms a key ground to challenge the arbitration and the award, as you shall see. Fourthly, Dr. Stamper's preliminary award of 2020, or the partial award of 2020, declared that Spain was the seat of arbitration and that Spanish law was the lex arbitrii. That being the case, he was completely inconsistent in refusing to recognize the decision of the Madrid Superior Court, annulling his appointment. By his own reasoning, the Madrid Court has supervisory jurisdiction over the arbitration. Fifth, once the Madrid Court had annulled his appointment, Dr. Stamper no longer had any authority recognized by any court or law to sit and adjudicate on the dispute between the Sulu claimants and his Malaysia. His authority is as fictitious as if he had self-proclaimed himself the new Consul General of Brunei. Sixth, Dr. Stamper's transfer of the seat from Madrid to Paris is unheard of. There is absolutely no legal doctrine that permits an arbitrator to transfer the seat of arbitration because, in his own words in the final award, he feared denial of justice in Madrid due to the unfavorable Madrid High Court decision. And seven, this is a ground that had been well explained by Alvaro, Robert, and Firoz, and that is Dr. Stamper went beyond making a finding on payment of a contractual sum of money. He declared the 1878 deed terminated and found that the Borneo territory reverted to the Sulu claimants, and Sulu claimants then became the landlord, and Malaysia became a tenant in effect. While he did not order a restitution of the territory, he ordered its monetary equivalent, and therefore he ordered compensation based on an exploitation of Sabah's natural resources, which, as my learned colleagues have already explained, this is a feature of state sovereignty. Now, as you will hear, some of these observations have also been made by the Paris and Hague Courts of Appeal. I will take a step back at this point to talk about those developments and put them in context. To understand the context of the Paris Court of Appeal decision on 6 June 2023 and the Hague Court of Appeal decision on 27 June 2023, that was just last week, we must understand the difference between two types of proceedings. The first type is to set aside an award. This can only be done in the legal seat or country where the award is made. Many countries have adopted the grounds for setting aside an award found in the ancestral model law on commercial arbitration. These grounds for setting aside an award in the ancestral model law are similar to the grounds for refusing enforcement of an award under the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. The other type of proceedings in challenging an award is to resist enforcement of an award. So this goes to enforcement and resisting enforcement. This is done in any country where the successful claimants seek to enforce an arbitration award against the assets of the losing party. Enforcement and refusal of enforcement in most countries are governed by the New York Convention. So just to recap and refresh your memory, Mr. Stamper had first issued a partial award in Madrid on 25 May 2020, finding that the so-called arbitration agreement is valid and he had jurisdiction over the dispute. On 29 September 2021, the President of the Paris Court of Justice granted an exequatur order declaring that this partial award is enforceable in France. So just remember, the partial award was one that was made in relation to his jurisdiction. He found he had jurisdiction, and in 2021, the Paris Court granted an exequatur order declaring that it was enforceable. On 8 February 2022, Mr. Stampa issued his final award, purportedly made in Paris, ordering Malaysia to pay close to USD 15 billion to the Sulu claimants. Now, in relation to this final award on 12 July 2022, the Paris Court of Appeal stayed the enforcement. Alvaro had also pointed out some of the grounds upon which the Paris Court of Appeal stayed the enforcement. Among them would be, one, the final award related to a geopolitical dispute between Philippines and Malaysia, and allowing it to proceed could lead to civil unrest. The second ground was, as you have heard, the final award described Malaysia as a lessee and the heirs as the owners of Sabah, impinging directly on the state's territorial integrity. And thirdly, again, as you have heard, the compensation ordered was the restitution value of the territory based on revenues from the exploitation of natural resources. So that was a decision to suspend enforcement. What about setting aside, which was the other type of proceedings? Now, Malaysia has also applied to set aside the final award. And I understand that this is pending before the Paris Court of Appeal. There's no decision yet. Now we come to the Paris Court of Appeal decision on 6 June 2023. What does it relate to? It relates to enforcement of the partial award, the first partial award on jurisdiction. As you have heard, the Court of Justice initially granted an exequatur order to allow enforcement. And the importance of the Paris Court of Appeal decision on 6 June 2023 was to annul the exequatur order for enforcement. In other words, the Paris Court of Appeal refused to enforce the partial award. And what the Paris Court of Appeal found was this. The Paris Court of Appeal found that the choice of the British Consul General in Borneo to hear a dispute constituted an intention to have recourse to arbitration. But since the disappearance of this office of the Consul General, the clause became inapplicable and null and void. Therefore, a new voluntary agreement between the parties was necessary, but since there was no such agreement, the clause became impossible to implement. And for this reason, Mr. Stampa could not validly declare himself competent to hear the claims by the Sulu claimants. And this is similar to the comments by many observers about how Mr. Stampa really had no standing to declare himself an arbitrator because his appointment by the Madrid Court had been revoked. And there was no agreement actually making him the arbitrator. Now we come to the Hague Court of Appeal decision. What was it about? The Hague Court of Appeal decision on 27 June also relates to enforcement, but enforcement of the final award. So basically, it related to whether the final award could be enforced in the Netherlands. And it should be noted that at the time of the oral hearing before the Hague Court of Appeal in April 2023, the Paris Court of Appeal had not yet rendered its decision refusing enforcement of the partial award. Therefore, the reasoning of the Hague Court of Appeal did not take into account the findings of the Paris Court of Appeal. In fact, on one important point, it differed from the Paris Court of Appeal. What are the grounds given by the Hague Court of Appeal in refusing enforcement of the final award. Yes, the happy news is that the Hague Court of Appeal refused enforcement of the final awards. So this is grounds. There are three. First, the appointment of Mr. Stampa as arbitrator had been reversed by the Spanish court that had appointed him. The effect of the Madrid Court of Appeal decision on 29 June 2021 is that the assignment of the case to Mr. Stampa had lapsed, and therefore he could not make an award. There was no award to be recognized and enforced within the meaning of arbitral awards in the New York Convention. Secondly, even if there was an arbitral award, it could not be recognized in Netherlands for two other reasons. One, the 1878 agreement did not contain an arbitration clause. So this is quite interesting. You see that on this ground, at least, the Hague Court of Appeal differed from the French Court of Appeal, because the French court held that there was intention to have an arbitration clause, except that the office of the Consul General was no longer available and Dr. Stampa was not the Consul General. But the Hague Court of Appeal challenged whether there was an arbitration clause in the first place. And with this, I agree with the Hague Court of Appeal. But what is very ironic is that how do you determine whether there is an arbitration agreement or whether there is a valid arbitration agreement? The irony is here. In accordance with the New York Convention, Article 6.1a, if the parties do not expressly choose the arbitration law of the arbitration agreement, then its validity would be determined by the law of the place where the award was made. And the putative law of the place where the award was made, the final award was made, was France, Paris. So the Hague Court of Appeal decided that French law would apply to determine whether there was a valid arbitration agreement. But then having done that, it just went on to analyze all the features of the clause and decided that there was no arbitration agreement in the first place. The reasons are, first, the word arbitration was not used. There was an asymmetrical or unilateral option to the Sulu predecessors to submit a dispute to the Consul General, but the Consul General could not be regarded as an independent third party because he represented the British government, which was the colonial government that approved the agreement with the Sulu predecessors. So there was no reference to a neutral third party in the sense that an arbitration would have to be. And furthermore, this office of the Consul General no longer existed. Now, on this basis, it's similar to the Paris Court of Appeal. And the third reason is that the French court had suspended enforcement of the final award in 2022. Now, you may recall just now when I spoke about the final award, there was suspension of the final award, although at this time there's still no final outcome on setting aside. But notwithstanding this, the Court of Appeal, Hague Court of Appeal found that this was a reason to refuse enforcement under Article 5.1e of the New York Convention. Article 5.1e of the New York Convention says that the enforcing court may refuse to enforce an arbitral award if it has not yet become binding on the parties or has been set aside or suspended by a competent authority of the country in which or under the law of which that award was made. So what's interesting here is that the Hague Court of Appeal held that, well, it wasn't obliged to refuse enforcement, but given the importance of the case and the exceptional cause of the arbitral proceedings, it decided that it should refuse enforcement on this ground, and it applied the reason of the enforcement having been stayed or refused in Paris. So of course, at this point in time, we do not have a setting aside yet, but if there is a setting aside of the final award in Paris, I think then that should put to rest a lot more of the attempts to enforce this final award around the world. And I should stop here. Thank you very much.
Thank you very much, Leng Soon. That was a very concise interpretation of what happened in Paris and Netherlands. So in the interest of time, I've been told by the organizers that I can only limit questions to 2. But maybe I can just start the first question to Leng Soon, actually. Leng Soon, what is the likely impact of the Paris Court of Appeal decision and the Dutch decision on the Sulu dispute in its entirety?
I think they would be very persuasive if you talk about strict legal principles. Whether the award would be enforced in other countries, apart from these 2, depends on the laws of those countries. But assuming that, well, we are applying New York Convention principles, the relevant provision would be what I have just cited, and which was cited by the Hague Court. And that is if the award had been suspended by a competent authority of the country in which that award was made. So it is, I think, very persuasive that the French court has state enforcement. It's better if it's set aside, as I mentioned, but even though staying enforcement is not the final word on it, I think courts around the world will see that the French courts have already taken a view on the arbitration proceedings and on the arbitral award. And this is reinforced by the Paris Court of Appeal decision on the partial award, finding that Dr. Stempa basically had no standing as an arbitrator because there's no existing arbitration agreement. I think that will be key. So, and given that the Hague Court of Appeal has given very strong reasoning for it, I think it will also be very persuasive to many other courts who are faced with this issue.
Thank you, Leng Soon. So, to everyone, all the members of the public, obviously, the recent victories for Malaysia bodes well for our defense in the Sulu claim. And for this, we have to thank, of course, the Malaysian government and the team of lawyers and experts who have done an excellent job. Okay, can I open it to the floor? Thank you. Okay, Dr. Barrow. Besides Dr. Barrow, anyone else? Okay, I see 2 questions. Can we start with Dr. Barrow?
Yes, thank you very much. I'd just like to express appreciation to all the speakers. Actually, hearing what has been said has given rise to a furtherance of my previous question. The question of the validity of the Sulu agreement in the first place, in view of the fact that the Sultan of Brunei had declared his sovereignty over the area, all of the area of the state of Sabah, then Sulu made an agreement 3 weeks later for part of that area. I question the sovereignty of Sulu, the Sultan of Sulu, to even come into an agreement. I'm questioning the agreement in the first place was not valid. That's what I'd like to...
Thank you, Doctor. I'll pass it to Dr. Firoz because I know he has views on this.
Hello. Yes. I agree, Dr. Barrow. I think the point that you made is a very valid one. And it also underscores the need for a proper narrative to be formulated as to the correct historical position. Because what you say is very, very true, that this region was probably during the course of history under the sovereignty of Brunei and not the Sultan of Sulu. And therefore the Brunei agreements, the earlier Brunei agreements would prevail. And those agreements provided for a cession of territory. So that is in accordance with our position that the sovereignty remains with Sabah and Malaysia. So you're absolutely right. I agree with you. But I think the others might have a different view. Maybe Alvaro may have a different view.
Alvaro, would you like to add on to this?
Well, basically what I think is that the sovereignty of Malaysia over Sabah comes from the principle of self-determination. So although the previous historical antecedents are important, I think that the reason to recognize Malaysian sovereignty is basically this of self-determination. What I can say is that there was not much discussion on the historical precedents between the different treaties in the area. Because it's true that sovereignty was being discussed, and also there were different treaties between the colonial powers. You know? So I agree with what has been said, but I think that the key point, as I said, is that the principle of self-determination should be applied here. And maybe Robert has also some views on this because he knows this field very well. Thank you.
Thank you. Robert, do you have anything to add to this?
Well, yes. I mean, of course, I agree with everything that Dr. Feroz and Alvaro have said. Looking around the world globally, what happened in relation to the 1878 agreement and this part of the world is not unusual. The European expansion and colonial activities over several centuries were messy, and they were trying the European powers to impose their concepts of law and order in parts of the world that did not have a history of the same sorts of ways to view things and people and territory and so on. And agreements of a quasi-sovereign nature between companies and local rulers and sovereigns were not unusual. They occurred everywhere around the world. And those agreements being transferred eventually to a clear sovereign state, like happened here in terms of eventually going to the United Kingdom and then eventually to Malaysia. Again, entirely normal in the course of history. As Alvaro said, one of the key factors in relation to Sabah is the self-determination exercised by the peoples of Sabah in the 1960s as recognized by the UN and so on. And so that is determinative in and of itself. But these sorts of agreements where countries or commercial enterprises acting as quasi-foreign ministries just tried to tidy up local claims as they saw it, were not unusual. And it wasn't unusual that a colonial power, for example, would come to multiple agreements with multiple rulers in an area just to resolve what they viewed as small problems, small claims, to make sure, as they saw it, that everyone was lined up the way they wanted to impose their view of the world. So these are not unusual things, and for the Philippine nationals to sort of pretend this was some strangely unique, unprecedented thing that happened in 1878, this quasi-sovereign agreement with businesses that then converted into sovereign agreements and then self-determination. This happened many places around the world, and it's not exceptional. What is exceptional is that the arbitrator, Mr. Stampa, tried to turn this into what we know today as the so-called award, which is entirely a violation of public international law principles.
Thank you, Robert. I can, as just a thought, we started out with history, and I'd like to think that's because history is very important. History is one of the reasons why we are here today. So without understanding history properly, we cannot appreciate the rights that we have today, or the lack of rights that we have today. And for that, we have to thank people like Dr. Yong Tet Lee for always pushing a narrative with historical backing and hopefully those in power and those in charge of Malaysia's case will take note of the history that has been presented to everybody. Amdi, okay, 1 second, standing up and waving at me. History that has been presented, and that we can use this for our future final resolution, if I can call it that, because this arbitration award will go, and when it goes, what has been said in the first session is this claim over Sabah is still left hanging, right? So we need to push for a final resolution. And how do we go about doing it? One of the main ways of doing this is obviously using history, and through history, ascertaining rights or lack of rights, and from that, hopefully come to some final conclusion to the claim over Sabah, which has been hanging over our heads for decades. Okay, actually, she put her hand up first, so I'll pass on to you. Sorry, I can't remember your name.
Hello. Hello, good afternoon.
Hi.
My name is Faisan.
Yes.
So a question to the panel. Under international law, what can Malaysia do to put a definitive end to this recurrent issue of this alleged Sulu claim?
All right.
That's my question.
Robert, I pass this to you because I spoke to you about this in Kuala Lumpur. So without revealing national secrets, please do share with us what do you think are the ways to go about putting a definitive end to this whole saga?
Well, there are a number of things that a country can do in a situation like this. Of course, nobody in the world can stop other people in the world from being envious or from wanting something that they have. If another country wants something that a country has, it's not possible to stop that desire. But there are things that countries can do to continually to reaffirm, for example, their sovereignty over territory. There's various kinds of laws that can be passed dealing with the administration of the territory. There can be things like exercises of self-determination, which happened in Sabah in the 1960s. There can be constant vigilance about attempts to encroach on that sovereignty. Indeed, I had the honor and pleasure of being appointed the lead counsel by Malaysia in its intervention in the South China Sea arbitration between the Philippines and China. The Philippines, in the first round of that arbitration, which was only between China and the Philippines, and it was a jurisdictional phase, the Philippines had submitted a number of documents and maps that had nothing to do with the South China Sea arbitration at all, but was an example of the Philippines trying to put on the records of an international arbitration and have an international tribunal endorse. And these showed Sabah as being either part of the Philippines or claimed by the Philippines. And the government of Malaysia engaged me to make submissions to the tribunal as a non-intervening party. So Malaysia was intervening non-party, essentially to point this out to this tribunal, to point out how Sabah was part of Malaysia and had chosen to be part of Malaysia as part of self-determination in the 1960s and going through the historical record of the 1878 agreements and so on, and ask the tribunal, the arbitration tribunal in the Philippines-China dispute, not accidentally to endorse the Philippines' point of view or use the documents that the Philippines had put forward that showed Sabah in this way. And the tribunal completely accepted Malaysia's points, and you can see there's a reference to it in the final award where the tribunal said that it had understood now that there were some documents submitted by the Philippines in relation to Sabah, and that the tribunal was making it clear that they were not endorsing the Philippines' view, etc., etc., etc. So it requires a constant vigilance, preparation, and activity on the part of government, and the government of Malaysia is, as I am aware, continually vigilant on this point.
Thank you, Robert. I've been...
Roger, if I may add to Robert's response, in this specific case, the government of Malaysia has also filed a set-aside action in Paris against the final award. And once the final award is nullified, as we expect will happen during 2024, the Sulu claim is mainly over. I mean, this specific Sulu claim. So this is another important action taken by the government of Malaysia, which will for sure quash the purported award.
Thank you, Alvaro. I've been given a 2-minute sign, which literally means 1 minute. Amdi, can I get you to, instead of asking a question, make a statement so that we can conclude with that? Can you do that?
Thank you. My interest is just to clarify the validity of agreement signed January 22nd, 1878 is located is very dubious, right? You see, this particular agreement, which is the main focus of legal argument, was done 24 days before the same agreement signed between Sultan Brunei and Arbitration. This was signed in 29 December 1877. And then come the second agreement was done January 22nd, 1878. It's only 24 days different. Now, are we saying Sultan Sulu either recognized there was an early agreement before that? Maybe no, maybe yes. But what about Arbitration? Surely he knew that that agreement was done because he himself signed the agreement both between him and the Sultan Sulu and between him and the Sultan Brunei. Thank you.
Thank you very much. Yes, we do understand the importance of that first treaty with Brunei, and I'm certain that the authorities will be having a look into that. So thank you very much. Can I have everyone give a great round of applause to our very distinguished speakers. Thank you.
Thank you. Thank you to our panel of speakers and moderator for this really engaging session. May I kindly request the panel to remain on stage, and we'd like to invite Yang Berhormat Datuk Seri Panglima Yong Tek Lee, the former Chief Minister of Sabah, to present a token of appreciation to the panel and moderator on behalf of the organizers. Ladies and gentlemen, round of applause for our panel once again. To our panelists who are joining us virtually, thank you very much for your attendance and your input. And I'm sure we'll find a way to get one of these goodie bags over to you guys. Ladies and gentlemen, we have arrived at our third and final session of the day. The final session is entitled The Sulu Case, Its Effects on the New York Convention and the Global Arbitral System. We welcome on stage the moderator for the session, Yang Berbahagia Datuk Sundara Raju, Director of the Asian International Arbitration Center, the AIAC. Joining him on stage, please welcome Yang Berbahagia Professor Datuk Dr. Rahmat Mohammed, former Secretary General of the Asian African Legal Consultative Organization, ALCO, and Yang Mulia Datuk Tengku Fuad Tengku Ahmad Burhanuddin, partner at Mrs. F.T. Ahmad & Co. Joining us virtually, Mr. Stefan Fieta KC of Fieta LLP. Ladies and gentlemen, please give them a warm round of applause.
Hello. Thank you very much, Ezra. I think that Yang Mulia Datuk Tunku Fuad is now rushing to the front. So, okay. Let me start because I'm been told to finish this session in 1 hour flat. So we will try. A warm welcome to the final session of the International Arbitration Colloquium 2023, Sabah edition, entitled The Sulu Case, Its Effects on the New York Convention and the Global Arbitral System. Of course, we thank our joint organizers for giving me the opportunity to be moderator of this final session. I welcome my colleagues, Yang Bahagia, Professor Dr. Rahmat Mohamad, former Secretary General of the Asian African Legal Consultative Organization, ALCO. He was my boss, by the way, a few years ago. And then Yang Mulia Datuk Tunku Fuad, Tunku Ahmad Barudin, partner of Messrs. FT Ahmad Company. And joining us virtually is Mr. Stefan Fieta, King's Counsel, so I think we can start. Now, Malaysia has successfully secured 2 consecutive landmark victories in our international duel to now settle and terminate the Sulu Awards. In particular, the Paris Court on the 6th of June decisively affirmed that Dr. Gonzalo Stampa was devoid of jurisdiction and has wrongfully declared himself competent as the arbitrator proper in the proceedings. Now, also, the Paris Court of Appeal ruling now stands as the implied indication that the final award, which is also being heard by the Paris Court, will be finally annulled, and it would lead to, we believe, a comprehensive defeat for the claimants. Now, more importantly, on the 27th of this month, or last month, we have had a very decisive decision from the Hague Court of Appeal, which rejected the claimant's application to recognize and enforce the final award. So, in this way, these 2 victories have set us on a road that I think there is no turning back. So, it's worth mentioning is today we are going to explore, we're going to discuss the recognition and enforcement of the purported final award under the New York Convention, 1958, vis-a-vis the Paris Court of Appeal ruling on the 6th of June 2023. And then we also want to understand what are the principles and protection of the arbitral process and proceedings under the New York Convention. And we also want to look at the peculiarities of this particular arbitration and how it has given rise to the abuse of process and what does it mean to the global arbitration system. Now, I'm quite sure, I think I'll cut short the introduction. You will be able to get the introduction, but suffice to say that Professor Dr. Rahmat is actually a professor of international law, and he's chairman of Sohakam, and also chairman of the Malaysian Stadium Institute of Malaysia. And then I have Tunku Fuad, who is one of the luminaries in Sabah. I see him more often in KL also. He practices both in the High Court and all the superior courts, and he's one hell of a litigator. I know that him to be. And then, of course, Stefan is well known to us for many years. He's one of the leading practicing public international lawyers, and he's top rank in the globe, and as one of the most prolific and outstanding counsel. So, ladies and gentlemen, we are honored to have such an esteemed panel with us. And without further ado, I'd like to invite Stefan from London, I believe. Can you have your presentation, Stefan?
Yes, good morning. Thank you, Datuk Sundara. I hope everybody can hear me clearly. Good morning from London. Good evening in Sabah. I equally, like other speakers joining remotely, regret that I'm unable to return to Sabah for this event, but I look forward to visiting again soon. I'm going to speak for 15 minutes, I hope, no more than that, to help Datuk Sundara with his challenge of finishing this session within an hour flat. I'm going to cover the Paris Court of Appeal's ruling and the Hague Court of Appeal's recent ruling, and draw those into the umbrella of the New York Convention and explain their relevance, both under the New York Convention and for the purposes of recognition and enforcement of the purported final award globally. I can be brief, in part because my colleague Chan Leng-Sun has just covered some of the ground that I was intending to cover, so that will help because it will mean that we can hopefully catch up. I'm going to share my screen. Hopefully, everybody can see my slides. So my first slide just sets out the 4 topics of my presentation. The first is the New York Convention. We'll do a brief review of the relevant provisions on recognition and enforcement of the New York Convention, which, as a matter of international law, is the framework within which this award will be recognized and enforced or not, of course. Secondly, I'll talk about the key findings of the Paris Court of Appeal, and then the key findings, thirdly, of the Hague Court of Appeal, but I'll be very brief on those given that Chan has helpfully covered those issues already in some detail. And then I will close by looking at the likely consequences of the Paris Court of Appeal and Hague Court of Appeal rulings for the purported final award and its recognition and enforcement internationally under the New York Convention. So first of all, just a brief recap of the relevant provisions of the New York Convention. The relevant provision really for recognition and enforcement purposes is Article 5 of the Convention, which sets out a number of grounds on which recognition and enforcement of an arbitral award, such as the purported Stamper Award, can be granted or refused under international law. Now, the New York Convention is extremely important in this context because it essentially sets out or codifies ubiquitous rules for the recognition and enforcement of international arbitral awards. There are 156 states parties to the New York Convention, and even those states, those very few perhaps who are not a party, would reflect otherwise the principles set out in Article 5. I've set out on the slide all of the provisions of Article 5 which are potentially relevant in this case. In particular, there are 5 aspects of Article 5 which are notable. First of all, and all of them set out bases on which the stamper award could potentially be refused recognition and enforcement. The first, under subparagraph A, is that the arbitration agreement is not valid under the law where the award was made. Now, of course, in the context of the partial award, the country where the award was made is Spain. And for the purposes of the final award, the country where the award was made is France. And that's important for the purposes of the Court of Appeal's decision in Paris. Secondly, under paragraph B, failure to give notice of the appointment of an arbitrator or of the arbitration proceedings is a reason to refuse recognition and enforcement. Thirdly, errors in the composition of the arbitral authority or tribunal. That's under subparagraph D. Fourthly, under subparagraph E, the award has been set aside or suspended by a competent authority of the country in which that award was made, which again means France in the context of the final award. And finally, under paragraph 2 of Article 5, we come to the well-known public policy exception. Recognition or enforcement of the award would be contrary to the public policy of the country in which recognition or enforcement is sought. And all of these elements of the New York Convention have been pleaded in one way or another by Malaysia in connection with the Stamper Awards. Let's move on to see how the Paris Court of Appeal addressed this in its 6th of June decision, refusing, of course, exequatur or setting aside exequatur or recognition and enforcement of the partial award on jurisdiction and applicable law rendered by Stamper in Madrid on the 25th of May 2020. And the Paris Court of Appeal's ruling is relatively short and straightforward. The court focused its attention on one fundamental flaw in the arbitral process and award, which was sufficient to dispose of it for the purposes of French law. And that was the absence of a valid arbitration agreement binding Malaysia. Now, as my colleagues pointed out in the earlier presentation, the Paris Court did find that there had been an arbitration agreement initially when the 1878 agreement was signed. That was contrary to Malaysia's position, of course, and actually contrary to findings that, as we'll see, have been made by the Hague Court of Appeal. But that didn't matter because, as the court said at paragraph 79 of its judgment, you can see here, the disappearance of the function of the British Crown Consul General, who of course was deemed to be responsible for resolving issues under the 1878 agreement, that office had lapsed. As a result, there was no longer any arbitration agreement at the time that the Sulu claimants lodged their claims against Malaysia. And secondly, the court pointed out at paragraph 79 also that the absence of an arbitration agreement by that time was reinforced by the fact that in 1946, the British government has succeeded to the rights of one of the parties, with the result that from that date, the British consul could not be regarded as an independent third party. So therefore, when Britain succeeded to rights under the 1878 agreement, even if the British Consul General was or had been an arbitrator under the agreement as originally signed, he had ceased to be such an arbitrator because he no longer was independent of the parties. So on these two bases set out at paragraph 79 there, the French Court of Appeal, the Paris Court of Appeal, concluded that there was no arbitration agreement, no valid arbitration agreement by the time that the Sulu claimants brought their claims against Malaysia. And in fact, of course, because as the court indicated, the the arbitration agreement had lapsed by 1946 at the latest, that means that Malaysia had never been a party to an arbitration agreement under the 1878 agreement because, of course, it succeeded to that agreement many years later. As the Paris Court said at paragraph 81, the clause has become impossible to enforce, and the court could not therefore, or the tribunal could not validly uphold its jurisdiction in the partial award. As a result, the partial award was refused recognition in the French jurisdiction. That's very important for purposes of the prospects of recognition and enforcement of the award generally, the final award, as we'll see in a moment. Turning then quickly to the Hague Court of Appeal's ruling. This was only 21 days later, 21 days after the Paris Court of Appeal. Here, the Hague was looking at the different question of recognition and enforcement of the final award in the Netherlands. And this was refused by the court on 3 independent grounds, as we've heard. First, under Article 5.1d of the Convention, there was no valid arbitral award because there had been no arbitrator, effectively. Stamper's appointment had been annulled by the Madrid Court of Appeal on the 29th of June 2021. And the Hague Court held that the Madrid High Court's decision of June 2021 must be recognised in the Dutch legal order. The effect, of course, was that as a matter of Dutch law, Stamper could not make a final award. He could not make any award at all. And therefore, the final award was not eligible for recognition and enforcement. And as a result, the arbitral tribunal was not properly constituted because Malaysia was not properly summoned to the arbitrator appointment proceeding in Spain. That, of course, had been the basis for the annulment of Stamper's appointment in June 2021. The second ground that the Hague Court set out for non-recognition of the final award was that the 1878 agreement does not contain a valid arbitration clause. This is slightly different to the approach of the Paris Court of Appeal a few days earlier, because the Hague Court, in contrast to the Paris Court, found that there had never been a valid arbitration clause under the 1878 agreement, due to the language of that clause indicating an absence of common intention to appoint an arbitrator, due to the fact that the British Consul General in Borneo was not an independent third party, even at the time that the agreement was concluded, because he'd been involved in the negotiations around the agreement and had been one of its signatories. And thirdly, because the office of the Consul General, as the French court had found, also no longer exists, which makes the agreement unenforceable in any event. So there was no valid arbitration clause. That was the second ground. And the third ground for non-recognition was that the suspension of the purported final award by the Paris Court of Appeal means that the recognition and enforcement of the award should be refused under Article 5.1e of the New York Convention. Now here, of course, the Hague Court was referring to the previous suspension decision of the Paris Court of Appeal prior to the 6th of June decision on the partial award. The enforcement of the final award, the court said, was suspended in the country where it was made, namely by the Paris Court, in July 2022. And although this is a discretionary ground for refusal of recognition and enforcement under the New York Convention, the court felt that it was appropriate to exercise its discretion so as to refuse recognition and enforcement on this basis. In the court's words, given the great importance of the case and the exceptional course of the arbitral proceedings. Consequences. What are the consequences of the Paris Court of Appeal decision? Well, the reversal of the executor order of the partial award by the Paris Court of Appeal should unquestionably lead to the annulment of the final award by the same court. Of course, that will be in separate annulment proceedings, which are ongoing in in France. And this is because the final award is based on the partial award's findings on jurisdiction, of course. Without jurisdiction, the tribunal could not purport to render a final award, and the French Court of Appeal has determined that Stampa had no arbitral jurisdiction. Therefore, inevitably, on the basis of the 6th of June decision, the final award itself should fall and therefore be annulled in the French legal system. And the rationale used by the French Court of Appeal to refuse exequatur of the partial award will apply equally to the final award, the absence of any arbitration agreement at the time that the Filipino claimants brought their claims against Malaysia. Therefore, it's highly likely that absent a stay pending appeal by the Filipino citizens against the 6th of June ruling, the Paris Court of Appeal will annul the final award soon based on the same ground. Alvaro in Madrid has mentioned the likely timeframe of sometime in 2024. In the event that there is a stay and an appeal on the 6th of June decision, then it may take slightly longer to secure annulment of the final award, but it will still happen in the event of a successful appeal proceeding for Malaysia on the 6th of June decision. And Malaysia, certainly, I'm not French counsel, of course, in that case, but is very confident that it will prevail in any such appeal. Of course, the Paris decision is particularly important because it is made at the purported seat of the arbitration. And any annulment of the final award, which seems inevitable following the 6th of June decision, will have significant consequences under Article 5.1e of the New York Convention, because Article 5.1e provides that recognition and enforcement can be refused where the award has been set aside by a competent authority of the country in which the award was made, which of course here was France. As a result, all of the 156 state parties to the New York Convention, and other states even, will almost certainly refuse any form of recognition and enforcement of the award under the New York Convention following the expected annulment of the final award in France. As for the Hague Court of Appeal decision, this is equally important, albeit not rendered at the seat, but the Hague Court of Appeal decision is important because it is the first time that a leading jurisdiction or any jurisdiction has looked at the final award and refused its recognition and enforcement, even prior to its annulment, its expected annulment in Paris. The Hague is a highly respected arbitral jurisdiction, of course, including in connection with arbitration against states. And the rationale of the Hague Court of Appeal ruling, which repeatedly cites the New York Convention, is easily transposable in other jurisdictions. So the Hague Court of Appeal ruling itself should constitute another formidable obstacle to recognition and enforcement of the purported final award globally. Finally, where does this leave disputes under the 1878 agreement? Well, it's very interesting, this one, because we've heard about history, and here recent history is quite telling. Following the recent judgments of the Paris Court of Appeal and the Hague Court of Appeal, to the effect that Malaysia has never been a party to any arbitration clause under the 1878 agreement, any disputes under that agreement or with respect to that agreement, including as to its validity, should be resolved in Malaysia. That's the only possible consequence of the absence of an arbitration clause in that document. And this will also be the effect of the expected annulment of the final award by the Paris Court of Appeal. It will be expected that the Paris Court of Appeal will annul the award on the basis set out, at least on the 6th of June decision, to the effect that there is no valid arbitration clause in the 1878 agreement. And interestingly, before they even started this arbitration through the Madrid courts, the British government itself informed the claimants of this position. Before the arbitration, They wrote to the British Foreign Office in 2017, requesting intervention with reference to the 1878 agreement and the role of the British Consul General in Brunei under that agreement. They asked for Britain's intervention into the dispute between the Sulu claimants and Malaysia. The Foreign Office declined to intervene on a number of grounds, but it questioned the nature of the Filipino citizens' rights under the 1878 agreement. And importantly, it invited the Filipino citizens to take up their claim directly with the government of Malaysia. Of course, the Filipino citizens declined to do that. They decided to try an arbitration via the Spanish courts. But it is interesting that ultimately the outcome of the judicial assessment of that process in France and now in the Netherlands is exactly as the British Foreign Office had advised it should be, namely that any disputes with relation to the 1878 agreement, absent a valid arbitration clause, should be resolved within Malaysia. That's the end of my short submission. Datuk Sundara, unless there's any questions, over to you.
Yeah, we'll handle the questions at the end. We'll do the presentations continuously. Thank you so much, Stefan. It's a very insightful presentation. I just want to recount how this arbitration occurred. It started originally in Spain with the appointment of an arbitrator, which subsequently, which was appointed by the Spanish court. The Spanish court subsequently nullified that appointment. And before that, the arbitrator had issued a preliminary award on jurisdiction. Thereafter, when he was nullified, he moved the seat to Paris. So this is an arbitration, one single arbitration with two seats, which is quite unique without consent of the parties. So I think that is the first thing to be remembered. What is the importance of the Netherlands decision is that it is the first time the final award is being tested for the articles in the New York Convention, which will be mirror image of the annulment grounds in the model law, which is incorporated in all these countries that we are going to. So it's so important that this Dutch decision is already setting up the precursor for what is going to happen completely. So there is no arbitrator, there is no arbitration agreement, and finally there is actually no award. So I think with that, I ask Dr. Professor Rahmat Mohamad to actually give your presentation. Thank you.
Is it working? I have a PowerPoint presentation. Can we start? Assalamu alaikum wa rahmatullahi wa barakatuh. And a very good afternoon. Yang berbahagia Tan Sri Hanif Ahmad and moderator this afternoon, colleague Datuk Sondra Raju, Datuk, Tuan-tuan dan puan-puan. I would first like to thank the organizer for giving me this opportunity to make this presentation, a very short presentation, I presume with 15 minutes or 20 minutes of duration. And I must also congratulate the organizers in organizing this very important colloquium. I think it is very important that a quick and effective measures have to take place to ensure that Malaysia will not be put to unwarranted pressures, using arbitral process as a sham to gain profit illegally through fraudulent scheme. I must say that a lot of development, recent development, especially to the historical perspective of how it started. And I think I would like to say this, that Malaysia misfortune is that we have landed in this case. It is, to me, it is sort of an ambush. That this case is a case where it is cleverly designed. And again, 1878 has been the focal point, which today we know that from colleagues, that especially historian, that why do we have to focus on 1878 when we have earlier dates that would dispel the air of Sultan Sulu claims as regard to the legitimacy of Sabah, Malaysia. Now, when you put the transaction under commercial arbitration, obviously, as a sovereign state, you have ousted Malaysia, and we were caught by surprise. How do we respond to these claims made by the 8 Filipinos, helped by a lawyer in London? So the case was brought under arbitration. It was a unilateral pursuit by the 8 Filipinos claimants. And again, as mentioned by Dato' Sondra, it was in Spain where the forum had been made, and as if that there is also a forum shopping, moving from Spain to France, and finally our assets in Luxembourg is also being questioned as part of their claim. So it will never end. I mean, I will not delve into the merits of the 2 cases that we have won. These are some of the historical timeline, which, as I said, I'm guilty of putting the date 1878 as the focal date, when we know that there is already there was an earlier agreement signed by Sultan of Brunei and the 2 Europeans. So what is the position of then the agreement signed between Sultan Sulu and the European? So this is something that where my colleague Dato' Feroz has said, we have to be sure of what date to apply really. But since this date has been used in the arbitration, so we conveniently accept that this actually is the date where it all started. But for matters of future reference, I think we need to make sure that we are very sure of which date that actually applies in our case. Yes, I think the 2 recent cases, the French Court of Appeal and the Hague Court of Appeal, I think has been very consistent, that we see a very encouraging pattern that we may, win the battle with 8 Filipino claimants. But of course, when will it stop? Because this is the problem with the New York Convention having global enforcement effect. But I think from the very beginning, we have complex, I'm not good at this. Working? Can you move on to the next slide, please? Yes. Now we have this issue of public international law and private international law. When we talk about public international law, then we talk about the state sovereignty, state immunity has been discussed in a previous session. Then there is this historical claims, which is part of territorial disputes and also effective control. Now, it is actually a historical tragedy that the nature of the current boundaries and territories in Southeast Asia countries have been drawn by the colonial masters. The Dutch, English, and the Spanish had divided this part of the world. And because of that, we are now competing. We want to claim our territory. And this is something that we have to face, we have to encounter in the future. And we know that under public international law, the importance of state sovereignty and also state immunities being a very important doctrine of public international law. So we mix this concept of state sovereignty, state immunity with arbitration. And it's unfortunate that most of the time we argue on the basis of, hey, we are a sovereign state. Why should we entertain this claim made by the 8 Filipinos? Because this is Sabah, this is Malaysia we're talking about. So probably we did not respond to the earlier claims made by the 8 Filipinos and their lawyers. So we thought, how can they claim such a claim because we are a sovereign state? So it was only later we realized that perhaps this is an issue on private international dealing with arbitration. So as I said earlier, it is a sham. So they said this is nothing to do with state matters. This is a private arrangement. This is a commercial venture signed by the then Sultan of Sulu with the 2 Europeans. So how is it that, the state wants to enforce or impose its sovereignty, or for that matter, a state immunity? So we are very much embroiled into this situation. In fact, until today, we still want to push the idea that, hey, we are a sovereign state. We are, we have immunity against, the other party. But the reality is that this is about international arbitration or private international law that we are dealing with. So that is one. And then in relation to historical claim, again, this is something that has been claimed years after years, decade after decade, that Sabah belongs to Philippines. But we know very well under public international law that by virtue of Sipidan and Ligitan case, by virtue of China and Philippines, and also Pedra Branca, Batu Putih case, that historical claim is not so fashionable under international law. Because at the end of the day, it will be the effective control, the display of sovereignty. This is how we lost Pedra Branca to Singapore, because we did not do anything to the island. Singapore went ahead, they had effective control and demonstrate the sovereignty of Singapore over Pedra Branca. And there you are. And ICJ admitted that in the first round, that Batu Putih belongs to the Sultanate of Johor. But because there is this theory of effective control, we lost that rock to Singapore. So historical claim is also something that is very much ingrained in us, that we tend to mix issue of historical claim under international law. We argue that this is ours. I truly believe that we are ahead of the other party in claiming Sabah as part of Malaysia. I don't have an issue with that. But again, this is private international law. It deals with arbitration. If you can observe, and what has been stated by colleagues earlier, that the argument put forth in the two cases, and also the decision made by the Court of Appeal in France and Dutch, did not mention at all about Malaysia as a sovereign state, or even for that matter, having immunity. It is all about the New York Convention, the enforceability of New York Convention. So I must say that with these two cases, hopefully Luxembourg is our victory, but it will never end because, as I said, the idea of New York Convention is having that, it has that global enforcement effect. So it will proceed, it will go on. There was a good question asked by the participant, that how do we stop this? How do we end this? Maybe I can propose some ideas, but I'm not sure whether, it's a long shot anyway. But these are the issues. These are the different issues that we have to understand, the dichotomy between what is public international law and what is private international law. So now, as it is, we have to deal with issues pertaining to private international law, arbitration, and the New York Convention. How do we deal with that? So, state immunity, I will not say much on this because arbitration basically, it is a defense, but again, at the moment, we cannot enforce or impose the idea of absolute immunity. And this is not a case where it involves trade or commerce. So there's little room to apply state immunity in this sense. Now, as regard to the defense that we are applying, in fact, we applied this defense to set aside the award. One, I see that we apply international public policy in our argument in French Court of Appeal. And when we say public policy, it covers cases in which it has been shown that there is some element of illegality, or that the enforcement of the award would be clearly injurious to the public good, or would wholly offensive to the ordinary, reasonable, and fully informed members of the public on whose behalf the powers of the state are exercised. Now, we did highlight this in the argument in the French Court of Appeal, but the response from the court was, I don't see the response there, but I hope that there would be a response from the court. But I assume that the court accept the argument or the defense on public policy. And so is fraud. So these are the two main defenses that we have in order to oust or to ensure that the award will be set aside at the end of the day. And indeed, we see the pattern, which is a very positive pattern, and it's very encouraging that the court accepted the argument on our side that this is a sham. There was no, as the Dutch Court of Appeal said or decided, that there was no arbitration agreement in the first place. So what is this then? So when the 8 Filipinos claimant came to the court and claimed that there was arbitration, in fact, there was none. So I take it that it is a unilateral, attempt to make the award, materialize at the end of the day, which the court did not allow that to happen. Now, the question asks, what would be the impact on the global arbitral system? Now, when I was the Secretary General of the Asian African Legal Consultative Organization, we have regional arbitration centers. Kuala Lumpur, now the Asian International Arbitration Center, is one of the regional arbitration under the auspices of the Asian African Legal Consultative Organization. it is very influential. There are currently 3 regional arbitration centers in Africa under the auspices of ALCO. And currently, Hong Kong is the latest edition of the Asia Arbitration Center. We take matters seriously in relation to arbitration matters. We know that arbitration is very important. It is an alternative dispute resolution, particularly with individuals. And of course, now you have the investment. It also involves state and individual and companies. So it is a very important alternative dispute resolution or mechanism. So reputation and integrity, assuming that many will take up arbitration as a sham and get its award all over the world, and the way it is being done is actually an abuse of legal process, that would mean that it will put arbitral system in disrepute, because people will come and use that because they know that they will, at the end of the day, get the award. And this is not a very good trend. So one is reputation and integrity. Then there is a question of trust and public confidence, because if this case go on and on without ending, because there are 175 signatories to New York Convention, imagine we have so many assets abroad, so we have to be very, very careful when it comes to Africa. We are confident in European countries because of the advanced arbitration system, but we are not sure if the matter is put before African arbitration or African courts, where some of these countries never heard of arbitration before. So this is something of concern, and I said earlier, how do we stop this continuous flow of the 8 claimants or the 8 Filipino with their lawyers go from one town to another. So that is another issue. So abuse of arbitration process, as I said. And of course, there will be disruption of trade and business, because we look at the arbitration centers, It is very important that we maintain that confidence, we maintain that integrity. So as I said, it will put arbitration tribunal in a shambles. So that this, and my last point, yes. So how do we conclude this? How do we stop this? Then we stand ready to defend Malaysia's interests in any jurisdiction where assets are located. We have to be vigilant. As I said, the New York Convention has that global enforcement effect. So we have to ensure that where our diplomatic missions are and where our assets are located, we have to make sure that these are not diplomatic assets, but business assets. If you think of London, for example, what are our assets? We have a lot of assets in London. Our GLCs, they have the assets there. So in Africa and other part of Asia. So it's very important that we be ready with that. And it will be a long period of time. It will take some time to ensure that, of course, as I said, the positive thing is that these 2 cases have indicated that, we may get a positive answer, that maybe we can set aside the award at the end of the day. Now, a long shot, which I have, is probably a request for declaratory judgment from ICJ on whether, upon the successful annulment of the final award, we take a few courts, for example, Luxembourg, Belgium, France, and if these are positive, we say that these are being annulled by the courts, and perhaps we can ask the court, the ICJ, to say that, or give that legal cognizance, because they can't stop, as Robert said, we can't stop people from suing or from pursuing their agenda. But at least the courts all over the world is aware that we have this, sort of cognizance and also the annulment of the award, and the court should be prepared with that. The other thing is the advisory opinion. Again, it's a long shot because you would require General Assembly, the UN General Assembly, or the Security Council, or UN specialized agencies take up the matter, which we don't have that privy. But again, we can try. As I said, this is something that we can try. I mean, a lot of research needs to be done on this. And finally, head on. But there must be political will. In other words, be ready for litigation with Philippines. And as I said, I am very confident with all the legal backups and case laws and precedents. Of course, precedent is not binding in international law, but still, if you look at the cases that has been decided by ICJ, they definitely use old cases or previous cases as a good sampling to make the decision finally. But as I said, we are very confident in that. So this sad tragedy, or sad, is unfortunate that Malaysia will have to face this episode, and I hope we need to finish it quickly. We need to be effective on this, and I think we need the help of the local experts. I was thinking of probably proposing Malaysia Academy of Public International Law or International Law, where we can gather all the academics, the practitioners, and have a definite position and advise the government as to how do we go about in settling this. I don't think it will rest. We cannot rest now because it is a long journey. So I wish all the best to the team, and we hope we can win. And as far as Sabah is concerned, I think you have a bigger agenda. As I said, we must have the political will to say that let's go to ICJ and solve this issue for once. And I think I'm very confident that we can win. So thank you very much.
Thank you, Dr. Professor Rahmat. I just want to put things into context. I think some of you all may not know what arbitration is, but let me try to explain in a very simple form what happens. Arbitration is something that is outside the court system, a rights-based decision-making, which comes out with an award. Now, there are two main types of arbitration: domestic arbitration and international arbitration. International arbitration can be divided into another two types: international commercial arbitration and investment state arbitration. So every day, I believe in the world, there must be thousands of awards being issued. So there is a procedure. Okay, let's look at international commercial arbitration. There is already a procedure that is envisaged on both annulment and enforcement. In Malaysia, if it's a domestic arbitration, then you go to the Malaysian court to set it aside if it's wrong, if you think it's wrong under those grounds, or enforce it. Internationally, you go back to the country where the award is issued and you try to annul it, that is, set it aside. And then you also can enforce it through 172 states across the globe, because there is an integrated system of ensuring trade flows can occur, disputes can be settled internationally. I think that is the basic scheme. Again, the basic scheme requires certain procedures to be followed. And if you do not follow those procedures, it is risky. And I invite actually Yang Mulia Datuk Tunku Fuad to actually explain what happens. Exactly. Sorry, please.
Can everybody hear me? Yeah. Distinguished guests, moderator, ladies and gentlemen, Assalamu alaikum warahmatullahi wabarakatuh. In terms of speakers today, I am at a distinct disadvantage because I'm neither eminent nor am I distinguished. I am neither a professor of international law nor am I King's Counsel. However, I am a Sabahan and I think we need to be heard, especially today. So the topic that I've been asked to speak about revolves around the peculiarities of the Sulu arbitration and how it may give rise to an abusive process and the corresponding ramifications that abusive process may have on the global arbitration environment. It's a very big question. So I thought I'd simplify it by just putting into your minds a couple of points. The first point is to remember this date. In February 2022, Malaysia found itself in a bit of a pickle. In February 2022, an as yet unknown man by the name of Gonzalo Stamper issued a final arbitral award against Malaysia in the sum of 14.92 billion US dollars. Not only did this come as a surprise to most Malaysians, it came as a horrific surprise to the people of Sabah. How is it that our tiny state, with an annual government budget of less than 4 billion ringgit a year, can incur the entire nation of Malaysia a loss of 14.92 billion? I wasn't aware we were worth that much. So, how are we going to approach today's topic? Well, I thought of many ways to approach it, but I think the best way is to tell a story. And at the end of the story, I hope you can see the points I wish to make. And those points are this: yes, there was abusive process, partially because Malaysia was at fault. And no, the Sulu arbitration, I think, is unique. And I don't think it exemplifies a greater systemic problem under the arbitral enforcement framework of the New York Convention. Ladies and gentlemen, let's start with the New York Convention itself. There are 172 signatories, and the section that we are concerned about today is Article 5, the grounds upon which an arbitral award can be refused recognition and enforcement. In a nutshell, there are only really three grounds. The first is that there's no arbitration clause, or that the arbitration agreement is for some reason invalid. The second ground revolves around a lack of due process, and the third ground talks about a violation of public policy. To put that more simply, that the arbitral award for some reason is repugnant or against the public policy of the country in which enforcement is sought. So now that we have a basic understanding of how why or how an award can be refused recognition, we now must turn to the issue of abuse of process and the actions on Gonzalo Stamper. I'll just call him Stamper, because if we're going to argue that recognition and enforcement of an arbitral award is to be refused, then we have to evidence our argument with reasons. So, what are some of the things that Stamper did? So, I've called this item B, Watching Stamper. Our story begins in 2017, when a group of people who claimed to be the heirs of the defunct Sulu Sultanate decided to commence an arbitration against Malaysia. In 2018, they filed an application for what's called judicial appointment of an arbitrator, and this application was filed in Madrid, Spain. A copy of this was served on Malaysia. Malaysia did nothing. Later on in 2018, the Superior Court of Madrid examined its own competence and came to the conclusion that it had jurisdiction. Malaysia did nothing. Later on, Malaysia, again not represented, a proceeding took place whereby the Superior Courts of Spain declared that Malaysia was in default of the judicial application to appoint an arbitrator. 2019 comes around. The Superior Court of Justice in Madrid renders judgment in favor of the Sulu descendants. And later on, in May 2019, Stamper is appointed as sole arbitrator. Where was Malaysia? From 2017 to 2019, Malaysia was absent. In June of 2019, Stamper starts making orders. Stamper says Malaysia is to be served with a notice of arbitration. Malaysia must also, under the order, submit its response to the notice of arbitration. Additionally, Malaysia must attend in person a preparatory conference in Madrid on the 24th and 25th of October. Ladies and gentlemen, throughout this entire process, Malaysia was absent. Malaysia failed subsequently to respond to the notice of arbitration, which was served on Malaysia, and nor did Malaysia attend the physical preparatory conference in Madrid. The Malaysian Attorney General at the time simply did not defend, nor did he seek to represent Malaysia's position in respect of, first, the Spanish court's jurisdiction, second, the appointment of Gonzalo Stamper, and thirdly, to the extent to which Stamper has jurisdiction over the arbitration that is in question. However, only after Stamper was appointed did Malaysia do something. The then Attorney General appointed one Dr. Arias and one Mr. Capiel as Malaysia's representatives to the arbitration. But then, quite mysteriously, the Attorney General instructed that Malaysia simply will not participate in the arbitration and that Malaysia will not participate in the challenge to Stamper's jurisdiction. Notwithstanding this, in 2020, February, proceedings regarding Stamper's jurisdiction over the matter went ahead. And Stamper, in late February, early March of 2020, gave the Attorney General of Malaysia one final warning. And the warning took this form. One, that if the Attorney General failed to avail himself of the opportunity to present Malaysia's case on jurisdiction, notwithstanding ample opportunities to do so, Stamper will proceed to determine his own jurisdiction and the substantive law applicable to the matter. The Attorney General was given a deadline to make submissions. The third condition was that even if Malaysia doesn't respond, Stamper will determine his own jurisdiction and that the award on jurisdiction, this is called now the partial award, will be legally binding and enforceable against Malaysia. I pause here now to ask you to observe. Malaysia opened the door to a future abusive process by not standing its ground, by not being present, and by not stating its case early in the Sulu arbitration proceedings. The Attorney General at the time simply did not take the matter seriously and did not understand the serious ramifications that would follow from his failure to participate in the arbitral process once it was initiated. So here we are in Sabah, not knowing what's going on, and we're at the heart of one of the largest arbitral awards in history. At this point in time, I ask you to observe that for all intents and purposes, this is a normal arbitral process. There's no real abusive process yet. Stamper's asking us to state our case. What did we do? We did nothing. So you could make the argument that Stamper was abusing his process when he self-ascribed jurisdiction, where he decided to take jurisdiction for himself. But that was the basis of Malaysia's opportunity to challenge jurisdiction. Stamper also took the position that the 1878 deed of cession was arbitrable, and that Malaysia was the proper successor in title and heir to the 1878 deed. Again, these are all matters that should have been challenged by Malaysia early in the process. So at this stage, ladies and gentlemen, Malaysia, by failing to challenge Stamper early, created the environment with which an arbitrator could abuse his position, which he later did. No discussion, however, can take place about the Sulu arbitration without reference to one particular document. The document to which I'm referring is the Attorney General's letter dated the 19th of September 2019. This letter is important because it formed the backbone to the final award rendered in Paris. This letter was from the then Attorney General to the legal representatives of the Sulu claimants. And in the letter, the Attorney General on behalf of Malaysia said the following. One, that it was regrettable that the payments to the purported Sulu descendants ceased in 2013. He apologized that we stopped payments in 2013 without reference to the Lahadatu incursion. So he apologized for not paying. By doing so, he admitted that there's money owing. Secondly, he said, and I quote, Malaysia is now ready and willing to pay the arrears from 2013 to 2019. In other words, again, the Attorney General admitted we are at fault, that we owe them money under an existing contract, that the 1878 agreement is a contract to which Malaysia is a successor in title. Why would the Federal Attorney General make such an admission? Is it carelessness? Or is it negligence? Or is it misfeasance? The third point that the then Attorney General made was this. He said that the Sulu Sultan had never divested himself of sovereignty over the territories of North Borneo. Ladies and gentlemen, the Attorney General's letter of 2019, September, became the backbone of Stamper's final award and was the basis upon which the 14.92 billion US dollar liability was based. We also should regard and observe the following. The Attorney General then took the position that Malaysia had breached a commercial agreement between the Sulu descendants and Malaysia, and he offered to settle the matter. This was a key and fatal admission. Second, the Attorney General said that Malaysia had commercial dealings with his Sulu heirs, and he therefore conceded that the matter was arbitrable and that Malaysia was in breach of its obligations. Finally, the September 2019 letter issued by the Attorney General was done so without the knowledge and without the approval of the Malaysian cabinet at the time. It was a singular and unilateral act of the then Attorney General. However, all was not and is not lost. There was something of a change. And in 2021, Malaysia finally acts. This is item C on my little list. In 2021, we got lucky. The Superior Court of Justice in Madrid held that the appointment of Stamper was invalid because Malaysia, as a matter of Spanish law, was not properly served with the documents. Please observe, we didn't win because we argued that Spain is not the right place to bring the arbitration. We didn't win because our lawyers went to court with a fabulous argument saying that Spain has nothing to do or that the matter is not arbitrable. We won because the other side made a mistake. So let's not celebrate too early our jurisprudential and legal brilliance. They made a mistake, we picked it up, we got lucky. And because we got lucky, Stamper's appointment was annulled. And the order said the appointment as arbitrator is annulled and therefore all subsequent proceedings are annulled. So, Stamper is out. At that point in time, there was no arbitration. Stamper is a stranger to both parties, and there are no proceedings to talk about. But was this enough for Stamper? No. Stamper was cornered, and like all creatures that are cornered, they will flee somewhere, and in this case, to a different European city. Madrid was a bit too hot, so he fled to the splendor of Paris. And when Stamper reached Paris, he did, in typical Parisian style, what is always done, and that is to pull a fast one. He went to the Paris court and he said, look, I have an appointment by the Spanish court, and I seek recognition and enforcement of this partial award, giving me jurisdiction and power over an arbitration. And he didn't tell the he didn't tell the French court, and the French court in typical French fashion didn't ask, what is the status of your appointment as a matter of Spanish law? He kept that from the French, and the French didn't ask. So the French said, I'm recognizing your partial award. Please proceed. Now, 2 points to be made. The first, the French court should have asked, why aren't you still in Spain? Why are you seeking recognition of the partial award in France? But never mind. The key point to observe is Stamper did not ask anyone for permission to move the seat of arbitration from Spain to France. Malaysia was never consulted. There is also, upon research, no rule of either Spanish or French law that gives an arbitrator unilateral powers to move the seat of arbitration. So, abuse of process number one. You have already had your appointment annulled in Spain, you run to France. Abuse of process number two. You seek recognition of your appointment, knowing it has been annulled, in the French court, and you didn't tell the French that your appointment had been annulled in Spain. So we have now two abuses of process arising from the peculiarities of the Sulu arbitration. Never mind, because Malaysia is now in action. Having found out that Stamper had fled to France, proceedings took place in Spain to not only defend against an appeal against the annulment, but also to hold Stamper in contempt. Secondly, in France itself, proceedings took place to first set aside the partial award on the appointment of Stamper, as well as the later on final award. But I've skipped one step. Having obtained recognition of his partial award, Stamper then proceeded to issue the final award. Now, this is particularly detrimental to Malaysia for a couple of reasons. The first is that once the final award is rendered within the framework of the New York Convention, there's only one remedy, and that is to seek refusal of enforcement in the country in which enforcement is sought. So, logically, what happens? Well, Stamper knew, and the backers of the Sulu descendants knew, that there's lots and lots of court proceedings in both France and Spain. So they take the final award and they go off to Luxembourg and they seek to enforce the award in Luxembourg. Then they take the same award to the Netherlands and seek to enforce the award in the Netherlands. Now, at this point, what does Malaysia do, or what could it have done? Well, without giving away too many secrets, the answer is we have to wait and see. There are a number of countries in which Malaysia has assets, and there are a number of countries in which Petronas has assets. But we would not know and did not know where the Sulu descendants will strike next. So we had to hire lawyers in many, many more countries than you see before you. So, what are some of the weaknesses in the New York Convention? Well, if you have a bad actor and a bad arbitrator, it is for the defendant country to resist enforcement. But that resistance of enforcement, particularly in terms of an arbitral award of this size, is extremely expensive. I remember looking at a Zoom screen with at least 35 to 40 lawyers from Europe, from Spain, from France, from Luxembourg, from the Netherlands, and a few more from other countries I can't mention. I have never seen so much white on a screen. But what really moved me was the fact that if you took 30 people and multiplied that by 400 euros an hour, you could see how expensive this is getting, and it's no surprise that that Zoom call took 3 hours. So, how much has Malaysia spent? Well, last time I looked, it's in excess of 30 million ringgit. 30 million ringgit just to have this matter set aside. Because under the New York Convention, the mere existence of the final award is enough to attract enforcement proceedings. So is this a weakness of the New York system? Maybe. But did Malaysia bring it on itself? Partially. Did Stamper act badly? Definitely. So what do we do now, and where are we? Malaysia is on a strong footing now. We have 2 courts of appeal, one in the Netherlands and one in Paris, that say, in a nutshell, that there's either no arbitration agreement or that the arbitration clause is no longer workable. It's now impossible to implement. But one thing that I'm very curious about, and maybe this is a peculiarity of French law, is this. The French have said in their own Court of Appeal judgment that there is no enforceable arbitration clause, that the arbitration clause is, quote, impossible to administer. And the reason is because there's no more Consul General in Brunei that represents Her Majesty. But surely, as a matter of logic, if there's no arbitration clause, and you've already found there's no arbitration clause, then how can there be an operative and enforceable final arbitration award? Because don't forget, Malaysia is still in proceedings to have the final award annulled and set aside. I would think that it's a consequential result of a finding that there's no operative arbitration clause, that there could therefore be no final award. But again, that's a quirk of French law. For lawyers, I think it's wonderful because it means that we are constantly in litigation, even when the outcome is becoming more and more obvious. But never mind, that's a discussion for another day. So, where do we go from here? The minister, Yang Berhormat Azalina Othman, said on the 7th of June 2023 that Malaysia will sue the Sulu heirs and their backers. I think she's quite right. However, I think that the Malaysian government must go further. I think that the Malaysian government should first and foremost, in terms of Sabah, make it clear and make a decisive statement to say that Malaysia is not an heir to the 1878 agreement. That the 1878 agreement is defunct, it has been superseded by and nullified through the formation of Malaysia. It no longer has relevance or binding effect today. The second thing I think Malaysia should do is this. We need to make it clear once and for all that Sabah is, was, and always will be an integral part of Malaysia's sovereign territory. I call upon the Ministry of Foreign Affairs to stop tiptoeing around the issue by saying that the position of Sabah is complex. It is not. We have had a referendum. We have gone through the process of federation. We have a self-sustaining democracy whereby the people vote for their leaders within the framework of the federal constitution. There is nothing complex about being Malaysian, and there is certainly nothing Filipino about that. Thirdly, I don't think it's enough to just summon the Sulu heirs and their backers. From what I have said today, there is a case to be made that Gonzalo Stamper acted in bad faith and therefore outside of the ambit of his appointment as arbitrator, if there ever was one. The moment that the Spanish court annulled his appointment and Stamper nonetheless made awards and cost us money having to defend against the recognition and enforcement of those awards, that cost us money. He cost Malaysia money. So when you cost another party money and you do so wrongfully, or you do so because you did something illegally, I think that's a basis for us to summon Stamper. Let him feel for once what it's like to have a foreign court declared and enforced against you. Let Stamper be summoned to Malaysia and to account for all the damage he's done to Malaysians and to taxpayers. Ladies and gentlemen, in conclusion, the Sulu arbitral experience represents a perfect catastrophe within which abusive conduct not only arose, but was in some cases allowed to thrive. Malaysia was initially incompetent and blasé about the arbitral process, and it didn't take the matter seriously at all. But thanks to changes in the Federal Attorney General's chambers, competence in handling the matter was eventually established. But for this, Stamper and friends may have gotten away with it. They were close to getting away with it. And at worst, had competence not been established early enough, Malaysia could be embarrassed greatly by A, having to force a settlement, or worse, having to pay out the amount stipulated in Stamper's award. What this experience tells us is that the New York Convention does have some weaknesses. It relies on arbitral actors operating in good faith and within the rules. But when arbitral actors breach those rules, the safeguard provisions in Article 5 do come into play, but are costly and they are cumbersome. They are at times also imprecise. But now that Malaysia has achieved significant court victories in both France and Spain, what Malaysia must now do is not catastrophize about the injustice it initially suffered, but instead it must press its advantage. It must make an example of these bad actors. Summon Stamper, summon the Sulu heirs, and summon their backers. Make them pay for our legal fees, and when this is done, it will not only deter, dissuade, but also discourage others from engaging in this sort of egregious and extraordinary conduct in the future. Thank you.
Thank you so much, Yang Mulia Datuk Tunku Fuad. It is a fitting end to this colloquium, I must say, because we have no time to take questions. I would like to end it here. Thank you so much again, both all the panelists. And I think what an end, a summary, a fit, I think that this session clarified so many things that I wouldn't have said it the way Tunku Fuad would have said it. Thank you.
Thank you to our panel of speakers and moderator for that very powerful session. We kindly request the panel to remain on stage, please. And I now invite Yang Berbahagia Dr. Adeline Leong, Chairperson of the Institute for Development Studies Sabah, IDS, to present a token of appreciation to the panel and moderator on behalf of the organizers. Thank you. Before we move on to the final agenda of the Sabah Colloquium, we would like to invite the following VIPs to join Yang Berhormat Senator Tan Sri Datuk Sri Panglima Anifah bin Aman, Senator of the Dewan Rakyat and Special Advisor to the Chief Minister of Sabah for International Relations and Foreign Investment at the front seats. Could the following VIPs please... Could the following VIPs please join Yang Berhormat in the front seats? Yang Berhormat Datuk Sri Panglima Yong Tek Lee, former Chief Minister of Sabah. Yang Berbahagia Datuk Adeline Leong, Chairperson, the Institute for Development Studies Sabah. And Yang Mulia Datuk Tunku Fuad Tunku Ahmad Burhanuddin, Member of the Special Secretariat. To round off this colloquium, we are honored to invite Yang Berhormat Senator Tan Sri Datuk Sri Panglima Anifah bin Aman, Senator, the Dewan Negara and Special Advisor to the Chief Minister of Sabah for International Relations and Foreign Investment to deliver the closing remarks. Ladies and gentlemen, please give a round of applause.
Yang Berhormat Datuk Seri Panglima Yong Tek Lee, former Chief Minister of Sabah. Yang Berusaha Dr. Panita Silva Raju, Deputy Director General, Legal Affairs Division, Prime Minister's Department. Yang Berbahagia Datuk Adeline Leong, President Sabah Law Society, come member of the Special Secretariat. Yang Mulia Datuk Tunku Ahmad Fuad Tunku Ahmad Burhanuddin, Member of the Special Committee. Yang Berbahagia Datuk Feroz Hussein Rahmat Jamuddin, Member of the Special Secretariat, YB Members of Parliament, YB Ministers of Sabah State Legislative Assembly. Yang Berbahagia Tan Sri Datuk Head of Government Agencies, Senior Government Officials, Moderators and Speakers, and members of media, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. And if you realize, I'm not sure, right from the beginning, apart from the opening ceremony and the closing, all speakers and panelists are lawyers. And I think what I'm going to say today, in my views of what I understand a little bit of legal things, will make you crawl. But I think I represent to all those those who are not lawyers. I think I'm going to present your views, and because there's a lot of confusion and understanding on our part. But nevertheless, you have done a fantastic job. But nevertheless, it has given me great pleasure to be here with all of you. It is International Arbitration Colloquium 2023 to discuss a subject matter, I think, which is very close to all our hearts. And also the sovereignty of Malaysia, and in particular Sabah. And I would like to extend my appreciation to the Legal Affairs Division, the Prime Minister's Department, Asian International Arbitration Center, Institute for Development Studies, Sabah Law Society, and those who have contributed in organizing this event. Thank you also to the wonderful speakers and panelists for sharing their views and experiences, especially those who have been directly involved in the Sulu case. Indeed, your presence of many legal eagles have certainly given us an engaging and somewhat lively debate. I do not intend to repeat the historical background of the Sulu case or dissect the events relating to it, and my esteemed colleagues have done a good job in relaying the events and spent these many hours exchanging views and debating them. But I would gladly reiterate the delight I share in Malaysia's recent wins in Paris Court of Appeal and the Hague High Court of Justice by denying these self-styled heirs of defunct Sultanate the false and outrageous claims against Malaysia and Malaysian sovereign assets overseas. These resounding victories reaffirm the undeniable fact that in the eye of the world, that Sabah is part of Malaysia and has been since Malaysia Day 16 September 1963. Saying otherwise is not irresponsible, but also an act of futility in view that our Malaysian Agreement 1963 is an international treaty registered with the United Nations to be upheld to the world over. And there's no changing in Sabah, is and will always be, as Fuad was saying, as be part of Malaysia, and we will neither recognize nor compromise on any claims to the contrary. In fact, we will go to great lengths to vigorously protect and defend our national sovereignty and identity, as we have done in challenging the purported arbitral awards rendered in the Sulu case. I have great hopes that the rejection of the so-called arbitral awards will once and for all assure us a definitive conclusion of the long-drawn saga, which should not have occurred in the first place, given the sovereign immunity is a long-standing and well-accepted principle of customary international law. I would go so far to say that despite the lack of sufficient ratifications, the proposed Global Treaty UN Convention on Jurisdictional Immunities of States and their Properties, sovereign equality and sovereign immunity remains one of the most inviolable principles respected in international relations. And so it was shocking to hear how the international arbitration process was misused to threaten our national sovereignty. Thankfully, though the European Courts of Spain, the Netherlands, and France have seen fit to reassert the inviolability of this principle in favor of Malaysia. The disasters in this singular Sulu case, however, should not be to dissuade Malaysians from engaging in international arbitration as an alternative dispute resolution mechanism. Instead, those engaged in cross-border businesses and transactions desiring to opt for international arbitration should be encouraged to learn from it. International arbitration has many advantages: neutrality, efficiency, case of enforceability, and confidentiality have made it a preferred forum under the backdrop of globalizations. But foremost, it is founded on the principle of freedom of contract and a desire to compromise. In the first place, the parties must agree to arbitrate, to submit to the jurisdiction of the arbitral process, to have a level playing field. And there can be no room for unilateralism. The case of Sulu has attempted to appoint their own arbitrator where no agreement to arbitrate exists is one clear example. It is not possible for one party to trust international arbitrations as a platform for dispute resolutions on a non-consenting party simply to achieve their own desired outcome. So actually, I would hesitate to classify the Sulu case as an international arbitration simply because Malaysia did not even agree to participate in the arbitral process, which views, I think, Tunku Fuad and the rest will argue. But nevertheless, my stance during my time as the foreign minister was not to recognize any claims on Sabah and our excellent bilateral relations with the Philippines, and because we did not even entertain this baseless claim at that time, there was no question about the so-called Sulu heirs daring to initiate an arbitration. They've had no basis for it. On one hand, alone cannot clap, but take even the slightest misstep, these opportunists will seize the chance to force our government to engage in these frivolous games in order to defend our national sovereignty and immunity. The Sulu case shows how careful we must be when dealing with such matters of national interest, especially when financial reward is the claimant's only motivation. The actions prove this, and after the appointment of the so-called Spanish arbitrators, appointment and his purported awards were then rightly challenged by Malaysia. The rogue arbitrator proceeded to autonomously move the seat of arbitrations to France. Let me see that whilst it's always sound and wise to have a considered strategy in pursuit of a claim or dispute resolution, foreign shopping and going overboard with it in the likes we have seen should not be condoned. This is a challenge for international arbitration, especially when stakes are particularly high, because the situation has been exacerbated by the advance of litigation funding, which largely remains unregulated. When litigation can be funded by deep pockets and in an unchecked manner, states have the tough job of continually defending frivolous claims. We must always remember that the New York Convention is intended to facilitate the recognition and enforceability of any legitimate foreign arbitral awards. Under no circumstances should our international community belittle and abuse, especially when it threatens our national assets and ignores our sovereign immunity. As we have heard, these aggressive actions also put paid to the questions of the conduct of the arbitrators in councils involved in international arbitration, emphasizing the lack of internationally recognized mechanism to ensure their conduct remains independent and impartial, professional, and also ethical. I believe that Malaysia would not hesitate to take action against those who have acted in bad faith and disregard of the law in this case. My view is that in order to flourish, international arbitration processes should have the right balance between transparency, legitimacy, and legality on one part, and flexibility on the other. The Sulu case not only exemplifies the vagaries involved in any international arbitration, but also pushes to the fore in a real situation that many challenges to be grappled with towards ensuring fair justice to all peoples involved in international arbitration processes. In that sense, the worldwide media attention the Sulu case has attracted and served at least some purposes to highlight the challenges faced by the global arbitration system and potential abuses arising from gaps within the system. At great expenses and anxiety to the nation, many lessons have been learned from the episode and how to our state sovereignty and immunity can be better managed and mitigated. How can we improve on our oversight of actions threatening our state? How can we ensure the integrity of international arbitration processes? How this advising or relying on arbitration as a dispute resolution mechanism should be more robust or vigilant in the advice and decision-making and negotiations of their arbitrations agreements. We have heard today with so many views on this, but this colloquium is only the first step. And the Asian International Arbitration Center, our legal experts, and all those in the room have a big task ahead to continue their efforts to examine the ramifications of the Sulu case and share their learnings with others. Before I end my speech, I want to take the opportunity to thank YB Datuk Sri Azalina Othman Said for her role in bringing in Sulu case to light for all Malaysians, especially Sabahans, to know. 3 days ago, she has stated on behalf of the Malaysian government, and the Malaysian will go on the offensive until the end to ensure that damages can be borne by the claimants, which is being shared by some of the speakers and panelists today. Now, this shows that the federal government goodwill is upholding the Malaysian Agreement 1963 and to ensure that episodes like this do not repeat in future. I would also like to thank the Chiefness of Sabah, Yang Amat Muhammad Datuk Sri Panglima Haji Noor, for his continuous support given to the federal government in ensuring that no party can ever claim Sabah. He has been vocal on the issues pertaining to the Malaysia Agreement 1963 and ensuring that the sovereignty of Sabah as part of Malaysia is always protected. He is passionate about it, and I believe that the state government under his leadership will always put Sabahans first and protect our sovereignty against any claims at any cost. Finally, whilst the Sulu case has shown us how vital the preservation of our state sovereignty and immunity is, what it has shown equally as important is that compliance with and respect the well-established legal procedures and rules of law in the international arena must be universal and uncompromising. Therefore, I congratulate all of you, those who are championing the study of Sulu case from the outside. Now, thank you all again, and your contribution to the success of this colloquium. Your presence and views have indeed enriched us all. Thank you very much.
Thank you very much, Yang Berhormat Senator Tan Sri Datuk Sri Panglima Anifah bin Aman, for your words. We request Yang Berhormat Senator to remain on stage, please. And that, ladies and gentlemen, please put your hands together to invite Yang Berusaha Dr. Punita Silivaraju, Deputy Director General of the Legal Affairs Division of the Prime Minister's Department, to present a token of appreciation to Yang Berhormat Senator. Thank you. Ladies and gentlemen, we have come to the end of the International Arbitration Colloquium 2023, the Sabah edition. On behalf of the Legal Affairs Division of Prime Minister's Department, BHEUU, JPM, the Asian International Arbitration Center, the AIAC, the Institute for Development Studies, Sabah, IDS, and the Sabah Law Society, SLS, we thank you once again, the panelists, for making this colloquium possible, and to all attendees, both physically and virtually, for your continuous support. We look forward to seeing you all once again in our upcoming colloquium in London. Please be advised we have a networking session with light refreshments provided at the foyer outside. Thank you very much.